Lord, my Lord. Lord, one motor vehicle accident matter, my Lord. The executing court has put the property to auction, my Lord. There's some urgency. I have complied the office objection on 27th, my Lord.
All mentions memos to the court officer and look into it and
Please.
yes.
Madam, my lord, one submission, my lord, I have I have already filed the memo, but it is not listed in my name because it is present, I have filed the NOC wakalat. They have not updated the,
So what is to be done by the court? We should go to
no,
the
but they are also not listing in.
No, all the memos have given the dates. If you want, please verify with the court officer. If required, give another memo. And don't mention, that's what I want.
Much.
Yes.
If this is a matter 1711, it is posted. It seems the law is applied incorrectly. It's NPA calculation of NPA 90 days was supposed to be from the date of non-payment. That is, their non-payment date was excluded when court made the observation. So I'll produce the necessary circular. I'm producing it today. So it may be taken up tomorrow. It's urgent.
When is it? No urgency. No urgency.
No, not because of anything else. Sir. It will have a wrong precedent set. That is okay.
When order is passed, now we.
No, mine.
No.
This is not uploaded in that matter.
What is the number?
Please, 12375 of 2022 had already given the number to the court of sir.
And
His order sheet is
court
yet
officer,
not.
look at it. Whoever is a stenographer, and when is the order passed, why it is not uploaded, ask the registrar judicial to look into it. Why it is happening every time. Yes.
Grateful.
Number is page-wise adjournments, if any. List number 1, page number 3, 6 to 9, page number 4, 10 to 16, list number 2, page number 3, 6 and 7, page number 4, 8 and 9, page number 5, 10 to 13.
My lords, serial number 10, my lord. No, there's some settlement talks which is happening, my lords. I've informed my learned friend also, my lords. Kindly, the matter may be taken up next week, my lords, and senior is
Do you have
also.
any instructions on that?
Respect of settlement, I don't have instruction, but this morning called me and said
I've
that.
met the AGM, my lords, so we are having a word, my lords.
Get instructions, call your office, then we will see when the matter reaches.
13 or
Yes.
4. My lords, I've already, my lords, senior is also not available, my lords.
That's not the ground. Yes, next.
Page number 6, 14 to 22.
Serial number
20. This is a matter challenging the subvention scheme, my lords. It is GMRES, the coordinate bench is dealing such matters. By mistake, the office is listed in under the category of GM DRP.
What is question?
Subvention scheme, my lords. It does not come under this quote or the roster, my lords.
We'll see when the matter is.
Serial number 19, my lord.
Yes.
The council is not feeling well. He's been admitted to the hospital. They pay for a week's accommodation.
19.
19.
19. This is matter on November 18th.
Please, much obliged.
Yes.
Page number 7, 23 to 29. Page number 8, serial number 30. List number 3, page number 1, serial number 2.
My lord, serial number 2 seeks for a short accommodation. Senior is having a medical
We'll
emergency.
see, we'll see.
My lords, I appear for respondent in this case, my lords.
My lord, it may be posted tomorrow. No problem, my lord.
This is matter on 20th of November.
Much obliged.
Page number 2, 3 to 5. List number 4. Page number 4, serial number 9. Page number 5, 10 to 16.
My lord, serial number 14, my lord. I am for the appellant in this matter, my lord. Kindly attend tomorrow in this matter, my lord. I am not keeping well today. I'm kindly attend tomorrow, my lord.
Your presence is not required for this.
My lord,
Oh, there is-
reason is this, my lord. This is a one appeal. Senior will be argued. Senior also not keeping well. That's why, my lord, I will seeking.
This is matter on 26th
My
of
lord, my lord, my
November.
lord. Next week, otherwise, please, my lord. First time I will approach this, sir.
And every day there are 150 MFs.
I'm approaching first time, my lord, in this matter.
This is matter on 13th of November.
Oblige, my lord.
Yes.
My lords, the video of the court perhaps is not on, my lords.
ಬರ್ತಾ ಇಲ್ಲ ವಿಡಿಯೋ ಬರ್ತಾ ಇಲ್ಲ
ಶೇರ್ ಮಾಡಿ ಶೇರ್ ಅಂತ
Call somebody to come.
Page number 6, 17 to 22. Page number 7, 23 to 26. Page number 8, 27 to 31.
My lord, 27. It may be same.
This also same day.
And 13, my lord.
This also the same day.
Oblige.
Page number 9, 32 and 33.
List number 2, serial number 29, I am withdrawing my petition. That's not first. Memo for withdrawal. Memo for withdrawal.
List number?
2, serial number 29.
List number 2 is over long back.
I am withdrawing.
Yes.
For orders, serial number 1.
May
Take
make
that 1 minute.
the video was not on. I could not make the submission earlier, my lord. List number 2, serial number 19. I had challenged the auction notice, my lords. I don't know whether the auction has taken place. I'll just confirm. Can I seek a week's accommodation, my lords?
List number 2, you are saying serial number?
19, my lord.
29. List number 2, serial number 29.
Serial number 20. Memo is seeking to withdraw the petition. Dismissed as withdrawn.
My lord, serial number 19, my lords. In the same list, my lords.
Serial number?
19, my lord. List 2, 19, my lords.
Yes.
I had
No,
challenged
already somebody has asked for adjournment,
Yes, my
saying
lord.
that you are not well.
Okay, my lords. Grateful, my lords.
You are well or not well?
No, I'm well. I never asked anybody to submit, my lords. Because the video was not.
That's what, no. 19 somebody mentioned in the morning.
Anyway,
that you're unwell.
even I needed time, my lord.
Anyway, it is adjourned, yes.
Grateful, my lords. Anyway, my lords.
Yes.
For orders, serial number 1, Jaiprakash Reddy.
Senior is held up in quota number 7.
Huh?
Senior is held up in quota number 7. May kindly be passed over.
This pass over.
My lords, in this matter, my lords, in the item number
Pass over.
1.1, my lords, I undertake to, my lords, file wakalat for the respondent.
Pass
You have
over,
been
sir.
there and on record from a very long time.
No, my lords, in 1.1, my
The-
lords, I am recently served. I will, my lords, file my wakalat. And my lords, in this matter, my lords, the proceedings are going on before
Submitted
the
that
land.
Mr.
Nitin.
Prasanna Kumar P has instructions to file wakalat in WP 20087 of 2025. List this matter on 13th of November.
Great.
Hmm?
Pass over.
Yes, to file wakalat, we'll see on 30th. Yes, no.
Serial number 2,
Grateful.
Sridhara K.
And
Appear for petitioner. It is respondent. The petitioner. The
in spite of an order passed by the court, wherever the court has an order of maintenance and also recommended. From the date of the order till now, the mother has not produced the children. Does this matter on 3/11/20?
Your Lordship, last date, Your Lordship, said you will hear the matter finally today.
This was order dated 30/10, I'm looking at. That's what is directed today. I've recorded the submission. Yes, where is order?
Yes, order page number 27, Madam. The operative person. Page number 118, Madam.
Is this an order on IA or it is a?
IA number 3 IAs are filed. The 2 IAs are filed by the wife, 1 IAs filed by the.
Page 27 to 119.
Yes,
IA
ma'am.
order.
Yes, ma'am. The IA number 3,
The petition is directed to pay a sum of rupees 3,37,000 in respect of school fees.
school fees. IA number 4 is,
10,000 each per month
yes, ma'am.
and 2 children, that is 30,000.
Yes, ma'am.
50,000 litigation expenses.
Yes, ma'am. IA number 5 is section 26.
The respondent is directed to produce the children by name so and so on every Saturday except second Saturday from 11 AM to 1 PM to interact with the children. Yes.
Yes. Now, we are challenging the IA number 3 and 4, ma'am.
IA number?
3 and 4. Ma'am. The
3 and 4 is educational
expenses and interim maintenance concern, ma'am. Now, the reason for desertion, my lord, the reason for desertion between the husband and wife. Now, the respondent is having a contact with someone person. He advised so many times, but he.
Please understand.
Yes,
as far as this ground of desertion,
Yes,
adultery, and all will not be decided in the
Yes,
IA.
that's my.
So we will not
No.
go into that aspect.
Yes,
We are
ma'am.
only, please confine your argument.
That's why we filed the petition for divorce on the ground of cruelty.
That
In
the
that
trial
pet-
court will decide.
Yes, ma'am.
So you please confine your arguments with regard to your financial
Yes,
capacity.
yes, ma'am.
Yes.
On 6th June 2020, order has been passed, ma'am. Now, on 31st June 2022 itself, we given the resignation and the resignation has been accepted by the company. That time, because if I am not in a position to attend the work properly, there are several cases pending between the husband and wife and also
What happened to you?
because I am not in a position to concentrate the work, the office,
Right from 2020, you're not working.
right from 2020, June 2022, I am not working, ma'am.
Then
Then, because we pay the expenses of the medical, the educational
you
expenses,
say
yes,
from 1st June 2020,
to 22, ma'am.
this order is passed in 22 or 20?
22, ma'am. June 22.
This is 6th June
6th June 2022. Yes, my lord.
You stopped working from 1st June
1st June
2020.
2022, my lord. Now,
Just
before that,
the
I
orders are passed.
yes.
Hmm.
Before that, I was earned 1,40,000 per month. I am taken care of the entire children education expenses also.
Right from 2022 till now, you're not working.
Not working.
Why?
Because I have no job, because I have to proceed the matter, because from 2022, there are 5 cases are pending between the husband and wife and the execution proceeding.
How are you living
Now,
without any money?
just having a one camera, I given the rent to the camera to the for the purpose of earning. I'm getting the income regularly.
How much you get?
20,000 the worth of the camera. Normally, the 10 to 20,000 I'm earning every month, ma'am. But because of to pay the maintenance, what is the object, the execution filed by the petitioner, the respondent herein, I'm not in a position to mobilize the amount. I sold the camera also. I'm deposit the amount. Now we have no job. As presently, I have no job. Now, apart from that, I am purchased the property in the name of my wife. The worth of the property more than 16 lakhs. Even say my wife never paid single rupees. Entire amount has been paid by the petitioner by way of demand draft. Now she getting. Apart from that, she sold the ancestor property. She getting the income. The used property, the amount from the ancestor property, she can utilize the said amount. In spite of it, suppress all the fact. The trial court ordered the they direct the petitioner to pay the amount maintenance of rupees 30,000 per month.
As on the day when the order was passed, it was not in the notice of the court that you quit the job.
Yes, as per my concern, he filed the memo before the court that,
No,
because he has not
anticipating-
pleaded in the objections.
Anticipating that the court will pass order on 6th June.
Yes.
So you quit the job on 1st June.
Yes,
Is it?
yes, madam.
Because
Because
court is
I have
going-
not filed any.
No. Because court is going to pass order on 6th June.
6th June.
Granting maintenance.
Yes.
You quit the job on 1st June.
Yes.
I'll record that.
Second one is that, second, because the
You
education.
understood what the court asked you?
Yes, please.
I said.
Yes,
Only to evade the payment of maintenance, you quit the job.
not madam, because I am not concerned. Now in para 24 of my petition, I have taken the contention because I am not in a position to concentrate the work the company has directed to the term.
That day till now, you are only waiting for this closure, cases to close and you are not working. Is that believable, Mr. Counsel?
The actual position, because when I am not concentrated, the company normally expected the good works because they pay the salary. That's why they
You are
expected.
arguing the case or the advocate is arguing?
But
You are arguing the case or the advocate
no,
is
the
arguing?
earlier advocate argued the matter.
Your client has engaged an advocate is arguing. So what is he doing in the courts all the time without working? These kind of, able-bodied man, you have a responsibility to take care of the children and the
Yes,
wife
yes.
who is not earning.
But the.
So we will not take all this into consideration,
No.
particularly in the light of the fact you were earning and you are earning 1,40,000.
Yes,
A person who is earning 1,40,000, just like that will quit the job from 22 and you sit at home. You say, I have rented the camera, I sold the camera. What is all that?
No, because I am not in a concentrate on the work. That is the reason I am quit the job.
So everybody who have matrimonial issues, they should sit at home.
Yes.
No.
Second thing is that the educational expenses, madam.
Yes.
Because the
To
before.
argue something on quantum, I'll hear.
Yes, ma'am.
Yes.
Yeah, second thing is the educational expenses concern, ma'am. Now, before admitting the child, wife never instructed with the husband and we never consulted the husband before admitting the child, ascertaining the financial capacity. Because I am ready to take care of the child as per my status, because my mother-in-law having one school and he interested to admit the child to the said school, but she never given the consent. But she claimed the educational expenses is 3,37,540 per year. Apart from that, the IA number 5 bill, though the visitation rate has been granted from 2000.
See, you please conclude your arguments
Yes.
on this. First is I number 3 and
30
the other, I number 4 is not in question.
IA number 5 is not question, IA number 3 and 4. Ma'am.
Yes.
Yes.
Why is visitation? I know you have not questioned.
Yes, ma'am.
If there is no the implementation,
Yes.
file a contempt.
Yes.
That is, so coming to this maintenance, court has granted 10
Thir-
into 3,
30,000 per month.
30,000.
Yes.
Hmm.
Now, but as per the situation from 1st June 2022 onwards, I am not in a position to pay that amount. Ma'am. Because to pay the amount I have already made under debt. I have taken the loan from others. I am not in a position to clear the said loan also.
Yes, what do you say?
Yes, my lord. Whatever my learned friend has said, the first thing is he has incapacitated himself. He has incapacitated himself from earning of 1.5 lakhs, number one. Number two, they have several properties. His younger brother is staying abroad. He's staying with his parents in a palatial house in HSR layout. They have a lot of rental income. They have a film production unit.
No. Please submit basing on the material that is available.
Yes.
That was placed before the family court.
Yes, that is the material.
What is the material?
The
What are the
material-
exhibits?
Now, your
What is
lordship will
that
see,
mark?
may I take your lordship the number of properties they have
No,
bought?
his income of his wife, his brother and all, that is not
No,
the.
what I'm saying, I said brother is abroad. So He's the only one staying with his parents in this palatial house. They have rental income, and he's now he's a film actor now in the regional film. He's acting in films, in the film, some of the films he has been released also. They have a production unit, not single camera, my lord. It is an entire unit worth of crores of rupees for a film production, which is
There is
using
a
the camera.
material, please,
Yes.
please draw the attention of
Yes.
the court to that.
They have got, my lord. They are in the film, the production, on the impugned order. You also will find. Yes. They also have is there in their affidavit they have filed. Yes, they have mentioned about the
Page number 32 of the impugned order. Page number
Yeah,
32
what
of the impugned order,
Nalliga
running
Productions.
page number 58, my lord. Running page 58, impugned page 32, my lord.
Yes.
First two line.
Yes. Have substantial same example. As far as the condition is concerned, for the entire charge and yes, yes, you all should kindly find in page number 58. First line, my lord. As far as truth, admitted petitioners, after struggling 6 to 7 years, are able to secure an opportunity to make his debut in Kannada film industry. And during the first film, there was only a lead actor. There was another actor also so and so. Then coming up to second film, there was released in the year 2019. This is so far as acting is concerned, my lord. He's still now acting in films. And then, yes.
Have you found out who is taken? Who has taken the dictation?
This is Nalliga Productions. They have got a firm, my lord, Nalliga Productions, which is still in the affidavit they have said in the trial court. It's referred to in the impugned order which they have challenged to the court.
When was the order passed?
It is there, my lord. Nalliga Productions, they are not denying that. And they have got, yes. Nalliga Productions.
You
Apart from
admit
that,
the
my
fact
lord.
that there is a partnership form.
Pardon? Partnership normally
It's existing.
Who is the
already-
partner in that?
his father and mother and his the petitioner and the two others, because they said partnership was already cancer closed, my lord, in the year 2022 itself.
Everything is done in 2022 itself.
Because there was so many rivalry between the respondent and the husband family member.
So
Even
wherever there is a scope to see that there is some income, you did something with that.
Yeah, we were ready to pay the minimum 15,000. We were ready to pay the 15,000. Apart from that, we pay the 50% maintain the educational expenses also, made because
Pay the 50%.
because he's having a ancestral property, one ancestral property. The said property has been sold by the mother and the petitioner, and the said amount also used. Kindly peruse the last document mail in page number 135, my lord. There was one property.
There appears to be like there are no bona fides on the part of the petitioner. Petitioner only to see that she won't get the maintenance. He's playing all the tactics.
No,
That's what
situation
is-
situation
that's
arose.
what
madam.
no
Situation arose because there are several litigation and matrimonial disputes. He is not in a position to reach the
There is no severity.
employee.
The DV Act, my lord.
Before
Orders
that, the learned friend, he himself conducted all the cases on behalf of the petitioner himself before the magistrate court and also civil court. He has taken the reply. Earlier to that, my learned friend is defending all the cases.
Of whom?
the petitioner cases. Now he is representing wife.
How can you represent?
I have not read any case, my lord. I'm sorry.
I filed the affidavit and also Wakalatnama. He
I
himself
have-
is conduct all the civil cases and criminal cases.
I have returned the
Yes.
NOC, my
Support
lord.
of that?
Yeah, return the NOC means.
I have just a civil suit of different matter. She's my niece over there, the respondent. When that notice came, I returned the NOC. That was the case of some other property matter, not this matter, any matrimonial matters. No. I returned the NOC. Only one
I
case
will
was there.
keep, I
that
will
was
kindly
filed.
have it definitely tomorrow. I will file to all the Wakalat because before the litigation,
I can produce it.
whenever the
I-
respondent,
my lord.
one submission, the respondent mother, the petitioner mother has issued the notice including the petitioner and the respondent. My learned friend issued the reply stating, denying all the averments. Thereafter, my learned friend has to defend the criminal cases which are pending against the petitioner and his father before the magistrate court. He himself is defending. In civil court also, he himself is defending all the cases and filed the written statement and contest the matter. Now, when the matter reached the family dispute, it and given the NOC and before issuing the NOC, already issued filed the representative wife.
My lord, you all should, you all may kindly take to my objection filed. This is even to the notice of 2014.
No, so
Yes, my
everything
lord.
because he's a relative of the both parties.
My lord, may kindly take to my 14,
Whatever it
9,
is.
22.
Whatever it is, when the disputes are
I-
between the parties, when you appeared for the wife, how can you appear for the husband? How can you
My
appear for
lord,
the
it was,
wife?
let me clarify, my lord. It was a case of earlier 2012 or 11 of some civil dispute of some other property, not this any matrimonial matter. No. You all should see what is talking about the notice which your lordship will find at page number 10 of my objection file annexure A. 14, where the notice was issued by the mother of the petitioner to her husband, to the petitioner here, and the respondent also. The respondent, my niece also was a party to this notice at page number 10, annexure A of the objection filed on 14 September 22. What is talking about a civil case that was, I returned the NOC because I have to defend the respondent in this case. My lord, may I submit one more, my lord, for zero tolerance. When this issue came to me, my respondent brought to me, I summoned these people before the notice. I said, if you are not irritable, please come and settle. No, issued a notice. I replied to the notice of this matrimonial matter. Even then, I called the petitioner and his father to my office and I spoke to them, their relatives. I said, suggest to me, please settle. No, he sent me a notice, the summons. Before that, I issued an NOC and said, please take it back because I have to defend my niece, the respondent here, because it's a very serious matter. That was only one of the defendants. They were not this thing. I will not file a case in that case. I was for the defendant in that case. I returned the NOC. That is not nothing to do with this. That not disable me to defend this case of the respondent in a matrimonial matter. They are not my regular clients. Therefore, Your Honor, that is not the issue here. The question is now whether you are able to pay the maintenance or not, whether your income is not is the question. Now, you have filed an affidavit before the trial court. You have made a mention of what the value you were getting. You file, my lord, the only two, we filed DV case that there's ordered now, he has to pay 8 lakhs over there from 22 onwards. Lordship will also find for 3 years this admission was pending. He did not raise any objection in the trial court. He did not move this court. When this case was listed for dismissal, he comes and says about visitation, he brought an issue. There, Your Honor, will find the daughter who's now about 15, 16 years had made an endorsement in the mediation report that I'm unable to stand to my father. He's harassing me. He's pressurizing me. I'm unable to wait. I'm getting, my mental state is deteriorating. He has made a mention. I've said in my affidavit. Now, therefore, Your Honor, will find out there's not an issue. It's off the track, which is trying to say now. The question now is on this merits of this case, what is that you've got to say is the question. And my lord, I can even produce the WhatsApp messages there. 14 years, this respondent is suffering. She has viral arthritis. She has pelvic problems, so many other medical issues she has. And then, my lord, he is the one who started 14 years ago about divorce. The respondent requests, please, for heaven's sake, my daughter came and spoke to me that one of her classmates in school said that their parents went for a divorce. She's unable to bear it. Please, till for some time, till I make these children mentally strong, please be with the children. He says, no. I can read that. I produce those things. But therefore, my lord, let him not try to say sudden concern about this and not. He never objected, my lord. First, my lord, let me say one thing. First, I filed an execution in 2022. He paid the amount over there, which was 6,83,000. He did not object. Then again, there was accrual of another 6,83,000, which I find now in that 53,000 is due. Now, as on date, my lord, the amount that is due is nearly around 6,60,000. Plus the DV order that is passed just last month for residence order, 8 lakhs is due. He has the capacity. He has this potential. Now this is off the track, he's making a submission. What case was defended there was, we did not find anything, only wakalat was filed in that case, the civil suit. That is about almost 15, 16 years ago. Not now. So therefore, my lord, the question is now, on the merits of the case, my lord, he cannot incapacitate himself and say that he has no income at all and he has resigned, he doesn't want to bother the job. And he is an engineer and computer scientist, engineer. Therefore, my lord, the question here is, now the question of maintenance is not paid. He was paying all these years. The order was passed in 7/7/2022. The petition was listed for dismissal on 24/7/25 when he comes up with the submission. For 3 years, he did not move the petition. Even after that, my lord, when this thing was there, he never objected or raised any objection in the trial court. In fact, my lord, he was brought under arrest. I pleaded with the respondent, said, no, let him not go. Please leave, let him pay some money. Where's the point? The children tomorrow will suffer that the father went to the jail. I did not press for that, although he was arrested and brought to the trial court. So therefore, my lord, this is off the track. He's trying to make a submission. And one thing, my lord, when the petition was filed, he did not file for custody of children. After I filed 3 and 4 IA, he files IA number 5 after that. And I can show my lord in the cat's WhatsApp how he has neglected the children. When the respondent requests to please stay with the children, he says no. Recently, I sold a property, my lord. I have produced the photograph. My John 6/8/25 with the photograph. Another property is kept for sale. Their mobile number is on.
Please come.
Yes, my one submission.
May I make
In my
one
assets
submission,
and
madam?
liabilities, my lord.
May I make
Now
one
till
submission?
today, sir, 1 second. Till today, I've paid 24,60,000, including maintenance and educational expenses, my lord. Now, to pay the amount, I've taken the loan from the Bajaj Finance and HDFC. The 40 lakhs rupees, the 40 lakhs rupees loan is pending, my lord. Because for my survival and also to pay the amount to the educational expenses, I have taken the loan. I have produced the detail, the accounts detail in Annex G and F in my assets and liabilities, my lord. Because I'm not in a position to pay the EMI also.
May I submit my lord?
Till now, the 24,60,000 paid, 9 lakhs rupees educational expenses, 15,60,000 as a main already paid.
I have filed the objections on 6925 where they have sold one property with petitioner for 3 crores 47 lakhs. I produced the photograph, my lord. I did verified document number 1, page number 4 of my objection filed on 6925.
Page number.
For my objections filed on 6925. Objections filed.
There is no page number for that.
69 I filed it. The seal is on 69. Additional objections, 69. And the second property is put for sale. Their mobile number is depicted on the building. Document number 2. It's my additional objections, Your Honor. Document number
146 lakh 17,000.
It's a 4060 3-story building, 3 crores 47 lakhs is what is registered. I don't know about the component. The second property you also will find is a mobile number of the respondent father-in-law and the petitioner, which is kept for sale. That was 4060. 14,500 they are quoting. I sent a decoy to find out.
All the properties are parents of the petitioner. There was a lot of litigation between the mother and husband. Because my late friend very well knows, he only issued the reply notice to defending the husband and daughter-in-law.
Okay, file the documents.
Yes.
What are your objections to that?
No,
What is
46, yeah.
What is your response to that?
Kindly peruse the mode of payment. The agreement entered in the year 2021, my lord. 21. The consideration 46 lakh 17,000, my lord.
Are you saying 1 crore or not?
No, my lord. The sale deed itself 46 lakh 17,000, and amount all the consideration passed the paid in the year 2021 itself, not now. 2021, the very same document reflects, my lord. Not the 21, the sale agreement has been entered between the vendor and purchaser. Now the amount mentioned, the 28 lakhs 10,021 by way of RTGS, my lord. 14 lakh 41,000 on 22 to 2021 itself.
Where from you're getting this 1 crore and or they have sold the property? Basing on what you're saying that the property is sold at 1 crore and odd.
3 crores 47 lakhs.
Where is that?
No, see, what I said, my lord, this is what one of the informant of their own people who informed me, which I would able to do. If they deny, no, my
Tell
lord.
all that. I want some document on record, not what your hearsay evidence.
Okay, document number 2, my lord. Their phone number is
You
on
have filed
mobile.
so many documents, which page, where, I'm not able to see.
No, I've given the address also, my lord. If they're not denying it, that they have not sold it. And also document number 2, the phone number is, the mobile number is on the building, which I got a photo for document number 2, page number 6.
That property is not belong
They're
to the
kept for sale at 14,500 per square foot. They're saying they're not able to pay the maintenance.
You can't expect the court to do all this exercise.
No, my lord, basically.
Looking at the mobile number, whether that mobile number belongs to him, whether the property belongs
No,
to him.
why
What is the consultation he has received?
No, the only
What you heard from the neighbors?
No, only, my lord, the only thing was to say that they have got the paper, they are liquidating the property, whatever reason I don't know. But they cannot take a stand that he has got no job or he is unable to sustain. He has to take care of the family, and then.
The court
my
can
lord,
only consider the evidence that on
Yes.
record, which probabilize your
Yes.
case.
Para 19, my lord.
19 of what?
Just one I'll read, my lord, para 19, please. Para 19 of the judgment. The petitioner has filed his affidavit as to the assets and liabilities in which he has stated that he is aged about 36 years and he has done BE graduation in the field of computer science, presently working at the A&T.
I've read all that.
No, the
Read
next
all
is,
that.
the next
What
one.
is the relevant, you please read?
He says the respondent has no source of income. She's only first wife, she has no source of income. He only has stated in his affidavit, the trial court, with all the medical issues he has got and the response of bringing up the children. You know, what amount has been granted by the trial court is very reasonable.
Yes,
So,
please come. Agreed with orders passed in.
In fact, she has
In
mortgaged
number
her
3 and
jewelry.
4. In MC number 4682 of 2020, dated 6 June 2022, the husband is before this court. The wife had filed I number 3 seeking a direction to the respondent to pay the arrears of the school fees at 3,37,000. 37,550. And I number 4 is filed seeking maintenance. The court, by order impugned, had directed the husband to pay 3,37,540 in respect to the school fees of the children. That is only to that particular year.
Yes. Subsequent year, they filed, we complied. And
3,37,540. And also directed the husband to pay 30,000 per month from the date of IA, that is from 20 to 1/2021, till the disposal of the case. And also is directed to pay a sum of rupees 50,000 towards the litigation expenses. Along with these two IAs, another IA is filed seeking visitation. And the court has passed an order directing the mother to produce the children for in the visitation room of the family court Bangalore on every Saturday except second Saturday from 11 a.m. to 1 p.m. to interact between the petitioner and the children. Learned counsel appearing for the petitioner husband submits that as on the date, the order is passed on 6 June 2020. On 1st June 2022, he left his job. While he was in, while he was doing his salary was 1,70,000 and odd.
14.
And after deductions, it is 1,35,000. It is submitted that on 1st June 2022, he had resigned the job as he was not able to bear the stress with regard to he is not able to bear the stress and balance the litigation and his work. And right from 2022, he is not earning anything. It is stated that he has a camera. He has rented that camera, and he was paid 20,000. It is submitted that later, as he has to pay the arrears, as they have filed the execution, he has to sell the camera also. And as of now, he has no source of income. Learned counsel appearing for the respondent submits that the husband and family are having immovable properties. They run a partnership firm where they lend these cameras, and they're eking out. They're earning a lot of amount. According to him, recently they sold a property for 1 crore and odd. All these things clearly shows that he's having the capacity to pay the amount. The wife is completely dependent of the husband, and she has no independent income. It is an admitted fact that while they were together, he was taking care of the expenses of the child, and the court had rightly considered and granted the maintenance, and there are no grounds to interfere. In response to that, learned counsel appearing for the petitioner submits that all those properties belong to his mother, and there are property disputes between them. All those amounts are given to her, and as stated by the counsel for the respondent, it is not 1 crore and odd, and the property is sold for 45 lakhs.
60.
Huh?
43 lakh 15,000.
It is sold for 43 lakhs 15,000. It is submitted that he has in fact to pay all these amounts. He has taken loan from the bank and is struggling to repay the, to pay the EMI. Next para. Having heard the counsels on either side, peruse the material on record. The petitioner was working till 1st of June 2022, where he was getting a good salary or handsome salary of 1,75,000, and after deduction, 35 to 40,000, 1,35 to 40,000. In that case, when a person, the argument of the council that as he's not able to balance the job and the litigation, he has completely left the job and is sitting idle from 21 to 22 till now, cannot be believed. He is a educated, able-bodied person, and right from the beginning, the wife is not working, and he has been taking care of the educational expenses and other maintenance of the children, and the properties that are sold, and the contention that the partnership is closed, and all other things on the face of it shows that the whole intention of the husband is to avoid the maintenance to the wife. And admittedly, there are properties in the family, properties belonging to the family. It is the case of the husband that it belongs to the mother. He being the children, it's the son, also will have a right in the property. The 3,37,540 that is awarded by the family court is a one-time amount where he was asked to reimburse the amount. Then after that, the amount of maintenance that is awarded is 30,000. 30,000, considering the family background. The amount of maintenance that is awarded by the court cannot be, it cannot be considered as an exorbitant amount. The conduct of the husband, the facts and circumstances shows that he is not inclined to pay, he is inclined to evade the payment of maintenance to the wife. The husband, who is an able-bodied person, that too in this case, who is qualified, has the responsibility to take care of the children, and he cannot, for the purpose of avoiding the responsibility, he cannot be permitted to come before this court with these kind of submissions. In the considered opinion of this court, the family court has rightly considered and granted the maintenance, and this court do not find any reasons to interfere accordingly.
MC petition in the year 2020. They are not complete the cross-examination today because they are only to drag on the proceeding to gain the maintenance.
Here is the MC.
2020, my lord.
But
MC 2020.
family court, it will dispose of the MCs till 2019.
We have completed the evidence in the year
I cannot
2022.
pass any direction for the MC after 2019. Yes.
20, my lord. 2020 matter.
I'm saying they will dispose of only till 2019. I'm passing orders for expeditious disposal of the MCs till 2019. You can file a petition in the month of January.
Please.
Then I'll pass an order.
Please.
Yes. No, why is she not uploading is the question. Every time this is happening, tell the registrar judicial to look into it. These kind of complaints we can't take. And ask registrar judicial to come to the chamber in the afternoon. Yes.
Seal number 3.
And for the
Petition
petition in this case, Lordship.
Yes.
Your Lordship. In the last of hearing, I have been directed to serve the notice. then she was, when I got the order from the small court, when I got the order from the small court, interim order, at that time I have been told to serve the notice, have been served. She was regularly appearing for 1 year. Thereafter suddenly stopped. And they are also not appearing before the family court for the last 6 hearings. In the last hearing, the matter was questioned.
Matter, please argue.
Your Lordship, the honorable,
Good order.
the honorable court was pleased to pass an order stating.
Page number, come to the order.
Your Lordship, I lost the file. You should kindly have it tomorrow. I had to appeal the.
You're making all complaints against respondent.
It's not complaint. It is a fact. You kindly produce the order sheet. It is a fact.
Please order.
In page number 27 of his petition, Your Honor.
It has been reflected in the.
Respondent is hereby directed to hand over the custody of the child to the mother forthwith, failing which the petition is entitled to take the custody of the child through due process of law.
Even though.
Yes. When is this order passed?
On 25/9/2023, Your Honor. The petitioner, along with the police, also had been to the respondent's house, the husband's house, to take the custody of the child. Even the police had come from Banaswadi police station, but they were not allowing her to enter into the house. Whole night she was been waiting there. She had been.
Whether this order is complied with or not?
Till today.
Your Lordship, Your Lordship, Lordship. See, when this order was passed, immediately approached on court. You can see the trial court has come to the conclusion that the child is 3.5 years. Actually, the trial is 5 years 9 months at that time. See, I have 5 years 9 months.
According to you, 5 years is older. He's too old to be with the mother.
No. 5 years 9 months. The child is 5 years 9 months.
5 years or 6 years, he is too old to be with the mother.
It is not like that. It is not like that. But the trial court has come to the conclusion. The court.
Is there any interim order in your favor?
We had interim order in your favor, Your Lordship.
Where is that?
This honorable court was pleased to pass an interim.
There is produced certain documents which depicts the child to be suffering from cancer. Therefore, care, custody, and love of both the parents would be required for the child in this situation. When is this order passed? On 29/11/2023.
Yes, Your Lordship.
The family court's order.
On 50. On 25/9/2023, Your Honor.
Now the boy who is suffering with severe
Yes,
health ailment,
yes, Your Lordship.
both of you are fighting on him.
So, Your Lordship, she left. See, when she came to know that the child is suffering from cancer, she left the child when he was 2 years old, and she has thereafter she has filed when he was 3 years old. She has filed the GNWC.
This is the false allegation.
And the father is taking care for the last 5-6 years.
I don't think you require the mic. Please switch on the mic. Yes.
Your Lordship. Your Lordship, she left the home. She has taken the divorce. She has married to some other person. She is having a child now. After 3 years, she has come to.
No. When was the separation?
In the year 2022, in the 2019.
During the period of COVID,
Your Lordship,
there was a false allegation. Your
even
Honor.
to this day, they are not ready to admit it. Divorce has been taken place.
Your
In fact,
Honor.
they produced all the documents.
During the peak of
Your
COVID-19,
Lordship, thereafter she married. Even they are not agreeing that also.
petitioner is already
Birth certificate
married.
of the child.
Only one advocate at a time. Yes.
Your Lordship, she has taken the divorce. She has remarried. She is having a daughter. And I am the person. I am maintaining the child. When he was 2 years old, at that time I came to know he is suffering from cancer. We are taking the child to Chennai, Kerala, and all hospitals. All my earnings are spending on the hospital.
List this matter as partner tomorrow.
Wakalat has not filed. It is reflecting. Wakalat is not filed. Look, I can
That is not your problem. You can argue tomorrow.
Yes.
Yes.
Number 4, Dinesha.
Interim order may be extended, Your Lordship.
Interim order only granted is extended. Yes.
My lord, serial number 4, my lords. I undertake to file wakalat for respondent. Undertake to file wakalat for respondent.
You have instructions. So and so submits that, write your name. So and so submits that his instructions to file wakalat on behalf of the respondent. Then counsel for the petition shall serve the, have you served?
Served, sir.
It is submitted Copy is served?
No, I'm not receiving.
Then counsel,
I
the
will give- I
petition
will
shall serve the copy of the writ petition on the council. List this matter on 20th of November.
Kindly extend interim order.
Interim order earlier granted is extended. Next file.
Number 5, MD Raghunath.
I appear for the petitioner, my
I
lords.
undertake to file the wakalat in favor of the respondent, my lords.
In fact, on the earlier occasion, my lords had,
So the
I'll give the copy.
I not served.
I'll give it.
counsel for
I'll
the
take a
so-and-so
Xerox.
submits that she has instructions to file wakalat on behalf of the respondent. List this
My
matter
lords,
on 13th of
may I
November.
make a humble submission? The trial court matter is there tomorrow, my lords. There's an extreme urgency. In fact, the application filed by the petitioner was dismissed in the trial court itself, my lord.
What is
That is
that?
Order 16, Rule 1 and 2, to bring the doctor on record as a witness. The only problem is, my lords, the petition is filed under Section 13(1), subsection 3. Now, the trial court has already rejected my application, but the earlier trial court,
Wakalat,
One
my
minute.
lords. Kindly
Earlier, whatever it is,
Yes,
no,
ma'am.
for substantial justice, for doing substantial justice to both the parties. Why not? Already, earlier there was an order, doctor
Yes,
has not come. Why not that be continued? What is the prejudice to you?
I'll file the wakalat and file the objection. Later I'll submit.
No
the
objections are
documents, my
required here
lords.
in the writ petition, because we are only looking at the impugned order,
Yes,
or
ma'am.
how it is bad. The last occasion I saw. So why can't there be no, already earlier it was allowed. For
Yes,
some
ma'am.
reason, the
Counsel
doctor
is
was not
different.
examined.
One submission, my lords.
When it
Counsel
was,
is, I'll get the information from the council, my
Tomorrow,
lords.
list this
Yes,
matter
ma'am.
tomorrow.
the matter is also listed tomorrow, my
Please
lords.
give the copy.
We'll not stop anything. Tomorrow,
Then
give
give it.
her a
Not
copy.
served.
I'll
One
do that.
submission, my lords. They have not given the copy.
I'll give, ma'am, I'll give. Let me take a Xerox.
He'll give you
Yes, ma'am.
and get instructions and tell your client, I'm going to allow this writ petition. Yes.
Much obliged. Please give the name. Number 6.
Ladyship, I appear in this matter, item
Absolutely.
6. Yes.
Yes.
Ladyship, in this particular case, the child has already interacted with the ladyship in the chambers. Now, the fact of the matter is that the child is continuing to ask the father on a daily basis for different things, including laptops, shoes, gym bags, etc. And the father is trying to do whatever best he can. He's also ordering him meals every alternate day. Athlete level meals also he's ordering every second day. But everything is coming to him, but the child is not meeting. It obviously means that the mother is not permitting the child. Because the father has given the phone to the child and the child interacts with the father asking for all these
But
things.
anyhow, we can't help it, Mr. Singh. So please, we'll hear the matter on the merits of it.
No, leadership,
talk to the-
I'm grateful for that. Leadership, can it be, we'll argue on merits. Now, the only point
Yes,
is,
list this matter on
can it be tomorrow or
20th
6th?
20th of November.
Which date,
20th of
leadership?
November. 20th of November.
Leadership,
Yes.
just 1 second. Can
Next.
it be
20th
this
of
week, leadership?
No, not possible. There's so many matters. Yes.
20th, the interim orders to continue, leadership, till at least.
If at all, look at it, wherever the interim order, extend it till the next date of hearing. Yes.
Number 7.
Leadership. Thank you.
Maybe Siddaramaiah. Siddaramaiah.
No representation on behalf of both the parties. This is matter for dismissal on 27th of November.
Number 8. Bopanna.
Petition.
Yes.
Petitioner is challenging the order passed by the trial court in MC number 7 of 24, where order date at page number 20, 11th July 2025.
Yes.
Page number 20, order 7, rule 11 of CPC, reject. The petitioner filed an application before the trial court seeking rejection of the plight filed by the respondent hearing.
You're the wife or the husband?
Husband.
Who filed the MC?
MC is filed by earlier, the respondent filed the petition, matter is compromised, living together. Subsequently, after lapse of 4 years, file another MC.
Why? Once it is compromised, she can never file MC.
Is okay, but the respondent and petitioner living happily, but respondent father taking away.
Whatever it is, how this application under order 7 rule 11 is maintainable? Let's see why you, according to you, why it is. Where is your IA? IA. Where is that application?
order is page number 20.
I saw the order, not the order about your IA. What are the reasons for you filing this application to reject the claim?
Page number. Order 11 sur page number 42.
40?
Sorry, ma'am.
It's not,
One minute.
this is an application under 11. This is under order 7, rule 14.
Page number 51.
Ah,
Page number 51.
Yes.
Application under section 7 rule of services.
Let's read. Please read your application.
For the reasons stated, annexure affidavit in the circumstances of the case, this honorable court may kindly please dismiss the petition in the interest of justice. Along with affidavit, page number 52. Read the affidavit, my lordship.
Yes.
Like
How can it be? I think this writ petition of yours has to be dismissed with cause.
My
But
lord,
this
once
kind of frivolous grounds.
My lordship, the first incident matter is compromised 2020. Subsequently residing with the petitioner house.
Can anybody compel the wife? If
Today
things are
is
not
ready to-
working out,
Sir,
it's for you to, then if you prove before the court that there are no reasons to grant
according
divorce.
one reason is stating in the order passed by trial court, brutally assaulted by the petitioner, no medical certificate.
That's that kind of a ground the court shouldn't grant.
Dismiss. My application is dismissed.
Why should it be dismissed?
Is brutally assaulted, only one reason stated.
It is a matter of trial.
Yes, I
Order
agree.
7, please tell the court from order 7 rule 11, what is the ground for rejecting the plaint?
Already matter.
That is not barred by any law.
Yes, I agree.
Then
Then the matter is amicably settled. Send the mediation center in meantime. For respondent petitioner living happily, but her father misunderstanding between them.
so the court has to understand it at the level of, at the stage of order 7 rule 11 and dismiss the petition itself saying that because the father is interfering, nothing survives.
Yes, my lord. This honorable court is ample power to consider the application, refer the mediation center living happily. One more chance will given. Petition is ready to taken away the result, but refer the mediation center.
I will not.
My lordship,
That can be done before the trial court also. For that, you don't have to file an application and come to the high court. If you want, I will also keep it open. If whatever you want. you can
in
do it.
meantime, further proceeding.
No further proceedings, nothing. Agreed by the orders passed in I number 6 in MC number 7 of 2024 dated 11 July 2025, whereby the court had dismissed an application, rejected an application that is filed under order 7 rule 11. The husband is before this court. The wife had filed MC number 7 of 2024 seeking divorce. The husband has come up with this application under order 7 rule 11 stating that he married the respondent herein wife on 2/2/2017. They have a daughter in the wedlock, aged 6 years. She is studying in first standard. Earlier, the wife had filed MC 36 of 2020 seeking the relief of divorce. The husband had filed MC for restitution of conjugal rights. These cases were compromised in Lok Adalat. Thereafter, the husband filed criminal case. The wife has filed a criminal case against her husband and her parents. And he has filed criminal petition number 1897 of 2023 to quash the same. And thereafter, a compromise petition was filed and case was closed. It is stated that this is a second round of litigation by the wife. He has been harassed and tortured by the wife for no reason. Now he has filed MC 8 of 24 for restitution of conjugal rights and is pending for disposal. This MC is second round of litigation by the wife. There is no cause of action for her. Hence, the petition may be rejected.
MC7 anta, not for 8, MC7/24 filed by the respondent. 7/20.
Yes,
8 anta.
MC7,
The 7 bar
7 of 24 is filed, is a present MC filed by the court by order impugned had rejected the same. While rejecting the same, the court has observed that the wife in her petition para 18, she had clearly stated that in the month of June 2023, the husband brutally assaulted, due to which she sustained injuries. After the incident, the husband ousted her and her children from the house, and she has taken shelter in a parental house. Since then, she has been residing separately. The court observes that in the petition, she has specifically pleaded the cause of action to file the petition. The averments made in the petition itself indicates that the the wife has cause of action to file the present petition. The husband has filed his objection to the main petition, wherein, except denying para 18 of the petition averments, he has not averred anything about the cause of action. The plain reading of the petition averments clearly reveals that the petition discloses cause of action. The pleadings pleaded by the pleading of the wife is a tribal issue, and the same is not the same cannot be rejected at the threshold. The cause of action is a bundle of facts which will be necessary for the wife to prove in order to get a relief from the court. The facts narrated by the wife comprehensively such as a bundle of facts. Hence, the contentions raised by the husband are not sustainable in the eye of law, and accordingly dismiss the same. Land counsel appearing for the petitioner submits that petitioner husband submits that there is no cause of action for the wife to file this petition. When the earlier round of litigation is as it is compromised and they are living amicably, there is no question of there is no cause of action for her to file the divorce. It is stated that the husband has brutally assaulted her, which is not a correct fact. As there is no cause of action, the court ought to have allowed the IA that's filed under Order 7 to 11. It is submitted that the further proceedings may be stayed, and there may be a notice to the respondent, and the matter may be referred to the mediation. Next para. Having heard the counsel for the petitioner, peruse the material on record. This court has perused the IA that is filed under Order 7 to 11. From reading the affidavit, though it is not specifically stated, it appears that the contention of the petitioner is that there is no cause of action for the wife to come before the court. When an application is filed under Order 7 to 11, the court can only look at the pleadings in the plaint, and the plaint contains cause of action. Whether the said facts that are stated in the cause of action are correct or not can only be decided during the course of the trial. Basing on the pleadings that are taken in the IA that is filed, that cannot be a reason for the court to reject the plaint. Further, it is as rightly observed by the family court, it is for the wife to prove what all has been stated by her, and and this is a premature stage where the court has to this application under Order 7 Rule 11 has rightly been rejected. The next submission of the Land Council that the matter there may be a notice to the respondents and to grant stay of all further proceedings and to refer the matter to the mediation is concerned. When there is nothing wrong with the impugned order, question of issuing notice or staying the further proceedings before in the MC will not arise. If the petitioner wants a court to refer the matter to the mediation, in all the cases, the matter will be referred for conciliation before taking up the matter, and if not, he can make his application before the court And this court finds no reasons to interfere. Dismissed.
In submission, my lord. The respondent here, now, according to the case of respondent hearing, brutally assaulted by the petitioner, even single document is not produced before the trial court. Once the brutally assaulted, sustained grievous injury, is not produced, not taking any treatment in MLC or not the complaint. After lapse of 2 years, once again filed another MC is not maintained by the law and facts. That observation is not yet come, my lord.
Where did you state so? Where did you state it in your affidavit?
Affidavit, affidavit is raised the Bruce petition responded here, not stated anything, brutally assaulted, only simple thing, not produce any medical certificate before the trial court.
Yes.
Please, that observation is not yet come, my lord.
That is not your case in the affidavit. That is not even what you have pleaded in the affidavit. Please read it. Read your affidavit under order 7 rule 11.
Respondent petition himself, not taking any treatment. Please read the para 18. Para 18 of the respondent petition.
Filed a petition under order 7 rule 11.
My,
What are the reasons, your submission that you are making today?
yes, my lord.
Are they part of your application under order 7 rule 11? Have you stated so in your affidavit?
It's not yet, only
Then
the,
why should we consider it?
according to the trial court, come to the conclusion, brutally assaulted. That
is not
observation is
that.
not correct by the,
It is for you to say on what ground the IA has to be allowed. What is that you have said? Nothing. Nothing is stated.
the second round of litigation hence stated in the affidavit.
And by all this, why we should consider all these by way of, what is the purpose of filing an affidavit before the court?
All the detailed narration is due to fault of the petitioner hearing. But my lord, one submission.
Counsel for the petitioner submits that along with the, as she has stated that he has been brutally assaulted, no document is filed by the wife. Then in the discussion, it is not necessary that all the evidence has to be placed along with the petition. It will be, the party who is pleading will have to substantiate their case, and that is not the reason for the court to reject a plaint. Yes, next.
Number 9.
Para 18 clearly stated, suppose if injuries.
Yes, next.
Yes,
Bharat Gowda, serial number 9.
Yes.
But petitioner in this case, my lord, sir. The facts of the case is, my lord, sir.
Come to the impugned order.
My lord.
Impugned order.
Yes, my lord. My lord, sir. The facts of the case.
Not required. Come to the impugned order. Let me look at the impugned order, then the facts.
My lords, no impugned order has been
What
passed.
What is the
Fact
prayer?
is that, my lords, on 26/8/2021.
What is the prayer?
The prayer is to stay the proceedings pending before the senior civil judge court of the MC petition filed by the respondent, who is my wife, under section 9 of the restitution of conjugal right, my lords. Just 2 months before that, she has filed a criminal case against me under section 498A of IPC.
Mr. Counsel.
Yes, my lords.
When you're filing a petition under 227.
Yes, my lords.
There should be an impugned order, or you're seeking a mandamus to the court for disposal of a petition.
Yes, ma'am.
Without an impugned order, how can you come before this court seeking stay of the proceedings of the trial court?
My lords, because she has filed a 498 case. Subsequent to that, she has filed an restitution of conjugal
What
right.
you should do then?
My lords.
You should go before the trial court. You should tell the court that such a petition is not maintainable, if it is.
My lords,
If it is open to say. But this court will not interfere.
we have told that, my lords, but they are not entertaining such matter.
You can't tell it. You have to file an application. They have to pass an order. That order will be assigned before the court.
Yes, my lords, but right now that
no.
If
That's not.
if the order
How
is
can the court exercise the jurisdiction? Why this case is numbered? Where is that? Let us see the prayer. Why the registry has numbered this? Issue a writ of certiorari and other writ like nature to quash the case pending before the senior civil judge.
Yes, my lords.
Under which law? Under which
We'll
provision?
withdraw this case and file a new suit after. We'll withdraw this case and file a new suit, my lords. So liberty may be granted.
Please come. The present writ petition is filed for seeking the following prayer. The petitioner has filed this petition under 227 of the Constitution of India. He is aggrieved by the initiation of the proceedings before the family court seeking restitution of conjugal rights.
Yes,
Seeking restitution of conjugal rights. It is submitted that when she has filed a petition under 498A against the husband, the relief of restitution of conjugal rights is not maintainable. Hence, a direction is sought to quash the case pending before the Senior Civil Judge and JMFC, Kolar, that is MC number 220 of 2023, and also sought stay of all further proceedings. The petition the prayer as sought and the petition as filed is not maintainable. The remedy that is available to the petitioner is not before this court, but before the trial court. Hence, this court do not find any reasons to entertain this petition, accordingly dismissed, giving liberty to the petitioner to avail the appropriate remedy. Yes.
Number 10, Vishweshwaraya.
I appear for petitioner in this matter. Lord, the impugned order is Millard's granting interim custody.
Where is the other side?
I have already served a copy on him.
On the council?
Yes, my lord.
Digant is?
Lord, your
When
lordship.
was it recorded?
My lord.
It's coming up for the first time.
Yes, my lord. Already there was office objection to
No,
serving.
who asked you to, it's a caveat.
Yes, yes. I already served on him.
Yes.
Already served.
Where is the copy served on them?
There
Where
is
is
an
the
acknowledgement.
endorsement?
There is an acknowledgement.
Uh,
And office objection is, my lords, I have complied.
Where is the impugned order?
My lords, impugned order is at page 16.
Page?
Page 16. 16. May I read it?
1 minute. Please read the operative portion.
IA number 2 filed by the petitioner under section 12 of.
You are for the mother or the father?
I am for the mother. IA number 2 filed by the petitioner under section 12 of the Guardians and Wards Act is hereby allowed in court. The petitioner is permitted to pick up the child from the house of the respondent at 8 a.m. on every second Saturday with him and drop the child at 6 p.m. on Sunday by keeping the child with him as overnight custody on Saturday. The petitioner is entitled for first 3 days interim custody during the Dasara vacation, Christmas vacation and summer vacation. The petitioner has to take care of the child and also.
What is the age of the child?
She is 5 years old.
When this JNWC is filed, 2025.
Yes, ma'am.
From how long they are living separately?
For the past 1 year, they are residing separately.
So there is the girl, then the girl was with the father.
No.
Not now.
Not now.
It's just a year. They're separated.
We have no objection for visitation. Right? Earlier, what the arrangement was, he used to visit the child every Friday and Saturday. For that, we have no objection for grant of visitation rights. Only apprehension is that having overnight custody.
What will happen?
The reason is this. There is already, there is already a 498A proceedings against the in-laws of the that is petitioner's in-laws. And there is an instance where the child was beaten by her grandmother. You have got the documents also. Let him take the child. We have no objection. And even he has filed a petition for restitution of conjugal rights. Let the mother accompany the child. Let him take the child from the morning till evening. Let them, both of them.
I don't understand what is the apprehension of the mother.
Apprehension is this.
Apprehension is because she has all that against the grandparent, that the child may get
not only
attached to the grandparents also is the mother's apprehension.
There is from the beginning, because she's a female child, from the day one, there are instances to show that the child was beaten. And if he comes,
then why are they filing JNWC according to you?
We have no objection for grant of visitation. Let him visit the child every day.
What is the distance between both the places?
10 kilometers. Let's let him come every day, visit the child. Because if he stays overnight, the reason is this, once he has taken the child to the hotel, and from there he sends message saying that I will commit suicide. These are some instances. There are so many instances like this. Let him have the custody from morning till evening. Let the mother also accompany, because he has already filed a petition for restitution of conjugal rights also. Let the mother accompany. Otherwise, there is
You
a very
have to
chance.
show some substantial reasons for that. What is the threat to the child from the father?
Threat is this. I have, there are messages, WhatsApp messages.
Show where are the messages?
Yes. Page number 66. He says that these in-laws, they have cheated him. I may just that my wife Shruti Mohan.
He's a doctor.
He's a doctor. He's a dentist. What happened was he requested to start a shop in the petitioner's house. He has constructed a shop as he was residing for some time. He had an eye on the entire property. For that.
Please show one message.
Yes, ma'am.
Which to convince the court that there is threat to the daughter. It is not good for her to stay with the father overnight.
Overnight is he will take the child to the he will take the child to the his house only. There is apprehension that the grandmother has beaten the child. Because the grandmother already beaten the child twice.
What from you say?
Yes,
please show.
I will show that. That's page number 66. He says that he had decided to take my life.
That I've seen.
Yes. Then I will just. Then page number 74, my lord. Page number 74. Lord, he says that he wants to see that the property is transferred into the name of this petitioner from the name of her father. I asked to transfer the property to your name. This is not dowry. He's having an. I have that also. There is an instance.
I'll take up the other matter in the meantime.
Yes, ma'am. Kindly have it for tomorrow. I will just highlight.
No, tomorrow. Pass over. Because tomorrow there are so many matters.
Number 11.
Day after, my I have got in some inconvenience afternoon.
Then we'll take it up on 21st of November. Yes.
Number 11.
Till such time, may I seek for.
Yes.
Shivashankar.
I'm appearing for the petitioner wife in this matter. There is an IA filed before the trial court family judge for interim monthly maintenance.
How much was granted?
50,000 was granted.
You're seeking enhancement.
We are seeking enhancement.
Notice to the respondent. The hand summons and shall file a memo to the, shall take hand summons on the council appearing for the respondent and shall file a memo to that effect. Once the memo is filed, this matter.
Number 12.
In this case, appear for the
Chandan.
petitioner. Is a case and connected case is there. The connected matter MC petition is pending before the mediation. The parties are negotiating. The case is posted on 18th December. After that, it may be posted. If they are not settled in the system, we'll go on with the merits of the case.
Yes.
Appearing for petitioner, my lord, as kindly page number 22.
He says that mediation talks are going on between the parties.
Yes, MC.
There is no
But-
any intimation has been made, my lord.
MC petition, that is, it was earlier, it was in Bangalore, and then the same has been transferred to Chitradurga and transfer petition by both the parties. Thereafterwards, now that it is pending for the,
Still, you can settle your MC. This direct petition is on the IA. Why it should be pending before this court?
this is with regard, they are negotiating now, they are in the mediation. Once if the case is settled in the mediation, ultimately entire things will be get withdrawn.
MC will be withdrawn.
Even this is a connected case, it's a family, husband and wife.
Fill up their applications. Why are we keeping it pending in the court?
That is the, because it is before the mediation, that's why I'm seeking the time till the 18th of
There
December.
are no
There-
instructions.
The December,
There is no instruction. my
here
lord.
it's
They have no-
there, my
Call
lord.
your
Here-
client and get instructions. Pass out. Yes, next.
Here it's there, my lord.
We'll find out, let her find out. Yes.
It's before the family court on 18th of December.
We'll see what it is. Yes, 11,
Pass over.
13.
13, Aki Manjunath Gowda.
This matter, my lord, is a wife petition. It's a impugned order, my lord, page number 31, annexure E, my lord.
31.
31, my lord. Annexure E. I'll come to point, page number 37, my lord.
Not
Reasons.
31. 31 is the MC petition.
No, it's impugned order, my lord.
Impugned order is not at 31.
Annexure E. Dated.
It starts at 40.
Sorry, my lord.
There are two numbers for this pages. Visible number is, operative portion is at 57. A petition is directed to pay monthly maintenance of 16,000 to the applicant respondent. That is 10,000 from the son.
Yes, my lord.
Yes.
My grievance is, my lord, the petition, husband is filed diverse petition, my lord. At the time of the assets and liabilities, my lord, his own accounts, my lord, this 10 months turnover is, my lord, 80 lakhs, my lord. Just 10
So
months
you are
turnover.
seeking enhancement.
Enhancement, my lord. One more thing, my lord, he is running a construction business, my lord. He sold 25 flats after pendency of the maintenance application. He is not disclosed before the court. Cross-examination, all documents.
Filed before this court.
Lord,
Have you filed those documents before this court?
my lord, cross-examination copies I'll
Make one
enclose, my
submission.
lord.
In this regard, I'll make one submission. What is only the trial court, I agree to that lordship, met only one year, 80 lakhs a turnover, which is in regard to the parents, my lord. And what he is saying is in regard to the construction business. In my objections, I have given my GST, parents GST certificate, wherein his parents are the owners. They have sold the flats. I am nothing to do it. I am doing the work of spiral binding, my lord. And my income is on 40,000. Based on that, and also I have produced the recent.
How many children are there for your parents?
My lord,
How many children?
children, one, my lord.
And they will keep everything to themselves,
My
not
lord?
giving to you.
My lord.
They are keeping everything to themselves, not giving to you.
No, I am the husband, my lord. I am the husband.
I understand. I'm asking about your parents.
My lord,
The only son.
no, he has a daughter. He has a daughter, sister, my lord. At the
Property is a joint family property or a self-acquired property?
self-acquired property, my lord. It's a self-acquired property by his father, and he has constructed it and he has sold those flats. In that regard, I am agreeing to that. And also I have produced this recent 2025 year bank statement, wherein he has no income because the spiral bending work is fluctuating. So that is also comes around 40,000. I have produced the statement of accounts also, my lord. In that regard, so hence the trial court, based on the assets and liabilities of 3 years, the trial court has considered 16,000. And I was and also I have mentioned the petition saying
What
that.
do you say? No, about that, according to him, it belongs to the parents. How do we construe that it is a joint family property and
Yes,
you
my
have to
lord.
share in it?
See, I'll pass on this. Cross-examination is admitted that is attesting witness and confirming party in the document. 25 documents is marked, my lord.
My lord, in that regard, I'll make a
My lord, I cross-examine, sir, 1 minute, sir.
In that regard, I'll make a submission. my lord.
Using two BMW car, my lord, is admitted that I am using this car, my lord, is a BMW car. One is in sister name, and another one is Audi car in the name of the father, my lord. All documents and cross-examination
They are
is
having it.
admitted.
That I agree, madam.
See,
They
10
are-
months
They
turnover
are
is, my
having
lord,
it. They are having it. We are agreeing to that. That is, it belongs to my father and my sister. And that is nothing to do with it. Whenever my father calls, I'll go and drive. It's not like even today. I'm taking my example, madam. Even I have driving the car. That is with my father. It doesn't mean that belongs to me.
Very interesting argument.
and he is
My lord,
disputing
and
paternity of the son, my lord.
As far as your comforts are concerned,
Well-
your father's comforts are all your comforts. When it comes to maintenance,
No, no,
only
ma'am.
what you earn is your.
No, my lord. I'm not comfort sometimes. I'm only going to drive because since he's aged on to 65 years, my lord. Only when he's going.
Are you a consenting party to this document?
My lord.
When the property does not belong to you,
Yes, my lord.
and it is the property of your father,
Yes, my
why are you a consenting party to all the
My lord,
sale
the
deeds?
thing is, my lord, nowadays what is happening is, whenever the sale deed happens, they are taking either you have to be a confirming party or a witness, so that tomorrow there should not be any shares. That is why he's made as a
What is
contesting
the averment in the
witness.
sale deed? Is it in English or Kannada?
Yes, it's in
English, my lord.
English only.
Then read the sale deed. Where is it?
But, so already the cross-examination 25 documents has been marked, my lord, after filing of this petition, my lord. See, I am not produced today. I have done day after tomorrow, my lord. I'll produce. And my lord, one more thing, my lord. Kindly see, my lord, photographs of the apartment. This apartment has been sold, and in the GST certificate, months very clearly mentioned name is in.
That I object, my lord. That is been tampered.
Cross-examination
That has
also
been
is
tampered.
admitted. Cross-examination. Jayant also.
What you do is that cross-examination is cross-examination.
Yes, my lord.
Please file a translated copy.
All is
It's
in
in
English,
English,
my
my
lord.
lord.
All is in
English,
English.
yes.
Yes, my lord. Already it's there, my lord.
Along with those documents, we'll have it on
My lord, one more thing, my lord. This
We'll have it
direction
on,
matter, my lord. Is
6th
that
of November.
My lord, one more
matter
submission.
is a direction matter, my lord. Till December, matter has been disposed, my lord. The trial court also insists.
Tomorrow you give
My
the
lord, one more.
papers. Court has no difficulty.
My lord, one more submission. I want to bring it to a notice, my lord. The lordship may see the conduct of the petitioner, my lord.
So we will also see your conduct.
Yes,
from
yes,
the
my
first
lord.
examination.
Yes,
Then we will
both-
see their
yes,
conduct.
yes, ma'am.
Yes, yes.
Number 14, Nagaraja.
Yes.
Or the respondent, my lord.
On the 17th, my lord, after my lord, everyday visitation, but for 1 week, the visitation went on every single day at my apartment complex. On 24th, my lord, a neighbor came and said that certain things were being told about my conduct and about our personal problems to him in the presence of the respondent and his parents. So from that day, my lord, visitation has stopped. Video call access is going on. May I make one? My lord, we have no objection to this daily visitation continuing, except my lord, let it now happen. There's a mall very close to my place because they're coming to my apartment complex and talking to my neighbors. It's making my, it's ruining my peace of mind.
Why your client is behaving like that?
The grandparents,
If
not the
I may
husband,
please be allowed to,
not the husband, not the in-laws.
Lord, the events that happened that day was the child was playing with, and one of the children who was playing with the child, their grandparent was also there. On 23rd, the visitation was curbed at 13 minutes. So a remark was made by the grandparents that we've received at least around 2 hours of visitation, but it's not being permitted. That is all, my lord. If restriction has to be placed on the grandparents that we should not engage with anybody else, we will do that, my lord. That is all that happened. There is no intention
No,
to.
the grandparents have to
They are-
realize that.
Yes,
No,
my
no,
lord.
that the court has passed an order.
Yes,
they
my
have to. And what is their business to talk with the neighbors?
I
Already
understand,
the
my-
relations are strained.
I
Why
understand,
they are
my
doing
lord.
it further?
I understand, my lord. It is only out of an emotion, because in that emotional state, when you have 1.5 hours of visitation, after the 13th minute when the child was taken away, out of emotions, the grandparents spoke that, my lord. But it is not after that. We've not, on the next day, there was an email where Charu informed us of what happened. On the next day, Lofty went alone. The respondent went alone. So we've spoken to the grandparents, we've made them understand. They're also in front of this honorable court. We've made them understand the seriousness of this and not to engage with anybody else except for the child and if required, Charu. We've made that really clear, my
What
lord.
is it you're suggesting, Mr.
Well,
Gordon?
my request is there is a mall right next to the about 5 minute drive from the house. Let the visitation happen there. And my lord, the petitioner has one. There are criminal proceedings pending between the parties. A 498 complaint has been filed where a FIR is registered. Therefore, there's some animosity between the parties. But the father has not seen the child for more than 2 years. Let the father come and meet. Let him first establish his bond with the child. My lord, the grandparents can come subsequently. Ultimately, my lord, the relationship of the child is first with the father. Let the father develop the bond. Once, my lord, the child is comfortable with the father, the grandparents can also come in. Three of them coming in together is creating, because they have, I understand, litigation is going on between the parties. They have their own emotions.
If it is father alone and he comes to the apartment, then there is no problem.
She says, "Mall, my lord, because of what's happened now, there's some embarrassment in the apartment complex."
Lord, one humble request would be, Lord, the grandparents, in light of the visitations that were granted, they have also come all the way down from Haryana and they're here now, my Lord. Even if this honorable court wants to limit their visitations, we're okay with it, my Lord. The father may be please permitted to visit the child, and grandparents may at least be given at least for a few days, my Lord, because they've come all the way from there just to see the child, my Lord. We've given them strict instructions not to engage with anybody else. Now, if the visitation will be taking place at a mall, the scope of that also does not arise. We are willing for any restriction being placed on us as far as engaging with anybody else is concerned. We just do not want these visitations to stop, my lord. And because on 24th, when we got the email, there was a request to pause the visitations. And it clearly details that the mother has fears that we will, on 20th, there was a conversation between the father and the mother. The mother detailed that she's afraid that we will take the child away. We are not looking to take the child away. We just want to meet the child. Grandparents have not come to take the child away. They have come because they also have not seen the child.
So only as far as that is concerned, the remaining things to be the
Lord,
same.
my request, let the father, my lord, father also has not seen the child for 2 years now almost. Let him develop a bond, my lord. The grandparents, I understand, grandparents also have a right to meet their grandchild. Let the father develop the bond first.
It is only with regard to what has transpired that day, with what they spoke with the
Yes.
neighbors. So nothing of that sort can happen in the
In a
mall.
mall.
So let them enjoy. Why should she? Because you have a right to restrict something.
My lord, I'm in your lordship's hands. My lord, your lordship suggested, I've agreed.
They have come. No, they're realizing that they did a mistake. If they do something which is not acceptable to the mother, we'll look into it further.
My lord, only one more request, my lord, that the visitation hours may please be kept, my lord, that it shouldn't be such that when we have 1.5 hours of visitation.
On the day of Diwali, that's over. On every day between 6 p.m. to 7:30 p.m.
Yes,
Your father can exercise the registration in the play area. If for any reason it's not convenient to spot, then the father can exercise the registration during the day time for 3
Yes.
hours, subject to the convenience of both the parties.
Yes.
So it is like 6 to 7:30 p.m.
If that needs to be taken a little ahead also, we're okay with it, because around that time, the child keeps saying that it's time to drink milk. So we understand 6 to 7:30 is a little too late for a 3-year-old child.
5 to 6.
We're okay with that, my lord. If 4:30 to 6 is also given, we're okay with it. 1.5 hours, my lord.
6 to 7, because she also will finish her work and she'll take the child and go to them.
6 to
7:30, as your
Lord,
lordship said.
Only submission is, we understand it's late and there might be difficulties because of that. That should not be held against
No,
us,
in a
my lord.
mall.
We'll come that time.
No. What she says is, even little early also, it's fine with them.
Yes.
Because the child will sleep early.
Yes.
So what they are saying is, instead of 6 to 7:30, what about 4 to 6:30?
Mother also is
Working.
working. That's the difficult.
So then we'll make it 5:30 to 7.
Obliged.
Half an hour. In case she is late, she will inform them.
Yes, we will be there. We will be present there, my lord. The only thing is, my lord, visitations may please not be paused like this, my lord, until the next date, at least if we get regular
Order,
visitation.
let her not take a decision and send an email.
We should have filed a memo, my lord. I understand. But if
On
anything happens, we will bring it to court.
17/10/2025, this court has passed an order permitting the father and the grandparents to exercise the registration. Today, when the matter came up, it is submitted with the land council appearing to the mother that when the father, along with the grandparents, came to the apartment for exercising the visitation, they spoke to the neighbors about the disputes between the parties, and also, what is that? They spoke the disputes about the.
Lord, they said that
about their personal disputes, not
about the personal disputes. They have they have disclosed it to the neighbors. As such, she sent an email to the father saying that it is not that she is not willing for the said arrangement in view of this disturbance.
Video calls every day were going on thereafter.
With
Every
the
day.
video calls, he was continuing with the video calls.
My Lord, just the direction, my Lord, on, like I said, on 20th, in that conversation with the child, when the child was also present, the mother started crying because I will instruct my client also not to engage with the mother also. The mother starts crying and the mother, that induces more fear in the child. The child also starts crying. We'll suggest that they only engage with the child. No need to have any other
Then counsel
interaction.
appearing for the respondent, father submits that as the mother has restricted to a 1.5 hours visitation to about 13 minutes. This led to the emotion from the grandparents, and it is submitted that they've already instructed the grandparents not to indulge in these kind of things. Things, and they will be adhering to the order of the court. In response to that, land counsel appearing for the mother submits that the mother is not comfortable in the exercising the visitation in her apartment in the light of what had transpired on the last visitation. There is a mall near to her house. What is that?
Sorry.
What is the mall?
PNR Felicity Mall. We'll communicate.
No,
PNR
There is a mall.
Felicity.
PNR Felicity
Mall.
Mall next to the house. I mean, which is 5 minutes away from the house. And the father can exercise the visitation there. Considering the same, this court is passing the following order. On every day between 5:30 to 7 p.m. the
Monday to
father-
Friday, my lord.
Huh?
Monday to Friday. that
Monday
was
to
it.
Friday, 5:30 to.
My Lord, this Saturday during the daytime, again, simply because the father is also on leave on
5:30
those
to
days.
7, 5:30 to 7, the father can exercise a visitation in that mall name,
Play area. Yes.
in that mall.
Play area.
And if at all there is, if mother is getting delayed or any other change in the timings, in advance, she would intimate to the father, and the same, the father should also do the same. Next, number 2, on Saturday, the father can exercise the visitation for 3 hours, subject to the convenience of both the parties. Next point, both the parties shall ensure that the visitation goes on smoothly without giving any kind of inconvenience to the boy. The grandparents can also meet the child, and it is made it clear that any kind of the grandparents shall only their endeavor shall be to meet the child and develop the bonding, and they shall not discuss anything with regard to the disputes between the parties or anything to with the child or anybody or anyone around. Let's just matter. And what about the money as he paid?
Yes, my
Yes,
Lord.
paid.
On that day itself, it has been
Shall be
paid.
same by 5th of every succeeding
Yes, my
month.
Lord. 5th of every
It
month.
is the arrangement with regard to the monthly maintenance shall continue. Let's just matter. We'll have now we'll give a month's time.
15th December.
Let's just matter on 15th December.
My Lord,
And in between anything.
We will
only by
bring it,
way of
we'll
an
we'll bring it to the
not
court's notice.
abruptly.
Yes, yes.
Yes.
Obliged.
obliged.
15, Rashmi Judge.
Yes.
Your Lordship,
Respondent by me.
there is an order of the trial court.
Respondent may be permitted to place the objections before this lordship if you're on.
Yes.
The Lordship, we had filed our application for the modification for the visitation rights in the lower court, because there was an order of this honorable court on 16/6, wherein in page number 122, Your Lordship.
I think I remember this matter.
Yes, Your Lordship. What happened?
Now, this request of the mother will not at all be considered. And if any restrictions on the father, will impose the restrictions.
Your
But
Lordship.
not
Your-
No,
Your
when the
Lordship-
custody was shifted from mother to the father, I mean, from father to the mother, this court has affirmed the order.
Your Lordship, it is a new event that has happened, because there is a
No,
liberty
because you
given to
have
the
the
lower court.
advantage of an order, now all the new things will come.
Your lordship, there is a liberty given by this honorable court itself to the family court. Because of that, the order was passed.
Considering it now, why should we change?
Because there is
those,
an order of the lower court. Here, the court has clearly mentioned that because I don't have the powers to change the existing visitation rights, your lordship.
Now I'm considering it. Why it should be changed?
Yes, your lordship, because the father is continuously talking ill of the mother, and the audio recordings along with the transcripts have been produced in the lower court. The lower court has clearly mentioned in the order on page number 38.
Why is the father doing all that?
No, please, your lordship, he has never been doing it. It is only the advantage what they are trying to take by taking undue advantage of the loopholes available under the order, please, your lordships. Here, the father has been trying to execute the order to see the child and trying to pick up the child. And it is the mother who is making all attempts on every Fridays to ensure that the child is not sent to the school in this number of weeks, please, your lordship, where the father had to pick up the child. She had ensured that one or the other reason the child is not sent to the school. Once fever ant heltare, once infection ant heltare. Other time she sends the child to the school and picks up the child at 10 a.m. And other times she says that it is her star birthday and she wants the child to be with her, and she ensures that the child is not allowed with the father. And further, please, your lordship, in the WhatsApp communication she writes, there is a court commissioner appointed in this matter, wherein to ensure that the child is picked up by the father and the child is dropped by the father.
Why should there be a court commissioner for
Your lordship,
Because there were instances wherein the child was not sent to the school intentionally on Friday so that the child should not be picked by the father. So an application came to be filed by the respondent claiming that, the police assistance should be given to enforce the order of the court.
Can I make some submissions?
No, we will review that order.
Your lordship.
That order passed by this court where the
Your lordship, what happened to
custody
us?
is affirmed.
Can I make 2 minutes submission,
Yes.
your lordship? Because he was telling that, citing that there is a reason for everything. They were not sending the child. In page number
How can you
147.
take a unilateral decision of not sending the child?
No, your lordship. I am saying that we didn't take any decision. In page number 142, she is sending a
Have you
WhatsApp
complied
message.
with the order? Have you been complying
Your
with the
lord,
order?
I'm only telling and answering to what they said because
No,
on
please tell the
17/7.
court, have you been complying with the order?
No, the
that's
child
passed?
was not there in the school and the child was in the hospital, and the father is seeking permission to come and visit the child in the hospital. And in page number 142, we are sending the hospital location along with the message. Advaiti is not going to school. If they still want to pick up, they can come in home and pick and kuda kalsideni. So we have sent that also. Let him come home and pick the child. He can. The child is at home and he wants to come to the hospital and check. We are sending the hospital location on page number 142.
No,
It is there, your lordship.
It appears that the parties are, because they can come to the court, they can engage the advocates, they can fight. This is all the frivolous petitions that are being filed.
Your lordship,
One after the
again
other.
on 18th, they are going to the police station citing
Like
that.
both the parties, don't they have any responsibility towards the kid? Why are they indulging
Your
in
lordship,
all
we
this?
have complied the order the best, how much ever possible we have
When is the order
complied.
passed? No. Let's
It is
see.
on 16/6.
1 minute.
It
When
is
is the
on
order
16.
of this court?
16/6, your lordship.
From 16/6/2025, how many times you have sent the child to the father?
Almost every occasion except 4 occasions. Because 2 occasions we have mailed them, July 17th and 4/7. The hospital records have been kept
No,
in
you can
this.
give the dates. So you are, according to you, from 16/6/2025.
4/7, 17/7.
What is that, July?
July 4/7.
July 4th.
4th. And then 17/7, July 17th. These are the 2 occasions. The child was sick and he was told to come to the hospital and see the child also.
So according to you, apart from these 2 days, you have been complying with
No,
the order.
your lordship, there are 2 more days. There
What
are
are the
2
days?
more.
What are the days?
19/9 is one day.
19th
19/9.
September.
Yes, your lordship,
Oh.
September 99. And if I'm correct, 1/8. Your
As per
lordship.
the order, every weekend, the child has to be with the father,
Yes, your lordship.
isn't it?
Yes, your lordship.
So,
Here.
1, 2, 3, 4. 4 weekends you have not
Your
complied
lordship,
with.
your lordship, here 2 days, the child was sick, he is coming, visiting the child in the hospital. She is asking him to take the child. He is not taking the child. He is finding that the child is sick and he is going back. And then he is going to the police station and filing one complaint. What is the purpose of that? And then on 9/9.
Please, both of you has to ask yourself, what is the purpose of it? What is this Harassment to the
We
child?
never went to any police
Harassment to
station,
the
your
court.
lordship. He went even to the extent of filing a POCSO case to get the custody of the child. We never went to the police station and did anything to him. He is only trying to file maximum number of cases and trying to do this. But now in the lower court, your lordship, lower court passed an order citing that in page number 43, lower court perused all the documents and the lower court says that from the above clauses 2 and 7 in the order of the Honorable High Court, it is clear that in case of any violation above order regarding ill speaking of other parent is brought to the notice of this court, then this court shall pass appropriate orders, but without altering the existing arrangement. Hence, both the parties and respondents shall have to comply the order of visitation, because the lower court only during my argument said that we cannot pass. How much ever grievance you have also, because I'm not given the liberty. Because the video, the pen drive
That
clearly
submission-
shows that, because
that submission I've
he wants to
understood.
create some.
Now, why should we alter the order? That's
Your
all.
lordship, he is trying to create the false, saying that the mother will run away with somebody. And in the video footage I have filed in the lower court, the child is taking the name of one person and closing the door when mother is about to leave for the office and saying that you go and you will run away with, my father has said that. He is taking the name of that person. That video I have produced in the lower court. Lower court has perused it, but saying me that we cannot do anything since there is an order of the Honorable High Court. And likewise, on the last visitation date also, the child is, while taking the shower, the child is telling that because you have lot of boyfriends in the office, my father is telling that you are coming home late. Is it true? So here the child is getting a false image about the mother, that the mother is with men. This is what the father is trying to do.
It is false statement, please your lordship. It's just an advantage what they are trying to take by the order of this court, please your lordship.
Client should also some sense should prevail on him to talk these kind of things with the child.
Not at all, please
Why
your
would
lordship.
he
There is no
talk? Why
reason.
would the child of his age would be talking all this?
It is their claim, please your lordships. In fact, they have also filed an application for contempt. In fact, I have also made an application for disobeying the order.
Or what is the material in support of these allegations?
The video footage, I actually produced the same pen drive in the Honorable High Court also, but the registry asked me to remove it. And I have produced the transcripts of the same in page number 150, your lordship.
I think this is the last opportunity to your client, Mr.
Certain, please your lordship.
Last opportunity to your client. Then what we'll do is we will alter that order passed earlier where the visitation is given. We'll also curtail that visitation to the client.
My client is
Because
ready
we
to
have to
file an
understand
affidavit before the court that he has not made any comments about the character
There
of the
is a
mother
pen
before
drive.
the child, please your lordship.
I'm ready to bring
The
it.
child is in the custody of the mother.
Bring it in
It
my
is the-
iPad and show it in the.
To the court.
It is the
Your
tampered child. Please,
Let
please.
me
Your
let me
lordship.
interact with the child. If
Please,
he
your
says so, I will alter that earlier order.
Certainly, please your
And
lordship.
we'll say that he is not entitled for in the visitation of the child also because he doesn't know how to behave with the child. That I will.
Your
that-
lordship,
that
there
Please, your
is
lordship, the
there
child
is
may
a
be
court
kept present before the
commissioner,
court.
your lordship, there is a court commissioner
And
report
counsel
also, your
appearing for
lordship.
the petitioner submits that this court has passed an order whereby the order passed by the trial court affirm the granting custody to the mother has been affirmed. And this court has passed an order granting weekend visitation to the father. It is submitted that the father, while the child is with the father, he is feeding the child with unnecessary things and also making allegations against the like he's assassinating the character of the mother. And when the child comes, he's questioning the mother that his father has said these things about her. It is submitted by the mother that these are not in the interest of the child, and father cannot pollute the child with these things as he has grudge against the mother. When counsel appearing for the respondent father submits that he has not spoken anything of that nature, assassinating the character of the mother before the child, and only to avoid the order that's passed by this court and to grant visitation to the visitation oblique interim custody to the father. The mother is coming up with these allegations. This is matter on 12th November in the chambers at 5 p.m. And the girl,
Your lordship,
the boy
Right
should
to
be
add up
present.
a
your
statement,
lordship,
please,
on
your
humble
lordship.
submission.
The mother, having filed this petition, please your lordship, and even filing the application before the lower court, has ensured that the child was not given to the father, claiming that the application is pending and the child will
This
not
is
be given.
matter on 12.
Your
The
lordship,
chambers at
one,
5.
one humble submission.
What is humble submission when without hearing the child, I will not be passing any order?
Because
Yes.
again, then this week, we will have to send the child and he is feeding the same thing to the child, your lordship. Kindly, the visitation may be continued after the interaction with the child. That is my humble
In that
submission.
case, this is matter on 5th.
Please, Your Lordship.
Much.
Yes.
16 parted matters. Krishnamurthy D.
What happened?
I pay for petitions. So earlier order is, well, as of now, they are living together, my lords, with some issues.
I think they have to understand that they have to settle their issues.
Correct.
The entire world will not be, worried about their problem.
Correct.
There should be some, effort
Both
from
of
their
them
side.
have to behave like a responsible
That's
citizen.
what, that's what. And it's not, marriage is not about imposing conditions on each other.
Correct.
You don't talk to your sister. You say, how is it possible? How can anybody say, don't talk to your parents, don't talk to your sister? And we
Yes.
can't compel them to live like this.
Please, Manoj, but,
Understand
yes.
that. I
But
told him
since,
the other day also.
yes,
And
But-
it is like, you're not like, doing any favor to the other person by residing together.
please.
You can't
Manoj, but
compel
yes.
you can't, everyone has their own, it is though they're living together, doesn't mean that the one will be the wife or the husband will be living or playing to the tunes of the other.
Please, Manoj, but for now, more or less, the arrangement is going fine. There are some issues. They may be just given some time to address these issues.
That is
So
what I can understand is the husband is more rigid on this. Husband is more rigid on the aspect. She has only one issue, and he also has only one point of agenda, that something has been done by the sisters and the father. So she shouldn't. Why should she? Why will she? Because after all, there are a family.
Please, Manoj, it's not just so simple because I think they're interfering a lot on all matters.
Only about was
Yes.
which he is not forgetting it.
Please, Manoj, even now.
Nothing is
appar-
happening
yes.
now. Nothing is happening
Yes,
now.
but then they are speaking to her in a way saying, do this with your husband, don't do this with your husband. Financial matters also, they are very, very, at the level is very, very.
Now the financial matters are
yes.
not with, they're living their own life. They're managing their own finances. Now the situation has not come. He's only talking about what has transpired about 2 years or 3 years back.
Please, Manoj, but as of now, since it is actually progressing, okay, it's at status quo level. So if it's since the order of 19, so if my lords can just
No,
extend it till
I'm-
December.
That's
Yes.
what I'm saying. I'll extend it. I'll take up this matter on December 17th.
Please.
And I'll have an
Yes.
interaction on that day. If the same thing continues and
Yes.
they are not even, if he's not taking, making any effort to compromise with this, then the court has no other go, but we will pass orders on the merits of it.
All right.
Yes. Let's just matter on
Well, in the
17th of
meantime, if
December in
one-
the chambers
Yes.
at 5 PM on the earlier arrangement that is made between the parties.
By the order of the 1st of September. And if one of my submissions can be
First
recorded.
1/9/2025 shall continue.
Please, well, just a submission of mine can be recorded that I'm seeking that parties discuss even relocation during this time. Relocation meaning shifting from where they are currently staying.
The problem is, unless and until the lady is convinced that I'm going to live with him, why would she relocate? That's a simple issue.
That we can consider on the next day, then at least that interference by her sisters may be minimal.
That I will not pass any order. First of all, let him come out of it. And lifelong, nobody will monitor that, whether the sisters are interfering or not. If that is, that she's not going to change. Her sisters will be there in her life. If it is acceptable to him, let him live. If it is not, let him leave it. Because nobody can compel a lady saying that don't speak to, when from the last 2-3 years when they are staying separately, they are the one who are with her.
Please. Well, there's no problem with talking, just the interference. But anyway, they will try their best till the next date. Yes.
No relation can go forward with restrictions. It can only go with understanding. That you please make your client understand. Otherwise, he can only, he has to face the consequences of it. Yes, next.
And
this is matter on that day. On that day, the party shall be before the court in the chambers at 5 PM. Yes, next.
List number 2, serial number 1 for dismissal.
For the respondent bank.
For the petitioner, my apologies for the non-appearance on the previous day.
Yes.
Lords, I may be permitted to withdraw the petition, Lord, and I may be permitted to withdraw the petition and avail my remedies before the DRT.
Whatever you want, but I will not grant any, it's in accordance with law.
Please, please.
Lord,
In accordance with law.
please, because
Have
interim
they
order is not.
deposited 10% of the amount?
No, my lord, interim order is not
Interim order has
compliant.
been
It may be
complied.
recorded, my
My
lord.
lords,
Present writ petition is filed.
Lords, may I make one submission? Interim order has been complied.
No, no,
Is it not compliant?
no, my lord.
It's complied.
Where is the,
Lords, the receipts, my lords, you could not
I will
supply, but I
record
have
both the,
asking for the
both
statement.
submissions.
Please,
then.
please, please.
The present writ petition is filed, seeking the following prayer,
At page 13, please.
seeking the following prayer. When the matter has come up for hearing, a coordinate bench of this court on 8/4/2024 has granted stay on the condition that the petitioner shall deposit 20% of the amount. What is outstanding?
Lord, Lord, as on the date of filing, my lord, it was around 21 lakhs, my lord.
10% of the amount within 3 weeks. And the remaining 10% within 3 weeks from thereafter. The counsel appearing for the petition submits that he wants to avail the alternative remedy and he may be permitted to withdraw the writ petition. According to as per his instruction, the interim order is complied with. Next paragraph. Land counsel appearing for the respondent bank submits that interim order is not compliant with. In toto or not at all?
Partly it was complied.
He submitted that the interim order is partly complied with. Considering the submission, the petitioner wants to avail the alternative remedy. The writ petition is dismissed, giving liberty to the petitioner to avail the appropriate remedy in accordance with the law.
Please, oblige.
Writ to me.
Number 2, Annaya.
Petitioner is withdrawn, ma'am. The matter is settled.
Where is the order sheet? Memo is filed, seeking to withdraw the writ petition as not pressed. Accordingly, petition is dismissed as withdrawn.
3, V. Mohan.
Memo is taken on file. Yes,
For the respondent bank.
Borrower's petition before this honorable court. Pendency of the petition, we have cleared the entire loan amount.
pending the pending petition.
Borrower's petition.
No, I understand you were saying during the pendency of the petition.
Pendency of the writ petition, I cleared the entire loan amount.
Hmm.
But during the pendency of the petition, one more thing happened is the auction proceedings. There's an interim order by this honorable court not to confirm the auction. And before this honorable court on 2 grounds, my lord. First one is these are all agricultural properties. They have filed their statement of objection. They have not denied that these are agricultural properties. Hence comes outside the purview of Surprise Act. Proceedings could not have been initiated under the Surprise Act. Second ground is, my lord, the property worth 7 crores. I produced the guidance value before this honorable court, was sought to be auctioned at a rate at 1 crore 60 lakhs.
Lords, I am for the auction purchaser. I filed impleading application, my lords.
Lord, I am for the respondent bank. My lord, it's an NPA of 2016, my lord. And my lord, the auction, my lord, has been conducted in December 2024. My lord, auction purchaser, my lord, has deposited the entire amount. But my lord, sale certificate is not registered because there's an interim order operating in this matter, my lord. During the pendency of this writ petition, my lord, the petitioner has also deposited the full loan amount, my lord. Full outstanding has been deposited. My lord, in such scenario, my lord, your lordship may kindly see, my lord, the latest judgment of the division bench of this honorable court. Because, my lord, there is a legal bar under section 13(8), my lord. Once, my lord, an auction notice has been published, which happened.
Allah, they're not answering the first point, my lord. Provisions of Surprise Act is not married.
No. When the surface proceedings were initiated?
Lord, 2016. 16. That's the date of the NPA, my lord.
May I read one section before they start?
No. Before that, you please answer to the court. 13(2) notice was issued to you.
Yes.
When?
13(2) notice. I'm sorry, my lord, I don't have the exact dates of.
So must be in the year 2016.
Yes, my lord.
13.2 will follow
Yes.
first. So have you submitted your objections stating that this is a agriculture land and it cannot be, it can't be part of the surface proceeding?
In the first instance, my lord, I'll have to secure instruction to that extent. my lord,
No,
because-
so, no.
Yes.
From 2016, this writ petition is filed in the year 2024.
2024.
Then possession notice must have been issued in which year, 13.4?
Lord, 13 for physical possession is taken on 19/10/2024. 19/10/2024.
That time he came here.
No, my lord, auction
Auction
notice
notification
is
was
issued on 2/12/2024. my lord.
2/12/2024. When
It
is the
is-
interim order by this court?
My lord, interim order, my lord, is granted on
First interim order was on, my lord, 31/12/2024.
31/12/2020.
Subsequent interim order was on 19/2/2025.
No, if that's the case that it is a agriculture land,
Yes.
what are you doing from 2016?
Lord, it was our case, my lord, that we were not notified. I'm an illiterate. My lord, regarding those proceedings, I have to secure instructions, my lord, prima facie. Lord, he's an man aged 62 years and he's an illiterate. He's an agriculturist. Lord, on the face of it, I produced
Lord,
documents.
may I make one submission, my lord?
That it's an agriculture land?
No, my lord, it's a
They do
coffee
not-
estate, my lord. My lord,
State is not.
No, with the
Lord,
leave of
may I
the court,
make
with the
one
leave of the court,
submission,
my
my
lord, I've taken it specifically that these are agriculture lands. I produced the RTCs to show that these are agriculture lands.
Please tell the court.
They have not,
Forget about what they are saying.
in writing, they do not
No,
deny it.
Forget about what they are
Please.
saying. I'm asking you.
Yes.
Is it a coffee estate or not?
It's not a plantation crop, my lord, it's an agriculture land. I
But
produced
these are all-
RTC to show that it's an agriculture land.
Let's see your sale deed.
my lord, may I make one submission, my lord?
It's an
My lord,
ancestral
First
property.
aspect is, my lord, under 13(8) there is a bar. The second aspect, my lord, these are all factual aspects, my lord, which has to be decided before the
But you know
DRT.
what bank bona fides in all these cases are? When the property, as per the registrar value, when
Please.
it is 9 crores, why do you send it for,
No,
send
my
it
lord,
for 1 crore?
my lord, it's an abandoned coffee estate. It is totally not maintained. It is not maintained. We have obtained the valuation report. The valuation report, my lord, has given this,
Valuation report
because
will
we have to
suit.
go by the valuation report, my lord.
Guidance
We have
values.
taken the valuation report. As per that, my lord, we have conducted the sale. My only submission is, my lord, insofar as these aspects, whether it's an agriculture property or it's a coffee estate, it's a factual aspect, which, my lord, the DRT has to look into. The division bench says so, my lord. Your lordship may kindly see the division bench judgment.
Unfortunately, whatever the division bench says, but all petitions are entertained and they have been
My lord,
enjoying
the-
the interim order for 1.5 years.
My lord, we, in this
It is
matter, my
because
lord,
of
in
section
fact, in
31,
this
my
matter,
lord.
my lord, one submission in this matter, we had challenged the interim order also before the division bench. The division bench has categorically stated that as there is an interim order and the matter is pending before the single judge, there is a direction for the then single judge to dispose
No,
of.
no, that we will
Please.
dispose of. But what is, like from the last 1.5 year, they are enjoying this stay.
Please,
And now again
my lord, we have
relegating the
been,
parties to the DRT.
my lord, we have been moving the matter. It has been heard couple of occasions also. My lord, one more aspect is, my lord, how he has deposited this amount, my lord, during pendency of this writ petition is, my lord, there was another property which he had mortgaged with Canara Bank.
One more thing, all the banks are sticking to the point that once a sale notice is issued,
Please.
question of redemption will not arise.
Please.
But that's not so.
My lord, under 13(8),
You
I'll just
blow,
show.
like, according to you, in one case it is possible, in other case it is not possible.
My lord,
There is
but
no,
13(8),
there
my
is
lord.
no rule, no, even those rules also.
Please.
It's all according, you people feel that you only made, you can only,
No, my
like,
lord,
do
the
whatever you want to.
my lord, 13(8) has been amended recently, my lord. It was earlier, it was not this
I'm
case.
talking about the recent cases. I'm looking
Please.
at it from the last 1 week.
Please.
That's what I'm saying. In one case, it is possible, you will redeem the mortgage.
Illa.
You will say, in the other case, you will say something else. So rules are not, not for the bank.
Please.
It can be applied against the
Please.
only the borrower.
Please. Lord, may I
So
just,
first of all, how do you come out of that, the judgment of the Supreme Court and the fact that once the auction notice is issued, the redemption of, the right to redemption, you will lose the right.
May I read section 31, my lord, of the Surface Act? My lord, this was not considered by the judgments of the Honorable Supreme Court. I'm not very sure, my lord.
Not the division bench, there is a Supreme Court judgment also.
No, my lord, regarding 31, no, it is not there.
No, it is there. Recent judgment of the Supreme Court is
please,
also
Lord,
there.
following the decision of the Honorable Apex Court only, division bench, my
That's
lord,
what-
on 16th
I pray for
September
a days of
2025.
accommodation, my lord.
Yes,
Tomorrow.
please look at it.
Please.
So at least what I'm saying is,
Please.
banks and the borrowers and and the court, let all of us be in one pace.
Please, my lord.
Not like, for one client, one order.
I understand.
So for everybody, auction notice is issued, your right to redeem the mortgage is completely lost.
Provided the auction notification is issued in accordance with law. If the Surprise Act is not applicable, my lord, they cannot.
But for that, if you
They
have to say there's some lacuna in issuing the sale notice or something, then the remedy is before the DRT. All these factual
No,
aspects
there,
have to be discussed, have to be considered by the DRT. Why should this court interfere?
I'll look into this judgment and.
Please look
I
at
may
it.
pray for one more day's extra time, my lord, day after tomorrow.
Yes, this is the after
Day after
tomorrow.
tomorrow, I have some difficulty. It can be on Thursday, my lord.
Yes,
There's a
Thursday.
family function.
And from the next week, or the DRT matters are only on Monday and Tuesday.
Please.
No other dates.
Please.
Thursday, this is matter on Thursday.
My lords, my
And the
application may be
request-
considered.
Huh?
My application may be considered, my lord.
IA number
3 of 20.
3 of 2025 is filed by the auction purchaser. It is submitted that he is a proper and necessary party to this writ petition. Accordingly, I number 3 of 2025 is ordered.
Grateful, my lord.
Please.
Must interim order has to be considered.
Interim order earlier granted is extended till the next date of hearing.
Much.
Yes.
Number 4, Yagade Veena.
My lord, appearing for respondent number 3, we will undertake to file a Vakalatan next date, my lord. We have got copy by petitioner only,
For
my lord.
you,
Respondent number 3, my lord.
3 is who?
Husband of the petitioner.
Husband of the petitioner, my lord.
The loan is standing in his name. I'm a co-applicant. Lord, it is a flat. Now, my lord, he is residing outside and he is not paying the, my lord, EMIs. Out of that, my lord, it has been declared as a NPS. Now, my lord, they have taken, my lord, sales certificate. That has been questioned before my lordship.
So what is
My lord,
wrong
we
with
have,
I'm not saying any wrong, my lord. The dispute is going there. Therefore, I
So
saw.
both of you have to settle the dispute, number
That is
one.
what, that is what I.
Bank has every right to proceed
Definitely.
against both of you.
Definitely, I'm not on that way. I just made, last time at taking stay, my lord, submitted that I'm residing there with my daughter, who is, my lord, going college, and she should not get, my lord, any kind of, my lord, mental harassment, my lord. I sought, my lord, time. Now, my lord, if the matter settled between me and, my lord, my husband, I'm ready to pay the entire amount in one-time settlement, which, my lord, I requested my learned friend is also not having any objection.
No, my
Because
lord,
his
I'm
only aim is that getting money. And, my lord, therefore, my lord,
Property belongs to whom?
property is standing in the name of my husband. I'm a co-applicant. I have, my lord, paid some of the, my lord, 17 lakh around, my lord, I paid to him. I'm not totally on that. My only concern is that, my lord.
No, when the property stands in his name,
Yes, my lord.
when if the amount is paid,
Yes,
property will be released to him.
that is the whole thing what we have to settle, my lord. We are
And
settling.
which the court cannot help it.
My lord, that is property, my lord, where I am and my daughter is residing.
How the courts can
My lord,
help
what
it?
my lord, my client instructed me that, my lord, if anything, whatever the family dispute is also going there, if that has been settled between me and respondent number 3, the amount whatever I'm receiving, adding some more amount, my lord, I'll pay entire amount to the, my lord, bank. And I'll get that property, I'll save that property in my name or in my daughter's name,
Unfortunately,
or
we
at
can
least in my
do
daughter.
justice within the legal framework. And what are all these reliefs that are sought before this court are beyond the powers of this court?
I do admit, I'm just seeking a proper jurisdiction from this
No,
honorable.
it's not
court.
that. Court, if at all it is permissible, court will definitely consider. Because we talk about a secured creditor, an act, Surface Act, and some wife and husband come to the court and say, you please stall those proceedings, how can we do it?
That is what I'm seeking, my lord, request, my lord.
Because
my
we cannot
learned friend.
settle your disputes here.
No,
First of all, we can't stop the bank from proceeding. That's the first problem here. And if you can settle, like if you say a month, we can understand. Eternally, we can't wait for you
I
people.
request one more time, I'll try to make out. If it is not, my lord, I'll give up my hopes from this property. I'll make some other arrangement.
When is the interim order passed in this case?
There is no interim order passed as what my learned friend is submitting. The matter was last listed on 25/9.
They shall, where is that?
25/9.
Hmm.
That was the date it was listed. The direction was that the submission was noted that
Then also the first respondent submits the petitioner will have to pay
some
some
20
rupees
20
and
lakhs
other
if they
charges,
pay.
that if the petitioner could tender this amount within
That's it.
reasonable time, Treasury to his case will consider the request for tender and regularization.
That is the only order. There is no interim order as such, which they have not come forward to regularize the loan. They have to pay 20 lakhs, which they have not done so far. They're only bringing up the reason of a husband and wife fight.
How will you ensure that she retains in the property? That is not in your hands.
He's residing in the property.
Huh? No, no, no.
Please, my lord.
She is residing.
Please, my lord.
Entire amount is paid. Ultimately, the property belongs to him.
They have
There are
to,
disputes between them.
yes, my lord.
Now, by paying all this amount, can the bank ensure that she retains a portion of the property?
My lord, that is not the anyway concern of the bank at all.
Exactly,
Only thing
that's
is,
what it is.
the submission was, on the last occasion was, what was made was, they are making some arrangements internally. That is left for them to work it out.
What are your instructions?
Oh, my lord, our senior will engage the next date. We got copy only from the petitioner side. Still, we have to file the wakalat with the respondent number 3, my lord.
But the entire challenge is to section 14 order passed by the honorable magistrate, which of course, my lord, the respondent number 2 also will not have any say in the matter. It's only that the legality of the section 14, they can only very well challenge before, under section 17 before the honorable DRT. So the petition doesn't survive. And one more submission, my lord. Previously also they filed one more, the same petitioner had filed another writ petition wherein she has obtained an interim order saying that they're going to deposit on 25% of the loan amount. Till today they have not come. Writ petition number, my lord, it's WP 29441 of 2024. The
Pending.
interim order was passed on 5/12/2024. It's pending. And they have not even.
Give that number. Mrs. Matter along with that tomorrow.
Please.
May I request one more time so that I'll settle it.
So that order also is not been complied so.
Tomorrow.
Please.
Both the matter.
Number 5, K.S. Pannappa.
I may be permitted to withdraw the first matter, my lord, that is 31903 of 2025.
Why?
My lord, appearing for the respondent, my lords, I have no objection for the withdrawal, my lords, but the
For the bank.
please, my lords, I have.
First one.
I am yet to file my wakalat and objections, my lords. They are ready, my lords. If I am permitted, I may file it, my lords, in the court.
Which one?
31903.
You want to file objections when you also.
My lords, why? Because, my lords, I want the conduct of the petitioner to be recorded, my lords.
So let's
In
see.
that,
1 minute.
please, my lords.
2510. What is this petition about?
My lords, what has happened, my lords?
I
The
may be
petitioner
permitted to
has.
submit, my lords.
Hmm.
All these petitions are connected.
No,
They,
first we are talking about the first writ petition, which you want
Yes,
to
ma'am.
withdraw.
the reason I'm withdrawing is, my lords, because they put out the auction now. They called off the auction. And that is why I'm withdrawing this writ petition,
What
because
is
it
the
has
relief that is sought? Please come to the.
I've asked for quashing of the auction notice for the simple reason, my lords, the bank, I have filed an application under section 94 of the IBC code. And similarly, other banks have also filed proceedings against me under section 95 of the IBC code. The minute a petition is filed under either section 94 or 95 of the IBC code, there is an automatic stay under 96 of the code, because of which they can't take any precipitative action unless my petition is heard and admitted by the NCLT. During this time, because they proceeded with an auction, I rushed to this court asking for stay of the auction for the simple reason because they could not proceed against it.
Then what was the earlier writ petition?
My lords, certainly, my lords, they have filed
Earlier,
the
I have not
section
filed
90.
any writ petition.
No, what is this writ petition? 31966.
31966 is with respect to another guarantor with respect to the same debt with respect to a different bank, my lords.
DRT order will not
What is questioned in that?
There, my lords, there is an order of the DRT where the DRT has asked one respondent number 2 bank to pay the rent that is payable to the petitioner to be paid to respondent number 1 bank.
Please give your objections, pass on the objections in
Please,
the
my
first
lords.
matter.
My lords, certainly, my lords, he may withdraw the petition, my lords. But however, my lords, despite filing of the 94 petition and section 95 petition filed by the Canara Bank, he has not intimated, my lords. Even we have issued 13-2 notice, we have taken the symbolic.
Paragraphs you're referring to.
My lords, paragraph, kindly page number 10, my lords.
Give him a copy
Of
of
my,
it.
I
received
have
a
already
copy.
served, my
Where
lords.
is it?
I've received.
Page number 10, my lords. Para number 25, my lords. Where I have submitted that, I have issued the demand notice, my lords, under 13-2 of the surface, my lords.
Where are you reading? The
Please, my
bank
lords.
issued
It is
a demand
submitted
notice.
that in spite of repeated requests, reminders and pleadings, the petitioner had failed to make repayment of his liabilities. Consequently, the bank had issued a demand notice on 25/10/2024 under section 32 of the Surface Act, calling upon the borrower and the petitioner as personal guarantor to make the payment of outstanding amount of rupees 7 crore 3 lakhs 71,371 rupees 0.76 paisa. Subsequently, my lords, I have issued the possession notice and symbolic possession is also being taken, my lords. Even then, my lords, the petitioner has not intimated, my lords. When I have issued the sale notice on 4/10, on 15/10, as referred in page number 40 of his writ petition, he has also produced, my lords. He has communicated the same to the respondent stating that I have filed application under 94 and your
When he filed the application under 94?
my lords, I am not a party to that application. My lord.
When was it
My
according
lords,
to him?
my lords, my
26, my
para
lords.
12, para
What was
12
the
of the
date?
26/6, 2024, my lords.
20?
24,
26?
6, 2024.
When were the surfacer proceedings were initiated?
My lords, it was initiated on 25/10/2024.
When was the notice issued to him under 13(2)?
On 25/10 itself, my lords.
He has submitted his objections to that?
My lords, no, my lords. He has not made any communication with respect to that. He has not raised any objection towards the demand notice or possession notice. Only after 2 weeks of us sending the sale notice, that is on 4/10/2025, on 15/10 he has communicated to us that section 94 has been filed and we have received the interim order. Moratorium, my lords. Apologies.
So the first time bank came to know about it on 15/10/2025.
Please, my lords.
What happened to the sale? Why the sale couldn't take place?
My lords,
it was scheduled.
It was scheduled for
tomorrow.
e-auction, my lords. In the meantime, they have communicated to us. Till then, we were not communicated with respect to the.
He wants to withdraw the writ petition,
My
saying that no,
lords,
there is no auction.
my lords, it may be kind.
Rescheduled?
It was scheduled for tomorrow, my lords. And they asked for case details. I furnished the case details. My lords may take para 12 of the statement of objection they have
He
filed.
wanted to withdraw this writ petition.
Please, ma'am.
But they have now rescheduled it to some other date.
As far as the information that I have given, they pulled out the auction because there is an NCLT moratorium in place.
Is it so?
No, my lords.
In that
We are
case,
ready. We have no objections for him to withdraw the petition, but only the conduct of the petitioner has to be noted, my lords. Why?
conduct-
Because, my lords, tomorrow they may.
You completely called off the sale or?
Please,
you're
my
going to
lords, we
conduct
have
it?
undertaken, my lords. We are even undertaking in these objections, my lords.
That you will not conduct.
No, my lords. We'll start it.
94 application.
Please, my lords, he has not intimated us only because we will not move our application before the NCLT, my lords.
The present writ petition is filed.
My lords, in the meantime, my lords, we would have gone to NCLT and proceeded there, my lords. He has stalled us from proceeding there, my lords. That conduct has to be recorded, my lords.
Yes, I'll record that.
Please, my lords.
The present writ petition is filed. Singer writ of Sareshwar consequently quash the sale notice dated 4/10/2025 to the respondent. It is stated that the respondents have issued the notice in spite of being aware of an interim moratorium. The impugned notice is against the mandate of the Insolvency Bankruptcy Court and is not sustainable. It is stated that the petitioner had filed application section 94 of the Insolvency and Bankruptcy Code seeking insolvency resolution on 27/6/2024. And as per section 96 of the code, the interim moratorium comes in effect immediately upon the filing of the application, that is from 27/6/2024. Hence, in these circumstances, the notice that is issued by the respondent bank is bad. Next paragraph. When the matter came up today, the learned counsel appearing for the petitioner submits that he may be permitted to withdraw the writ petition as the respondents have not conducted the auction, they are not going ahead with the auction scheduled tomorrow.
Please, my lords.
Scheduled to be held tomorrow. Learned counsel appearing for the respondent bank has filed his objections. It is stated that the bank has no objection to objection if the petitioner wants to withdraw the writ petition. It is submitted that the petitioner has not even informed to the bank about the filing of an application under section 94 of the IBC it is stated that the loan account was declared as a non-performing asset on 25/10. I think it is not correct.
My lords, the demand notice is issued on 25/10, my lords.
The asset was declared as a non-performing asset. As in spite of the repeated reminders, as the petitioner has failed to make the payment of the money, the bank had issued a demand notice on 25/10/2024 under section 13(2) of the Surfacer Act, calling upon the borrower and the petitioner as a personal guarantor to make the outstanding amount. After receiving the notice, the petitioner had not revealed to the respondent bank that he had already filed the application under section 19(4) of the Insolvency and Bankruptcy Code on 28/6/2021. It is submitted that the entire conduct of the petition is drenched with malafide intent and concealment. Land counsel submits that if the bank is aware of the same, that the petitioner has already filed an application under section 94, they would have approached the NCLT. It is submitted that the petitioner had concealed all these material facts with the bank and come before this court. Having heard the counsels on either side, there is the material on record. The petitioner wants to withdraw the writ petition because the sale was not concluded. And it's a grievance of the bank that the petitioner has concealed the material facts from the bank. That is filing of the application under section 1994. The respondent bank can have the said defense before the appropriate forum. Considering the submission of the land counsel, the writ petition is dismissed.
Please, my lord.
Has withdrawn. Next, what about 5.1?
My lord, the connected writ petition.
Connected writ petition is coming up on the 18th, my lords, for final hearing, 18/11/2025. This petition, my lords, I've challenged the order of the DRT,
Give the next part.
where the DRT, my lords, has
5.1. Oh, this is the one. Yes.
has directed respondent number 2 bank.
Where is the order sheet in this?
I think page number 14, my lord.
Let's see your prayer in this writ petition.
For caution of the order of the DRT. My lords.
What is the order passed for the DRT?
Directing the respondent number 2.
Ink page number 15, my lord.
Directing the respondent number 2 to make the rent payment to respondent number 1, which is payable to me, my lords.
Counsel for both sides present. Nationalized bank, which is in possession of the property by which of the registered lease, measures taken by the respondent.
This order, my lords, was passed on the 21st of August. It was communicated to me only in the last week of October. In the September's rent also, they have credited it to me. Now the November rent.
What is the impact of that, the application under 94 on this?
Here, my lords, one difference is the respondent number 2 or respondent number 1 has also initiated proceedings against the other directors in the company under 94. So they are also aware. So my first contention is being aware that they themselves had approached the NCLT. They could not go to the DRT and get a direction for payment of the rent.
My lord, it's a case where, my lord, Bank of Baroda filed an essay before the DRT to, my lord, certain directions, my lord, sought against, my lord, Canara Bank in respect of, my lord, the lease which, my lord, entered by, my lord, Bank of Baroda. My lord,
No, the bank is a lessee.
Bank is a lessee. And, my lord, Canara Bank is, my lord, before their lease, they have a, my lord, charge over the property. Therefore, the Honorable District Tribunal directed, my lord, kindly see the, my lord, essay filed.
No, in respect to the very same property, the petition's application is pending.
Under section 94.
That is subsequent to the essay, my lord. Essay.
SA came to be filed on 23/8/2024, my lord.
When the application is pending before the NCLT, can other proceedings go on?
My lord,
Already there is a final order, my lord. Sorry, my
In
lord.
which case?
Yes, my lord. 23/8/2024 SA came to be filed, my lord. And subsequently, as alleged by the
Only
petitioner,
I'm asking you one simple question. When the application is pending consultation before the NCLT, that's filed under section 94 with respect to the very same property, can the debt recovery tribunal proceed with this? That's the only question.
my lord,
it cannot, my lord. But
96
whereas
a bar,
the facts as
96 my lord section, the moment
interim
somebody
moratorium
file
will be.
application under 94 or 95, 96 my lord come to the operation, that my lord we are aware. It is a case, my lord, where my lord, whether the petitioner, whether file an application before the NCLT, according to me, my lord, bank is not aware. My lord, today
The bank will go. Because you are aware of it, now we will go.
No, my lord,
before the-
sorry
Because
to,
we can't.
Insofar relating to the
appellate
petitioner, my
forums,
lord.
we can't decide all these applications like this.
well, however, my lord, the order passed by the DRT, it's a remedy under
My
section
lord,
18, my lord, they.
The
ought to
respondent
have-
number 2 was the appellant before the.
The DRTA ought not to have passed such an order when the 96 application, 95 for.
Nobody has brought it to the notice of the honorable DRT, my lord.
No, what is the purpose of sending this matter to DRAT? The same submission will be made before the DRAT, saying that an application under 94.
But my lord,
is
they
pending.
cannot circumvent that.
No, let it, or not all these formality. Let's not go with these formalities at all.
But here it is only an interim arrangement which has been made.
Whatever, once the application is filed under 94 and an order under 95, everything comes to
That
a
is
stand.
during the pendency of the essay, they are not brought it to the notice of
When
the
was that
honorable DRT.
when was that order under
7/3/2025, my lord.
7/3?
2025, Annexure C.
Then
And
it is
in that
on
it is also not, the Canara Bank is not a party, my lord.
21/8.
21/8, my lords. There, my lords might see page number 14 also.
23/8/2024.
Now, all these facts are in the notice of all the parties before this court.
In fact, my lord, respondent number 2 has,
All of you please approach to the NCLT. And whatever applications you want to move there, you move, you get implemented there. Yes. Give the IBC. The present writ petition is filed, seeking to quash the order dated 21/8/2025, passed with the debt recovery tribunal at Bangalore in SA number 191 of 2024. It's a case of the petitioner. The facts of the case are: the petitioner is the owner of the ground floor commercial premises at municipal number 29, measuring 2,000 square feet, located at Nanjappa Mansion, KH Road, Shantinagar, Bangalore. He has executed a registered lease dated 29/4/2014 and leased premises to Vijaya Bank for a period of 15 years, commencing from 1/2/2014 up to 31/1/2019. Vijaya Bank has taken over by the respondent number 2, and the lease is currently in subsistence with respondent number 2. The petitioner's daughter is the director of BNH Infra Projects Private Limited. The petitioner had given personal guarantee to the loan obtained by BNH Infra Projects, which has suffered financial setbacks. And also, the petitioner was also under financial strain, and they were no longer in a position to service the loan obtained from the bank. Hence, the petitioner has approached the National Company Law Tribunal under Section 94 of the Insolvency and Bankruptcy Code, seeking initiation of insolvency resolution process on 7/3/2025. It is submitted that as per 96 of the Insolvency and Bankruptcy Code.
In the said application, they have not made any arrangement, Canara Bank as a party member.
That I will, in your contention. The interim moratorium commences from the date of filing of the application under section 94/95 of the Insolvency and Bankruptcy Code. As such, the interim moratorium commenced on 7/3/2025. It is submitted that the respondent number 1 is Canara Bank.
Yes, my lord.
Has also initiated proceedings against BNH Infra Projects and its directors under section 95 of the Insolvency and Bankruptcy Code. So you are there before the,
Please, my lord, their contention is, my lord, I also filed an application under section 95.
We are not
no,
aware.
no, no, you have filed.
My lord, that I had to secure instruction on that.
He wrote, he said so in his,
He said so, my lord.
the tribunal in CBIB number 102 of 2025 and CBIB number 104 of 2025. And even in that case also, interim moratorium under section 96 of the IBC is in operation by virtue of the respondent number one's application as well. Land counsel appearing for the petitioner submits that in these circumstances, the tribunal ought not to have passed the impugned order, page number,
15 minutes.
ought not to have passed an interim order, ought not to have passed an interim order on
Dated
the,
21/8/2025.
on 21/8/2025, based on the request of the first respondent bank.
First respondent.
First respondent bank against
Second
second respondent bank, bank, subject to, second respondent bank remitting the future rent to the, first respondent bank. It is submitted that the first respondent bank, having initiated the proceedings under section 94 of the IBC, cannot go before the DRT and file such an application. Next one. Learned counsel appearing for the respondent, first respondent bank submits that whether the IBC proceedings are initiated by the bank, he has no specific instructions in that regard. Learned counsel appearing for the second respondent bank submits that in none of the proceedings, the second respondent is made a party to the proceedings. Proceedings. Next one. Having heard both the counsel for the
And the
petition.
information of filing is not been brought to the notice.
Huh?
And the information of filing the application
And it was never brought to the notice of the second respondent.
Before
bank,
that,
having heard the learned
honorable
counsels on
DRT.
either side, but it was a material non-record. The surface, the first respondent bank, that is Canara Bank, has already initiated the proceedings under the, under section 94. of
No, my
the-
lord, they're saying that section 7 I filed against a corporator.
Huh?
Section
95.
Kindly come.
95.
my lord,
He has
page-
given the number also,
Number-
at paragraph
page
number 5.
Paragraph number 5.
it is-
He
it is
has the Canara Bank,
Not against the present petitioner.
in respect to the property.
Debt. My lord,
Debt.
that I am aware, my lord,
Ah.
fully aware in respect of section 7 I filed against him, my lord, the corporate debt, that is BNH Infra.
95.
No, the property belongs to the petitioner. The property which is leased to the second respondent. That
Respect of the
property,
property.
he
Please,
has
please, please,
mortgaged.
my lord, please.
The first, what did he do, right? Has already initiated proceedings against BNH Infra Projects
Please.
Private Limited. That is the property.
Please.
That is the property which is in question is mortgaged to the Canara Bank. Canara Bank, that as the daughter of the petitioner is managing the managing the affairs of the said company. And when those proceedings are pending before the when he himself has filed a petition under 94, the Canara Bank ought not to have filed an application before the
DRT.
tribunal DRT, that is essay number 191 of 2024,
It's filed by Bank of.
as
Application
That
has
is
been filed by
Filed by my
respondent.
second
number
respondent,
for 2
not
months.
me.
In that they
then
made a
yes,
submission,
The Canara Bank,
Error is respect.
but not have made a
for
submission.
the,
My lord, in the, before the, my lord, DRT, I'm the respondent, I'm not the petitioner.
he is the applicant.
He is the applicant.
He made a submission in that.
Yes, yes, the, that line you remove. So, Canara Bank is a party to the DRT proceedings, and this order is passed that the future rent shall be paid to the first respondent, that is Canara Bank, considering the fact that the IBC proceedings are pending before the
NCLT bank.
NCLT. And the moment an application is filed under 94,
96.
and the interim moratorium commences from the date of the filing of the application, that is on 7/3/2024. all the parties are relegated, or the aggrieved parties are relegated to the pending insolvency proceedings. The submission of the second respondent bank that is not made a party to those proceedings. Now, as he is aware of the pending proceedings before the NCLT, both initiated by the petitioner as well as by the first respondent bank, that is Canara Bank, it is for the second respondent to take appropriate steps. Next, one more submission from this side. When an order is passed by the DRT, you ought to have filed an appeal before the DRAT. Hence, the matter may be, hence the repetition may be dismissed and the matter may be remanded to the DRAT. Next part. The second submission of the, in this now the consideration. The second submission of the counsel for the banks, that as the order that is passed by the DRT is appealable before the DRAT and the matter may be remanded back, the repetition may be dismissed and the matter may be, and the petition may be relegated to the DRAT. This court do not find any force in the submission of the learned counsel for the petitioner. Admittedly, when the IBC, when an application and 94 is filed by both the petitioner and the first respondent bank, and the same is pending before the NCLT. Now, even if the matter is relegated to the the petition is relegated to the DRAT, as the matter is pending before the NCLAT, in the light of the, what is that?
Section 96.
Section?
Which?
No, because the matter is pending before the NCLAT in the light of 96.
96. 96 will come to the.
There cannot be any proceedings before any other court. So in that view of the matter, this court is of the view that no purpose would be served in sending the matter to the DRAT for deciding this issue. In that view of the matter, the writ petition is allowed, the order impugnated so and so is set aside, and the party and the second respondent is at liberty to approach the NCLT.
Grateful, much of.
Yes.
Number 6. Sharath Kumar Shetty.
Hearing for respondent. Short accommodation.
I've,
Second respondent.
Clear the entire loan dues, Your Lordship. Last date of hearing, the Honorable Court directed me to file this receipt. Copy also served, Your Lordship.
What is the writ petition about?
The first one is sale, second one also sale, Your Lordship. The first sale, that is earlier, Your Lordship, the first matter, 25-42.
No, first is 16439. 16349.
That is 2023, Your Lordship. That one is 2023. Earlier is 2022 I have filed.
No, any of the file is with me. I'm asking what is this prayer in this?
Challenging the sale, Your Lordship. As
What
per this,
happened?
as per this honorable court order, I have cleared the entire loan due.
No. What is the date of the sale notice?
Sale notice in 16349, Your Lordship. Sale notice date is 10/7/2023.
10/7?
2023.
23.
23.
Whether the sale was conducted or not conducted?
Sale has conducted and the sale confirmation is staged by this
For the
honorable.
auction
Yes,
purchaser?
I'm the auction purchaser, my lordship.
Then when was the order of this court to pay the money?
That one, Your Lordship, 28/7/2023.
28?
28/7/2023.
The sale shall not be confirmed till the next date of hearing, subject to the petitioner depositing with the respondent a sum of rupees 50 lakhs
Kindly.
as under.
Kindly.
What was the price, asking price?
1 crore 90 lakhs, my lordship.
1 crore 90 lakhs, 50,000 was directed to be paid.
50 lakhs.
50 lakhs is directed to.
Yes, my lordship. By 11/8/2023, he has to pay the
But
first
you are referring to
installment
the
of
entire
17
amount
lakhs.
means 50 lakhs.
Your Lordship, kindly, Your Lordship. So what happened in this
No.
matter, the loan due is
No,
only,
no.
kindly, for a moment, Your Lordship, Annexure C, for a moment. That amount, the 50 lakh I have deposited.
What about the other amount? 50 lakhs you have deposited. First of all.
So first, what happened, Your Lordship, kindly, for a moment, kindly go to the page 15, Your Lordship, for a moment. Page 15. Earlier to that, Your Lordship, there is one more writ petition.
You have collected the entire amount from him.
Lord, the on-record counsel is not keeping the lens
short accommodation may be given. We are filing the loan account details of the petitioner, my lord. I have
See that he has not paid the amount, my lordship.
account
This
details.
is matter on
In this week it's a.
10th of November.
Because there is a stay is
Account
operated in the
details.
earlier writ petition.
Look at it, if in any of the matters there is any stay, extend it till the next date of hearing interim
Stay
order.
is according to the,
Whatever is interim order, that will be extended till the next date of hearing.
my lordship, the stay is given only on the conditional basis of his
That
payment.
complied, your
His
lordship.
Payment is not done.
That complete, that bank has to say, not by the auction purchaser.
Interim order earlier granted is extended till then.
Kindly.
It's coming up on 10th, that day will dispose of the matter.
Much okay.
7, Narayana.
Pray for the petitioner in this case, my lords. Kindly, I pray for, we have engaged the senior advocate.
Time for action.
Senior advocate is not keeping well, my lords.
It's not well, my senior counsel,
Difficulty is this, my lord.
is engaged in the matter.
Yeah.
He's attending the death ceremony of his uncle. Last 2 days also, he was suffering from throat infection. He had made a request. Lordship may accommodate only 2 or 3 days date. He'll
Section
be back
14,
on
my lord, aside before this honorable court. My difficulty is this, my lord, I sold a property, I issued a confirmation, sales certificate issued. Only possession, my lord, I have to hand it over to, my lord, my friend.
Lordship may take
I'm
this
the
matter on
action-
5th, my lords. By 5th, he will be in the, before the lordships. He has made a request to make a request.
It's not the first round of litigation.
But
Since
every
2
day we
years-
can't accommodate like this.
Only 2 days. my lords,
Every
because
matter we have been accommodating, but it can't go on like this.
Only circumstance. He has to go to native, attend the function, there's a ceremony.
21/3/2024 is the interim
Only 2
order.
days, only 2 days.
What
not
is,
more than-
what is the outstanding amount?
My lord, I saw, my lord, kindly come to, my lord, the sale notice, which, my lord, in the page number 91.
What is the outstanding?
1 crore 30 lakh, my lord, 2 crore 70 lakh 36,365.
Hmm.
There are 3 loan, which I, my lord, page number 91 I mentioned. The total liability 1 crore 30 lakh 7,465 of so and so. And 2 crore 70 lakh 36,365. And one more loan, my lord.
So what is this? Then a senior counsel appearing for petitioner would project that the property worth rupees 6 crores is sold at rupees 2 crores for a loan that was secured for 30 lakhs.
Yes, my lords.
I have taken a valuation, my lord. What had
I
happened?
have purchased the same on 2 crore 2 lakh 80,000 since 2 years back, your lordship. They
Valuation,
have-
who will give you the valuation?
I'll take a valuation from the approved valuer by the, my lord,
Of your bank.
of my bank.
Internal-
And my lord, I'll put a property for auction.
No, this property is as per the market value.
120.
As per the value maintained by the registrar. If the property is 6 crores, how can your
No, my
valuer
lord,
give
it
it
is
at,
an allegation of the, my lord, borrower saying that the property value of rupees 6 crore. It is not so. That is the case, my lord.
You must have, or mortgage
Page
the
number one-
property.
Mortgage, please,
You
my lord.
must have mortgaged the property.
Please, my lord.
Mortgage deed contains what is the amount that is mentioned in that?
My lord, mortgage did, my lord, kindly come to, my lord, mortgage which I produced before this honorable court. Along with the memo.
Hmm.
In mortgage deed, my lord, will not indicate the value of the property. Will
No,
indicate.
on the mortgage sheet, the deposit of title deed will be there, no?
It is
Along with you.
It is there.
The title deed will contain what is, for what amount he has purchased the property, the market value, how much he has paid.
That is the case.
That would cut the issue.
Please, my lord, then that is the case, my lord, I'll produce a sale deed also before this honorable
That's
court.
all. If that is the case, then
In
he will
all
have-
the cases, borrower will have a same song, my lord, my property is sold for a song. It is a matter of, my lord, here the case, my
No,
lord, I am.
Please understand,
understand.
that may be the standard submission, but we have to look it from.
I'll
the-
produce it.
No, and I have been
Lordship,
seeing
the
recently.
properties adjacent to the
From
graveyard.
last 2, 3, I mean, at least 4, 5 cases I have seen. The property they purchased in the year 2016 for 2 crores. Now, you keep the offset price at 30 lakhs, 50
It's not
lakhs.
so, my lord. It never happened in bank
It
cases.
happened, that's why I
No,
granted
in
stay.
this case, my lord, it is not happened so. I'll produce a sale deed before this
Please,
honorable court.
So,
the
Lordship,
counsel
the
for the
properties
respondent
adjacent-
bank shall place before this court the sale deed,
Stands in the name of borrower.
huh?
Stands in the name of borrower.
Stands in the name of the
Borrower.
borrower.
Great.
List this matter on when?
Any, my lord,
Any short cut.
Interim order may kindly be extended.
On 11th November.
Interim order may
Meanwhile,
kindly
my
be extended.
application,
Huh?
I'm for impleading application, I'm the auction
Can be
purchaser,
allowed, my lord.
against which they
He is the
can,
purchaser.
I'm the purchaser of the property.
His
The application is
for
pending
consideration.
before.
Where is that? We will order it. IA number
IA number 1,
for impleading, I number
Yes,
1
sir.
of 25 is filed by the auction purchaser to implead himself as a respondent number?
Two, ma. Three.
How many respondents were there already?
He'll be respondent number 2.
Two, Your Lordship.
Treat as respondent number two. Consider the fact that is auction purchaser. I number 1/25 is allowed. Yes,
Interim order may kindly be extended.
interim order earlier granted is extended till then.
Like-
Yes, next.
Right?
Lord, I pray for petition in this
Second
matter.
again.
Same matter where KPAD and my lord surfacing
Oh.
central enactment and state legislation. My lord, petition number, in my lord, first petition, my lord, the auction purchase before this honorable court. My lord, he undertook to file an application for my lord, seeking refund of money. That my lord,
That's how it is. As he filed,
he wanted to file it, my lord, got stuck in quota number 1. My lord, 230 matter may be taken, my lord, he'll file it.
Great.
Number 9.
Case appearing for respondent bank, my lordship.
no, the other day one matter I have reserved, in that you have filed your objections.
No, yes, my lord, we have filed. In Punjab National Bank, where my lord, paragraph 4, I said that I'll hand over the position of a property.
Only one matter I have reserved.
In that we have filed our
Objection.
objection.
If not, I'll look at it. I will again
I think
post it
it's-
for being spoken to, because unless you have that,
Correct.
your objection on
I agree,
record,
Lord.
that's a ground for you to file appeal again. Yes, 9.
Number 9.
Case appearing for respondent bank, my lordship. My lordship,
For petition.
the petitioner has challenged the section 14 of CJM order, my lordship.
Senior out of session.
No, please, all these submissions will not go, there is an interim order in this.
Yes, my lord.
Yes, ma'am.
And all the senior not there, senior unwell, see accommodation, it is not
Okay.
possible. Having taken an interim order in the year 2023,
Yes,
you
my
have to
lord.
argue
Since
the
1
matter.
year, they are enjoying the interim order, my lord.
When will you argue?
2 days. ma'am.
Tomorrow? This is matter tomorrow?
Grateful,
Yes.
my lordship.
Next.
Number 10.
Senior,
It is asked.
10. A colleague had made a mention in the morning. First round, she made a mention that senior counsel, Lords, is, as I told Lords, is attending a death ceremony. Lords, may I accommodate only 2 days, Lords, not more than 2 days.
And this
Must-
accommodating business can't go on.
Only 2
like
days,
this.
Lords, that's
The whole last week I accommodated.
because he was
he's
not
well.
throat infection.
That I can understand. But every week.
He was not
this
in a
can't
position
go
to
on.
speak, Lords. Otherwise, he will always, Lords, he will be present. Like
No, 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 I'm not making any comment against him. I'm saying I have accommodated, but all again this week, we can't, for other reasons, we can't. This is matter. When is other matter coming? Just now I've adjourned the matter.
ಅದು ಯಾವತ್ತು ಹೋಗ್ತದೆ 11th 11th.
Unless this matter also on 11th.
Great.
Interim order, if any, is extended. No interim order. I think I do-
Lord's last date, it is not extended, but senior counsel made a submission that there is a proposal of settlement. Lordship, may I see a order sheet for a moment?
In your list, come
Intermod
on.
is there, my lords.
Come on 10th.
Intermod is there, my lords.
If it is not extended last occasion, we will.
That's
We'll
because
see
senior
on-
counsel himself made a mention that there will be a settlement.
We will see it next week. Yes, on 11th. Yes, 11th.
But serial number 11. Petition HM.
Petition, my lord. My lord, in last occasion, letter friend has filed a memo along with the email.
Lord, on the last occasion, I have
Answer the
It is-
respondent bank submits that in fact the petitioner himself has voluntarily given possession of the property and also requested the bank. You wanted to
Yes,
give
ma'am.
instructions.
My lord, in this matter, my lord, I am seeking only direction to the bank to regularize my account. My account has been
Why will
NPA, my
we
lord.
pass such an order directing
Allah.
the bank to regularize? If you're
Allah,
entitled, you're
he will,
entitled.
he will, entire due amount, whatever is there, my lord, he will ready to pay, my lord. Ready to pay, my
You
lord.
pay, they will regularize.
No,
Why
my
should
lord,
they
my
not?
account has been NPA, my lord. How can I pay, my lord? That is my problem, my lord. If a bank is ready to regularize my account, my lord, then I will pay the balance amount, my lord. Locked the premises, my lord. Myself has given the hand over the
I
key,
am
my
ready
lord.
to pass any order, provided you show me one rule, one law that says that High Court should pass an order directing the
Like-
bank to
My
regularize
lord,
the account.
property is more than 8 crore, my lord.
We
But
can't
the
have that.
due amount is, my lord, 1 crore or 40 lakh, my lord.
Whatever is the remedy available to you, please pursue that. We can't direct the bank.
And moreover, my lord, my client is in outside, my lord. He want to talk with the
Lord, on the
Let them
last
talk.
bank
occasion,
employee.
Let them talk.
Lord, on the last occasion, along with the memo, my lord, I filed the letter.
On that memo, I am seeking, my lord. Only seeking regularization, my lord. Allah, if there is any possibility, my lord, them.
Talk to the
Then
bank. It
please,
is all
ma'am,
about
please,
between you. The court can't do
Weeks,
anything.
weeks time may be
No,
granted.
no weeks time.
My lord, otherwise I will not get any order.
First of
my lord.
all, why this court has interfered, why should this court interfere with these?
I am
kind of
not,
particular-
I am not seeking any quashing order, my lord, direction, my lord. If there is any possibility by the bank, my lord, let them
Please
do, my lord.
understand.
Let them do, my lord.
If these kind of reliefs, if your client asks the court, I can understand, but you cannot argue like that. How can there be a direction? Please tell me, under which provision I
let
should
them,
direct them?
both parties, let them negotiate with me, lord. That's why, my lord, I am seeking 1 week time, my lord.
You already sought last week.
No, 2 days, so he is in outside, my lord. That's why, my
Finally,
lord.
list is matter day after tomorrow, no further time will be granted. And the order, on the merits
This
of it,
week,
the order will be
this week
passed.
they is not available, my lord. That's why, my lord. 1 week, my lord. Next
Then I'll
week,
vacate the interim order and post it whenever you want.
Friday, my lord.
Please, Friday.
List the matter on Friday.
Number 12.
Yes, I appear for the petitioner.
Under section 17(13)(2) cannot be challenged, so the writ petition is not maintainable. Now we have issued
Can I
until
just
14.
request
They have
a
now finally,
pass over to the afternoon, my lord? That's all.
Yes, pass over.
they can be
Please come.
relegated to DRT, my lord.
Let them come, pass over.
Yes.
Yes, 13.
13. Bharat.
I am for petitioner, my lords. I am filing amendment application.
Your lordship, this matter has to be heard, your lordship.
On 16th, it was heard at length, my lords.
And I passed an order. I
Yes,
see
my
all
lords.
that.
Interim order was
In
granted.
that, they have mentioned that I have made a false submission in the DRT and taken an order.
No, I heard on the day at length, the only issue is this. Whether a particular property is mortgaged for a particular
Loan.
in respect of a loan account.
Yes, your lordship.
That's the only clarification I sought. If you clarify that, there is nothing.
Yes, your
My
lordship.
lords, along with this,
Yes.
One particular property is mortgaged for one loan, your lordship. The other property is mortgaged for another loan. Both the parties are the same because in one he is a borrower, another one he is a guarantor. Since he is dead, all the legal has become. So the parties are the same in both the cases, your lordship. And what has happened because
No, you're only concerned with the particular loan account for which a security is created by mortgaging the property.
yes, your lordship.
Because the parties are one and the same, two accounts, two different mortgages, you will not club both together. If you have to, if you say you have the power to club, which provision permits you, if you
Your
show the
lordship,
code, it's fine.
the party is linked. There's an attachment order in another loan also, your lordship. The attachment order I have produced, your lordship. There is an attachment order in the other case. This property is attached to the other case also.
Under which provision it is done? You please argue on the, on the legal aspect of it, so that I'll understand.
may I make one submission. My lords, on the last date of occasion, the two, one sale notice was challenged, other one is DRT order. So it's permitted to my lords file amendment application, my lords, amendment of prayer, my lords. Because that particular 25/9/2025 order by oversight, my lords, I did not challenge. So that is the reason, my lords, I'm filing.
You're ready to argue the matter?
I'm filing application, my lords. Mr. Ravi Shankar had argued the matter at length on 16th. She has filed.
State that. You have to file it in the section.
Sorry, my
You
lords.
don't even file it. Why would I have it?
I'll
take
file it
in,
before the registry, my lord. I'm sorry.
Motion is posted tomorrow so that.
Well, next week, my lords.
They're seeking all adjournments on the matters. 11th.
I'll pass it over by afternoon. I'll be able to.
Huh?
In the afternoon, I will argue the matter.
No, if you argue what is the purpose, they should also have to conclude the, or they have to pass an order after hearing the other side also, then responding to your
Copy is not
arguments.
served to me, your lordship.
I'll serve a copy. I'll serve a copy.
Yes. This is matter on 11th at the request of learned counsel, the petitioner. No further adjournments will be granted.
May I request
Yes.
for 12th, my lords?
Huh?
I request for 12th, my lords, if possible.
12th, it is not possible. You have to
11th?
argue on 11th.
Much about.
Already too much of accommodations
Yes,
are being done.
Yes.
Yes.
14. Karan Gupta.
My lords, I appear for the petitioner. I filed my NOC wakalat. My name is on the cause list. On the last date, amendment was allowed to bring on record the legal heirs of respondent number 5. Amendment has been carried out. I was directed to serve a copy on one Mr. Rakshit Kumar advocate. I have not been able to source him, my lords. I have a copy. I can hand it over. The challenge, my lords, the main contesting respondents are R1, R2, and R6. I'll just give a very brief overview, my lords. I am someone who has given a loan to R3 partnership firm. Partnership firm's property has been mortgaged in my favor. The challenge is to attachment under the KPID Act in relation to investigation taking place of one of the partners of the partnership firm. Now, what has happened, my lords? I have given a loan in 2018. I got a mortgage, my lords, from the partnership firm in my favor. Then the impugned circular is released, my lords, under section 3(2) of the KPID Act, and attachment takes place. I have challenged it principally, my lords, on the following grounds. First, my lords, the KPID Act requires it to be published in the Gazette. That has not been published. Second, my lords, the KPID Act is very clear that when property is being attached, that property has to be property that comes from or has been bought from funds that have been collected by the depositors. Now, there is an investigation that is taking place against one of the partners of the firm, my lords, R4. The competent authority says, we are investigating the partner of R3, which is R4. This property belongs to the partnership firm. I am going to attach the property. The property which is mortgaged to me, my lords, the loan was taken to buy that very property. So whatever deposits R4 has taken, whatever investigation is taking place, R4 has now been arrested under ED, my lords. PMLA proceedings are going on in separate courts. The property which was mortgaged to me, in no way from the record, my lords, can be seen to be monies that were gotten by R4 through depositors in the public. Because the sale deed itself says,
How can this court decide
my lords, because
whether there's any involvement, there is any fraud, what has been done?
I bow down, my lords. There are two things, my lords, from a plain reading of the provision, the attachment itself which takes place.
Where you have to question that attachment?
I've questioned it in the
KPID Act. No, not before this court.
No, my lords, it's under the KPID Act. The procedure is,
You have to file a criminal petition,
the procedure is, my lords,
criminal appeal.
the procedure is here, my lords. There is a 4-step procedure. One is an interim order of attachment which takes place under section 3. Then a final order of attachment under section 5. Section 7 for liabilities and assets, and section 8 for dispersal. Here, this writ petition is filed in 2024, my lords, almost 16 to 18 months back. The competent authority has come on record last year, in the end of last year, has not filed objections to my objection that says that the Gazette notification is not published.
The property is attached, and any of the proceedings that are taken under the KPID Act is bad. Your remedy is to file a criminal appeal or a criminal petition. You need to file.
There is a provision according to KPID Act, your lordship. Powers, they have to question it before the special court.
Special court is.
After that, on an
After
order,
mere
that's
inquiry,
what-
they will
an
decide.
order
your
that is
lordship.
passed against that to this court, an appeal or a petition.
Amnesty.
lies
First-
against
It is not a criminal quashing petition, my lords. What happens here, the appeal,
petition.
Your lordship.
the appeal provision, if I may just respond, even the appeal provision under section 12 is only against a final attachment order passed under section 5. In this case, my lords, what is challenged is the section 3 order. We have visited their office on multiple occasions. We've asked them, is there a final attachment order? Can we please get a copy of the final attachment order?
The KPID Act.
Your lordship,
It
section 12.
altogether works in a different domain, which can't be part of the Securitization Act.
Your lordship.
My lords,
section-
there is a judgment, there's a coordinate bench of this court that is considering this question and granted an interim order of stay. I'll just pass that judgment, my lords.
What is that, what was considered?
The interface between the KPID Act and the SARFAESI Act. Now, what has happened?
Judgment of the Justice Bela Trivedi.
That judgment, my lords, is in the context of the Maharashtra protection of investors.
Which is parametria with this.
That is a question which is to be considered. My lords, I just pass this on,
Lordship,
please.
section 12 clause 3 of KPID Act.
Yes.
Kindly maybe take.
Now, where the Honorable Apex Court held that the state legislation, that is a KPID Act, would prevail over the Securitization Act.
My lords, in that judgment, there is a specific context which was provided.
That I've seen because I've heard it at length.
I bow down, my
It's
lords.
also initially under the same impression. But if you read the entire judgment, categorically, there was a finding saying that KPID Act or whatever is that.
The Maharashtra Act
Maharashtra Act, whatever is.
overrides the
State Act
SARFAESI Act.
Overrides the Surface Act.
I bow down to that. My lords will just see the copy that I've handed over, my lords. This is an order which is passed on 29/7/2025 by a coordinate bench of this court.
But in fact, I'm allowing that, I'm dismissing that writ petition. I've already reserved it.
For orders. So my lords, if I may make one submission. One is, I leave this.
This is another aspect which will prevail. You're not at that stage now. Now, the issue is when a particular property, whether it is attached or not attached, or it's an interim attachment or a final attachment, whatever it is, that is under there is a special act, special court constituted.
I bow down, my lords. My remedy,
You have to go before the court and file an application.
that happens only, my lords, when a final attachment order is passed. If my lords will see,
What is that?
section
provision?
12, my lords.
Section?
Section 12 is the appeal provision, my lords.
Section? Karnataka, what is this act called?
Karnataka Protection of Interest of Depositors.
Karnataka Protection of Interest of Depositors in Financial
Financial.
Establishments Act. You're reading?
My lords, I bow down. 16, my lords. My lords, if I may read, any person, including the competent authority, if aggrieved by an order of the special court, may appeal to the High Court within 30 days from the date of the order. The order which is appealable is an order of the competent authority.
Pending
Before the
consideration
appeal
before special court, your lordship. It's still pending before consideration. in
Come to
special-
section 10, an order under section 10. Then 11 is what the powers of the special court. Please read that. Let's-
I bow down. Just before that, my lords, in the stage, I have a lack of information is my submission. I want them to place it on record. What is challenged in this petition is a attachment order under section 3(2). The special court,
Let's see 3(2).
special court only comes in when an application under section 5 has been filed, my lords.
Let's see 3(2). What is 3(2)?
My lords, under
It's a
section,
consequential action then.
yes, my lords.
Attachment of properties on default of return of deposit.
If I may just read that portion out, my lords. It comes after, in 3(2), after subclause 3, after the explanation.
Why can't we read 3 from 3? Let's understand 3, attachment on properties of default of return.
The government or the nodal officer notified by the government or the district magistrates in their respective jurisdiction, suo motu or based on the market intelligence reports or police authority on receipt of any complaint, may
why-
investigate
no, no,
or
What I'm seeing here and what you're reading is not one and the same.
3(2), my lords. I'll start from 3(2), my lords.
Oh, you started from 3(2).
Notwithstanding anything contained in the above law, for the time being in force, where suo motu or based on market intelligence reports or upon complaint received upon from depositor or otherwise, the Secretary to Government Revenue Department is satisfied that any of the financial establishment has failed to return deposits after maturity or on demand by depositor, to pay interest or any other assured benefit, or to provide the service against such deposit, or where the government has reason to believe that any financial establishment is acting in and detrimental to the interest of the depositors with an intention to defraud them, or this is the one that is the attachment order relies on, my lords, the government or any authority notified by the government in order to protect the interest of the depositors.
Section 3(4) says, once on the publication of the order made under subsection 2, all the properties and assets of the financial institution shall forthwith vest in the competent authority appointed by the government under, that is section 2(4).
So, my lords, it vests in the competent authority. Now, my lords will see section 5, my lords.
Section?
5, my lords. Specifically, section 5(2).
Yes.
The competent authority shall, within 30 days from the date of the receipt of the order made under section 3. Today, my lords, I don't know if this application has been made. I don't know.
It's already made, your lordship.
The competent authority shall, within 30 days from the date of the receipt of the order made under section 3, apply to the special court for any order of attachment absolute. So this, my lords, once the application is made to the special court decides whether the interim attachment is made absolute. It is that order which is an appealable order as being passed by the special court.
And at that point of time, you will also, before the special court, you will also have the audience.
My request is this, my lords. R6 is the competent authority. They were brought on record last year.
Your lordship. I am for R6.
R6 was brought on record. Today, my lords, if a final order has in fact been issued,
Whether an order under section 5 is passed?
Your
As per
lordship,
your instruction?
kindly 12 clause 3, your lordship.
No.
Section.
I'm
keep it.
asking as far as this property is concerned,
Yes, your
the
lordship.
competent authority has passed any order?
No, your lordship. It's still pending before they have filed miscellaneous petition before the Udupi court, your lordship.
now, my lords,
Court, it's still pending for consideration, your lordship.
Before the special court?
Yes, your
No,
lordship.
when
I
it
will
goes
also.
to the, please come to the powers of the special court.
Yes, your lordship.
Where are the powers?
Kindly 12 clause 3, your lordship, KPID Act, any person claiming an interest in the property attached.
Which provision?
Section 10, my lords, is special
12
code.
clause 3 of KPID Act.
Yes, yes.
Any person claiming an interest in the property attached or any portion thereof may, notwithstanding that notice has been served upon him under this section, make an objection aforesaid to the special code at any time before an order is
You're
passed.
reading section 10.
No, 12:3, she is
12
reading.
3, your
12:3.
lordship, 12 3.
Powers of special court, yes.
Yes, your lordship, 12 clause 3.
Mm.
Any
So now,
person.
according to you, your application under section 5 is pending before the special court.
Yes, your lordship, I'll also. That number is also is there. Your miscellaneous petition number 1255/2025. It's and also 1243/2025 before
Yes,
principal.
this is
city
where
civil
your
judge.
right of audience is.
I bow down.
Yes,
Now,
your
my
lordship.
lords, I have visited their office on numerous occasions, which is why today I'm asking for a very limited direction. I have visited their office on numerous occasions. I've asked them to give me the case number of what is pending under 5.2. I've asked them to give me a copy of the application, because if that application is not filed within 60 days, the whole thing is vitiated under section 5, my lords. Now, I have no information on whether they have complied with the statutory mandate of section 5. And I'm requesting today, my lords, to request them to put it on affidavit. What is the case number of the section 5 application when it was filed?
Yes. Yes. Your lordship, this petition itself not maintainable, your lordship. If they have any queries, they can question before the special court, which is already pending for consideration, your lordship.
Which says that queries? Which provision says?
Any person claiming an interest in the property attached, that is 12 clause 3 of KPID Act, or any portion thereof may, notwithstanding that no notice has been served upon him under this section, make an objection as aforesaid to the special court at any time before an order is passed under section subsection clause 4 or subsection clause 6.
I bow down, my lords. My request is this, even for me to avail this provision, my instructions are, if we do have this remedy.
No, that's not, if you want an information from them, you can't file an application under the, no, this is a DRT, this is listed as a DRT matter.
Well, I bow down. When this matter was filed, it was filed merely 15 days after the section 3 notice was issued. It was not filed with no knowledge or information of the section 5 order.
Have all the information.
My lords, I'm requesting, please let me request this. Today, even despite approaching their offices,
Now they are telling what, now she says, what is the case number? Now you are aware, make all application before.
they've not mentioned it, my lords. Please let them place it on record. I've asked the offices.
Case number? Pass it on.
Your lordship, I have just taken the instruction. Number
What
is
is the number?
miscellaneous 1255/2025.
Miscellaneous?
1255/2025 before principal city civil judge and session court Udupi.
You write it on a slip, I'll dictate
Yes,
it
your
after,
lordship.
after lunch.
Yes, your lordship.
My lords, if I may, my request, I have sought instructions on whether this has to be withdrawn with liberty to make appropriate applications. If a short date may be fixed, I'll get the information and I'll come before the court, my lords.
We have, I heard it now, why can't we pass an order
I'm seeking a short date, my lords. I will examine whether this case details are available.
tomorrow?
I bow down, my lords.
The lordship's permission. No mentionings now.
It's not regards today's matter, minutes. It's reserved for judgment. I'm constrained to move the court because I'm not able to.
If your ladyship may allow me to mention item 26 for a moment, Village.
Take a. Slip ಬೇಕಾ?
Which item will be taken up post lunch?
I'll take that number from you, ma'am.
Okay.
Court master, which item will be taken up post lunch?
You have to file application there.
I agree.
But
Client is
here.
not able to tell me what is the list number.
Court master, which item will be taken after lunch?
2025.
ಇನ್ನು ಬಂದಿಲ್ಲ ಇವಾಗ ಹೋಗಿದ್ದಾರೆ ಮೇಡಮ್.
Am I audible to the court? Sir, which item will be taken up post lunch?
Post lunch, there are 3 passed over cases are there, sir.
There are series, I think so.
As per instruction of the honorable judge, we will take, sir.
And sessions.
The pause list 2 will be taken up, sir.
Now the list number 2, seal number 14 is over. Another 3 passed over cases are there. As
So
per
they
his
will be taking first, the passover take matters will be taken up, right, sir?
yes, sir. First, take passover matter will be taken.
Is it just
So
missed
2:30,
or-
yeah?
Thank you.
2:30, yeah?
Only
Yeah.
missed is showing.
You are next, session.
Send me the screenshot. Okay.
सर ये फाइल है सर सर ये फाइल है
ಇಲ್ಲ ಸರ್ ಮಾಡ್ತಾರೆ ಸೀನಿಯರ್ ಈಗ ಔಟ್ ಆಫ್ ಟೆನ್ಷನ್ ಅವ್ರು ಬರೋವರೆಗೂ ಮೂವ್ ಮಾಡೋದು ಇದಕ್ಕೆ ಆಟೋ ಲಿಸ್ಟ್ ಆದ್ರೆ ಬೇಕಾದ್ರೆ ಹಂಗೆ ನಾವೇ ಕ್ಲಿಯರ್ ಆಗ್ತೀವಿ ಇಲ್ಲ ಅಂದ್ರೆ ಸೀನಿಯರ್ ಬರಲಿ ಫೋಟೋ ಸರ್
ಗವರ್ಮೆಂಟ್ ಕೌನ್ಸಿಲ್ ಆಗ್ಬಿಟ್ಟು ನೀವು ಹೋಗ್ಬಾರ್ದು ಮಮತಾನೇ ಮಾಡ್ತಾರಲ್ಲ ಪರ್ಮಿಷನ್ ಅಲ್ವಾ
Good on, sir. effort for mediation, but we were present on the 2 times also. But from the respondent side, there was no representation.
It is posted for mediation and the date is on 18th December.
I think you heard what she submitted.
18th December, as per the.
You're not coming, you don't come before the.
They had been there,
No, that's why she's submitting.
He was present very much. The record ಅಲ್ಲಿ ಇದೆ ಅದು. It is there in the order sheet.
Which order sheet?
That MC petition 151 bar.
What is the mediation? What is the?
MC petition connected case.
No, what is the settlement that you
They
are coming
want to
forward?
settle with some amount and get rid of it because they want to get separate. So
When is the mediation next? When is it posted?
probably they might not be aware that they are negotiating and they are negotiating. Even yesterday I received the information.
My lord,
that
they were not
they are
present.
negotiating.
They were
through
not
the
present.
mediators. Through the mediators.
On both the times, they were not. They
Maybe,
only
but
referred for
they
the
are-
mediation, but they were not
With their
present.
relatives, they have contacted them and in turn the talks are going on. See, it's an information what I have received. They might have received different these things. I have received as per the court order sheet in MC 151 bar 2025, the mediation report by 18/11/2025. It's there. It is in
This is
the
matter.
19th it may be posted so that if
On
the case is
19th,
not
whatever
settled,
is the result of the mediation, if the mediation is not concluded,
the
orders will be passed and no adjournment on the ground that the matter is referred to the mediation. The parties can pursue their remedy, but the
if at all-
writ petition before this court will be disposed of by the next date of hearing. Yes,
but
for the
on
next case.
24th,
No, 19th it will come. Yes, next.
19th I will be in the Shabarimala, that's why. 24th onward, 21st onwards. Even 21st itself is okay because I am coming on 20th.
This is the matter on 27th.
27, much obliged.
Much obliged.
Last time, your lordship
Yes,
direct-
this is the
lordship,
matter.
your lordship directed the other side to file affidavit for.
Next matter.
List
please
number
call the
2,
next matter.
seal number 8, Shetty Vignesh. Seal number 8.
For the respondent 3 in this case, your lordship, has been held up in another court. Kindly pass over.
Morning, what happened?
Morning, it has been passed over, your lordship.
So pass over, again another pass over.
He has to make a submission and detailedly I have to argue on that. He's filing an application on that. So, your lordship.
No, it is unreasonable on the part of the advocate to seek pass over again, pass
No, your
over.
lordship.
Court has no other work.
I apologize before this court.
Submission, my lord. The same matter, my lord.
I remember.
But their two contentions are that a review petition is pending. Hence, my lord, this court may have to adjourn the matter. But their first contention is that a review petition is said to have been pending before the Honorable Supreme Court.
No, not that.
The second petition, my lord, I have no say in that. It is between my lords, the bank and them. It has got nothing to do with the first petition. The first petition may be disposed of.
Because both are together, I have to pass orders in both the petitions. Unless that order is, no, that is not filed till now.
No, your lordship.
And we have to wait till eternally.
No, he's been held up in the first matter has been called out over there. 10
It
minutes.
is called application, where is it?
Application is over here.
You have to. I
I'll
mean,
file the application, your lordship. And the only contention is he need to argue it detailedly. He had given an instruction to say this before this honorable court, your lordship. So I'm
nothing to argue, only that application to be filed, that's why it is adjourned.
One.
I'm not hearing any other arguments in this.
and 2 submissions may be taken, your lordship. Please. On the
It's
request.
wasting your time.
On
To
the
advocates
request.
are not understanding why the court has
I'll give it,
no,
I'll give it.
list this matter
But if the copy
in the month of December.
because if the
Your lordship, pass over, your lordship.
Interim order, anything, don't extend the interim.
Your lordship, only 10 minutes, your lordship. Your lordship, I kindly request this honorable court, your lordship.
Without filing that petition, seeking refund of the amount, without serving it on the other side,
Your
you
lordship.
say that no, he will come and argue.
He'll file it and he'll say the
He
argument.
has to file it not before this court, he has to file it before the registry.
I know, your lordship. He told it, he can give me an
No,
instruction.
I'll not hear this
Your
matter.
lordship, 10 minutes, your lordship. Your humble submission, your lordship. Your lordship,
WP
10
14220 of 2024 is reserved. 8.1, delete from the list.
Obliged.
your lordship.
D-link 8.1.
Obliged.
Yes.
Number 12. Varsha Dilip.
My lord, I'm appearing for petitioner, my lord. Arguing counsel is on her legs in the other court. I request for a pass over. It's a humble request, my lord.
I think I'll impose costs for this kind of, repeated,
My sincere
requests.
apologies. My sincere apologies.
Why the other side, they have no other work? And court also has no work.
I understand.
Any next day is there?
What
There's
is their
no
challenge is 13.2. 13.4, now they have filed an application for amending the petition. Not, this can be relegated to DRT. All their contentions can be considered by DRT.
Arguing
Still
counsel,
that 45 days time
arguing
is there for
counsel
them.
is there. We are ready for the arguments today itself, my lord. We are ready for the arguments.
Can't challenge 13.2. 17 only permits 13.4 to be challenged. Basically, the petition itself was not maintainable. Now, on that, he filed an amendment application.
The 13.2 can be challenged before the DRT.
My lord,
Some judgment has seen.
17 clearly says.
There's a
only
discretionary
13.4.
power, my
Some
lord.
judgment has seen. The 13.2 also can be challenged.
17 clearly says only.
No, not about the thing, but some judgment has seen. The 13.2 proceedings also can be questioned before the DRT. Some judgment. Somebody has cited.
Supreme Court also is there, saying that 13.2 is not, we did not challenge it. 13, this is 60 days time to give them to pay them on. There is nothing that coercive steps can be taken. You start taking coercive steps only after 13.4, 30 days are over. So what is there to challenge in a 13.2 notice? And 17 also is very clear. It says that only
13.4 and 45 days time,
So
that
how,
is there. No, but some judgment I have seen about 2-3 days back.
I can produce my lord, writ petitions that 13.2 is not a measure to be challenged at all. Even Supreme Court.
No, when it is said that,
Telangana is-
while questioning 13.4, any irregularities in 13.2 and all can be questioned before the DRT is about the judgment, if I remember correctly.
But I think.
That's what I saw from the judgment.
But it's, under
That all that can be heard by the DRT.
That can be done in 13.4. They have the time to go and 13.2, 13.3 is the remedy. Subsequent to 13.3, 13.4. 13.4 they can challenge. They don't have to challenge 13.2. If they want to
On
challenge.
what ground they're challenging 13.2?
The grounds are different, but at the time of filing the amendment, they raised the MSME ground. At the time of amendment, they raised the MSME.
No, what is the main prayer? Let's see.
MSME, that is the ground.
Then 13.2 they should have responded.
No, we have responded. We have responded to the.
There is this ground of MSME.
Yes, there is a ground.
What is your response to that?
Saying that you have been defaulter for almost 2.5 years. In the representation, they say we'll put the property to sale.
I think these come to their objections.
Restructuring.
Where are their objections?
The application that they have filed is filed on, if I am right, on 23/10. This is their introductory application and 226.
Where is the 13.2, I mean, objections to the 13.3A?
That is annexure E.
Page number?
Page 47, if I'm right.
47. Please read that.
Annexure F, if I'm right.
No, that is not.
That is their. What do they seek there? They seek.
No. Page number 44 is the 13.2, reply to 13.2.
Yes.
We challenge the classification of our account, special mention accounts category.
Your Honor, may kindly see.
MSME status.
Yes. Your Honor, may Lordship may kindly see it. Next page, 45.
No. They have at point number 2, they were mentioning about the financial distress and the MSME status.
Yes.
As per the MSME Act, what is the procedure to be followed to declare a asset as a non-performing asset? Yes.
But my lord, your Lordship may kindly see in that representation, what they seek also is to sell one property. To sell one property. If your Lordship looks at page 45, paragraph 5, if your phase 1 reduce OD limit of 1.75 crores by sale of site number 93. This itself clearly shows that they have no intention to run the company. They want to repay and come out of it. The question of MSME benefit will be only there if they want to restructure it and repay the.
What is the whole purpose of issuing a 13.2 and what is the purpose of the 13.3A?
Well, 13.3A, the Supreme Court has clarified it, clearly saying that they have to produce an affidavit along with documents. Here they do not produce.
But you will say that in your response. What did you say? This can't become a routine mechanical process of 13.2 and 3A. The loan account were classified. They were saying you classifying the loan account as NPA is bad. You should answer to that.
No, we do have answered it. My lord, your lordship.
Please read paragraph number at page 49.
No, that part we have not answered for the simple reason that verifiable material and an affidavit, if they do not produce, just saying MSME will not suffice. The Supreme Court also has clearly said an affidavit supported with documents.
Fortunately, problem with the bank is bank only reads all the provisions one-sided. That are applicable to the bank.
No, here in this case, what I would like to take your lordships in this case is the bank has personally visited the place.
We will read. We will read your response. The loan accounts are classified as NPA as on so and so. Guidelines issued by the you don't take any of their contentions or their objections into consideration.
We have taken, my lord. All the other contentions have been replied.
Please show me from your reply. That I can only understand from your reply.
Your lordship is only on the MSME. Only on the MSME, your lordship.
That goes to the root of the matter.
MSME I can consider is if they produce verifiable documents and an affidavit.
So what you are supposed to say, though you are saying, taking the ground that you are an MSME, no other material is placed on record. So this bank is not, this respondent is not under obligation to consider it. Should be your response.
My lord, let me. We have gone and seen the inventories. Past 2.5 years, there is no business. There is no inventories made. The statement of account has no transaction. The account is, they're not running the firm at all. And keeping all this in mind, and if your honor looks into the representation is not for restructuring. The representation is to sell the properties. They say 3 properties are there. You sell one, permit me to sell one. And what I would say this is, this is a matter which the DRT is competent in to decide this. This court need not get into this.
Yourself for saying that they can't go to the DRT.
No, they have issued.
The other line of judgments are when 13.2 notice is not questioned, and about this MSME thing, if they don't take that contention is not taken in 13.2, later at a later point of time they cannot take that contention also. And the whole purpose of
they have taken.
They have taken. You have to answer. It is your bounden duty to answer to the
13.4. Challenging remedy is available to them. I am not saying 13.4 they have no remedy.
But you have no obligation to 13.3A.
No, 13.3A we have answered. It is not, that is a subject matter which can be considered.
I'm not talking about giving a paper is not called giving answer. Sending one reply is not called giving answer.
The remedy for him, nothing will stop them from proceeding before the DRT.
This is a clear procedural irregularity on the part of the bank. Which will entitle this court to interfere in this case.
I'll file my objections if your lordship wants to.
Of course, it has to be.
I'll file my
You should have filed by this time.
No. I filed my wakalat just now. I received the petition copy today, so I will file my objection.
But I'm making it very clear. Court will all the time, the secured creditor. Because you are in a better position, that doesn't mean that you will bypass all the rules.
Well, past 2.5 years, they're not running this firm. Every time we
you would have told that all this in your reply. Why are you not doing it?
We have answered to the extent of what, apart from the
They
MSME.
have raised so many paragraphs, and you just do it in a couple of 10 lines, and you say it's a response.
Not 10 lines. We have answered with regard to NPA and all the other aspects. My humble submission is this. Your lordship may look into that Swami Narayan's judgment which is come. It clearly says material documents along with affidavit. If they just come now what has happened, my lord, they're all defaulters. They are not prompt in paying the loan. They come here to only see that they get some breathing time. Now even in the writ petition, there is not a single ground on MSME. Your lordship may look into the writ petition grounds, not a single ground on MSME. But subsequently, my lord, they come out with this. But verifiable documents,
No, no,
affidavit.
Affidavit is not properly drafted maybe, but that's what, no, we are not on other issues. What are the grounds in support of the writ petition? We are on the ground, why the procedure is formulated for a 13-2 demand notice and a response from them and your response to that.
We
That
have-
is the purpose. But that you have not done it. It is just a eyewash,
No, my lord,
a formality.
We have answered, keeping in mind that they have not filed an affidavit.
Routine answer is this.
No affidavit, my lord, what happens is the
But you
requirement.
should have said so.
No.
I know any amount of submissions from the bank will not substitute, you can't substitute it in this order.
What I would
That has to go.
My lord, what I would say is this.
We'll put the clock back.
No, this aspect, the DRT can
Please.
consider it. The DRT can.
Now,
Why does
as
why
per
do
the
we-
judgment of the Supreme Court, when and where and how this court can entertain the writ petition in spite of having a alternative remedy. Please tell the court. And according to me, this is a fit case where this court would exercise the jurisdiction and will set aside your 13-2 notice. And this notice itself, and you please let them give all the relevant documents, you consider it. And consequently, if at all any other proceedings are taken up, they will also go.
My lord, what I'm saying is I'll file my objections, I'll produce all the material with regard to the
But
facts of the case.
whatever objections you file,
To show,
it
and
will
whether
not.
this has to be adjudicated in the rejudication. What I am trying to say is, now when I produce materials to show that this is a sick unit from past 2.5 years, there is no,
But
it cannot even be
This court will
restructured.
not consider all those material. We are only concerned with all those materials are with you. When they have given a reply to your 13-2, whatever reply you have given to that is the one which is on record and which they know, which the court can understand. Now, what all there in your office, all the material cannot be the concern. So please follow what is the purport of 13-2 and 13-3A. Without that, we will not entertain any of the petitions. And we will interfere. In spite that, I will record that under though there is
No,
DRT.
I'll file my counter. Your lordship may have it next week. I'll file my counter.
No, what I am saying
Consider
is,
whether this court can entertain. I will raise all those grounds, my lord. Your lordship may consider. According to me, my lord, this court, DRT can adjudicate this matter. It is not that it's a complicated under 226 and interference has to be.
No, because
If
this
they-
is
if
not
they have
a-
a merit,
no.
they will raise it before the DRT.
this is not a
Doesn't stop them.
complicated, this is not a disputed questions of fact not involved. Simple. They say your 13-2 notice is bad for this. You should have said my 13-2 notice holds good. That's the only opportunity they will get. Now, you don't say anything. You don't respond to any of their contention.
My lord, the Supreme Court is very clear. They produce an affidavit with verifiable documents.
Did the Supreme
And
Court
in-
say-
In this case, they don't have to because, my
Did the
lord,
Supreme
they
Court
know for a
say,
fact.
no, did the Supreme Court say whatever are their, whatever is 13-2 you issue 13-4, whatever in between is only a formality.
I'll just take your lordship to one
Please.
paragraph.
Yes, we will read.
I'll file my objection. Next week. we will-
What objections you will be, waste of time?
No, it's not a waste of time.
Because how you can improve this response of yours?
No.
Any amount of documents that are placed before me will not improve this
No, the
response.
Supreme Court clearly says, what
Please
is
pass on the
mandated is an
judgment. Let me
affidavit.
see. What did the Supreme Court say? Because it's all waste of the time from the borrower, from the bank. Nothing else.
One second, my
Yes,
lord.
please read.
One second.
Where is it?
One second. I'll- I'm sorry, my lord. I think they have given you the.
Yes, it has nothing to do with this.
No, I'm sorry. This is the other one.
Please come. The present writ petition is filed
Same.
questioning the,
My lord, I'll file my counter. Give me an opportunity. Let me be heard along with my counter because the bank should
does
not.
this matter?
My lord, it may be taken up tomorrow, my lord.
Tomorrow,
The
I will
request,
some
my lord.
time. Next week, we will not.
I will,
Tomorrow
if
or
you
day
again ask for and make any request, I'll dismiss this writ petition.
No.
Because you have nothing to say in this for asking pass over again passovers. Does this matter? On 11th of November, by that time, if the objections, if any, are not filed by the respondents, the matter will be heard on the merits of it. The learned counsel appearing for the petitioner submits that when the 13-2 notice is issued, they have given a reply stating that theirs is a MSME and for declaring an asset as an NPA, the procedure that is contemplated under the Act was not followed by the respondents. And the respondents have not responded to the same, and in a mechanical manner, they gave a reply to the same. Next para. List this matter on so and so. Yes. Next.
15, Siddharth Suman,
Yes.
serial number 15.
Yes.
My lords, in this matter, notice has to be gone to the bank, my lord.
Huh?
Notice has to be issued to
It
the.
will go. First of all, let's see what is the relief that you're seeking.
Sure, my lord. Please,
From
my lord.
2024, notice is not sent to the bank. So there is no urgency for you.
My lords,
It has come up before the court
yes, my lord.
on 10/7/2024. Court 4/2025 adjournment, 10/9/2025 adjourned. Yes, what is the relief you are seeking?
My lords, we filed for a miscellaneous application, my lords, before the DRT. That application has been rejected. The application was merely for correction of the calculation, my lords. A demand notice had been sent to me, my lords. And with respect to that, there was some calculation. So with respect to that, we had filed an application. However, the DRT has rejected that. They've passed an order, my lords, wherein they've
Go before the DRAT.
My lords, if I take your lordships, my lord, the reason for them for rejecting my application being two grounds, my lord, stating that one, it is being time barred. Second, that the presiding officer has no authority. It has to come before the registrar of officer, my lords. We have judgments to the effect to show that the.
No, same judgments you can show before DRAT.
My lords, it falls. If a date might be fixed, I'll show your lordship as to how the writ petition is maintained.
No. Writ petition, when you have gone to DRT, the DRT has passed an order.
My lords,
and of 2024, without an interim order, you have been happily before this court from the last 1 year. So there is no urgency for you that this court has to interfere in this matter.
My lords,
You
we
can go
have
before the DRAT and
No-
whatever is
no,
the remedy.
No, your lordship, on the previous occasion, what had happened was there was because of time constraint at that point, senior was held up in another
What
court.
about last occasion? This matter come about 1.5 years ago.
Yes, my
One and a
lords.
half year ago. From last 1.5 years, you are not pursuing this matter. When you have an alternative remedy of going before DRT, when you matter pending here from the last 1.5 years shows that there is no urgency for you.
My lords, there is some certain urgency, my
not
lords.
at all.
My
Not
lords,
at all.
if it can be taken up tomorrow, my lords. Your lordship, there
So,
is.
Vignesh Shetty is directed to take notice on behalf of the respondent. Then counsel for the petition should serve the copy on the council. Why notice also can't be ordered to the respondents for 1.5 years? You didn't even seek for it.
My lords, we.
Get instructions tomorrow.
16, V. Mohan,
No representation on behalf of either of the party. Counsel for the respondent is present. No representation on behalf of the petitioner. List this matter for dismissal tomorrow. The 17th.
17, Vijay Raj.
Lordship, in the last date of hearing, your lordship had insisted for Supreme Court judgment pertaining to not to take coercive measures against the home buyers, my lords. Because there are three things which I put against the home buyers, not to take coercive measures. I had referred Moody's Saxena versus Union of India citation. Your lordship had suggested to furnish the Supreme Court judgments. I'm producing the same.
Take that. Yes.
My lords, in this case, as far as the case of the petitioner is concerned, there are three aspects, my lords. One is the tripartite agreement, and one more is the subvention scheme and the liability of the builder. Now, your lordship had made an observation that the High Court cannot pass order on the banks with regard to the recovery proceedings, my lords. I am citing the first citation, Bridgenor Urban Cooperative, Bosch Limited, Bridgenor and others.
You have to be on the point.
On the point, my lords, on the point.
On the point that according to you, the whoever is with regard to this housing thing, they stand on a different footing. That is what is your submission?
No, there are two submissions, my lord. One submission is how the High Court cannot intervene with regard to the functioning of the
That's a
banks.
settled law.
That is
That
what
judgment
they
is
can, they
required.
cannot give any direction with regard to the OTS scheme because they went to Supreme Court. Supreme Court made an observation with regard to any OTS scheme. It is the discretionary power of the bank. The second judgment, what I am just produced a Supreme Court judgment is,
So,
but
according to you, OTS scheme, this court can direct or not direct?
no, this court, this writ petition is very much maintainable because the recovery suit can be initiated because when there is a public exchequer.
No, OTS scheme I'm asking.
OTS scheme, no. OTS scheme, they had given a direction to the High Court that OTS scheme should be considered by the bank. Then again, it goes to Supreme Court. Supreme Court makes an observation that it cannot be considered because with regard to one-time settlement schemes, it is a discretionary power of the bank. Now I come to the second point, my second submission with regard to the second citation. I would like to read only the relevant portion, my lords.
Paragraph.
I have just put the post-it flag. Paragraph number, page number 59, my lords.
59.
59.
What is this first judgment?
The first judgment is pertaining to the OTS scheme, my lords.
Yes.
The first judgment. The second judgment is paragraph number 20.3. Relevant portion I am reading, my lords. It is therefore imperative that the life savings of a common person culminate in timely possession of the promised home. Article 21 would mandate nothing less. In Samatha versus State of AP, this court reiterated the right to social and economic justice, as well as the right to shelter or fundamental rights, encompassed within the ambit of right to life. Similarly, in Chameli Singh versus State of UP, this court observed, shelter for a human being, therefore, is not a mere protection of life and limb. It is home where he has opportunities to grow physically, mentally, intellectually, and spiritually. A right to shelter, therefore, includes adequate living space, safe and decent structure, clean and decent surroundings, sufficient light, pure air and water, electricity, sanitation, and other civic amenities like roads, etc. So as to have easy access to his daily avocation. The right to shelter, therefore, does not mean a mere right to a roof over one's head, but right to all the infrastructure necessary to enable them to live and develop as a human being. Right to shelter, when used as an essential requisite to the right to live, should be deemed to have been guaranteed as a fundamental right. As is enjoined in the directive principles, the state should be deemed to be under an obligation to secure it for the citizens, of course, subject to its economic budgeting. In a democratic society, as a member, the organized civic community, one should have permanent shelter so as to physically, mentally, and intellectually equip oneself to improve his excellence as a useful citizen, as enjoined in the fundamental duties, and to be a useful citizen and the equal participant in democracy. The ultimate object of making a man equipped with the right to dignity of person and equality of status is to enable him to develop himself into a cultured being. Want of decent residence, therefore, frustrates the very object of the constitutional animation of right to equality, economic justice, fundamental right to residence, dignity of person, and right to live itself. And the other aspect is
Ultimately, what is the ratio laid down? Those are all the observations you are reading.
Observations, my lord. And coming to the conclusion.
Observations are not binding on.
No,
the
suggesting for future reform.
So ultimately,
And coming to paragraph number 22, my lords.
yes, that's what is the ratio.
Paragraph number 22. Before parting, we observe that the right to housing is not mere a contractual entitlement, but a facet of the fundamental right to life under Article 21. Genuine home buyers represent the backbone of India's urban future, and that protection lies at the intersection of constitutional obligation and economic policy. Through these directions, this court seeks to restore faith in the regulatory and insolvency framework, deter speculative misuse, and ensure that the dream home of India's citizens does not turn into a lifelong nightmare. Now I come to the last judgment, my lords, which I have produced before the Honorable
So,
Court.
first of all, you summon up. What is your judgment? How this court has to consider?
My lords,
your proceedings are arising out of this surface.
Yes.
And this is something
No, my
the
lords.
court is referring
That
to.
is the clarification which I am giving to your Honorable Lordship, is that why a coercive measure cannot be initiated is my submission.
No, that is like you are somewhere, you are taking some line here and there from some judgment and you say that it will apply here.
Buddhi Saxena versus Union of India is very much maintainable, my lords, because it has been passed with the coordinate bench of this Honorable High Court.
Yes.
And in that case, it has been clearly specified that no coercive measures can be initiated when the position has not been handed over. Because the submission scheme, I've already produced RBI guidelines. As per the RBI guidelines, it is the liability of the builder either to complete the project or to
If both of you have any contractual obligation or you have a consumer.
No,
and
that is what,
go before the appropriate forum.
No, my
not
lord, I am
before-
producing the citation to make, to make a submission to the honorable court. It cannot be rejected by stating only it is a contractual obligation. Because I am coming to the next judgment, that is again the super tech developers in the Delhi High Court would reject the said application stating that it is a contractual obligation.
Yes.
Then it comes for Supreme Court. The Supreme Court makes it, I would just read the relevant paragraphs, my lords. At paragraph number 5, page number 72, my lords.
Yes, yes,
Yes.
please.
Agreed by the banks claiming monthly installments from them, home buyers approached the High Court of Delhi for a writ of mandamus internally directing, among others, Prayer A, the banks to charge EMI, pre-EMI payments from the builders come developers, not the home buyers. 2, to refund the already recovered amount to the home buyers and recover it from the builder come developers. And 3, the RBI to take strict action against the bank. Parallelly, some home buyers approached the real estate regulatory authorities and various consumer fora for relief. The High Court, by a common judgment dated 14/3/2022, dismissed the writ petition owing to alternate remedy available before the real estate regulatory authority. This is judgment passed by Delhi High Court. They challenge before Supreme Court. Challenging the same, the home buyers have approached this court. The home buyers allege that since the subject matter of the writ petition concerned public interest and thousands of home buyers, the writ petitions ought not to have been dismissed by the High Court. Almost 70 to 80% of the loan amounts were disbursed by the banks to the builders come developers as first tranche, despite project milestone not being achieved. And the bank and financial institutions violated several provisions of 2013 RBI guidelines when dispersing the amounts, as dispersal was done without any form of due diligence on behalf of the banks. Now, what the Supreme Court had given direction, my lords, at paragraph number 10, my lords, at page number 74. This blatant disregard and ignorance of the court's directions, coupled with the reluctance in appropriately assisting the court, hints towards a possible collusion between the builders come developers and the bank financial institutions. In such circumstances, it may be necessary to constitute a special investigation team to uncover the nexus between the bank financial institutions and the builder come developers. With respect to the development projects where the home buyers have paid substantial amounts and where the development projects have not even been launched, have not been completed construction or have to begin construction. Para 12, the Standing Counsel for the Central Bureau of Investigation, in short CBI, is directed to remain present in this court on the next date of hearing for the purpose of constituting an SIT. He may also have instructions as to why the CBI should not be asked to register a case and then proceed to investigate the nexus between the banks and the builders. Alternately, constitution of SIT at its own will also be considered by this court. Now, after this matter again, it was subsequently listed on the subsequent date, my lords. I would like to, because it has been showing as 18/3/2025 list the matter. This is subsequent date which the matter got listed, and the CBI had was present before the Honorable Supreme Court, and action was taken. And at last, this special petition also was allowed by the Honorable Supreme Court of India, my lords.
Yes.
There are about 1,200 home buyers, my lords. 1,200 home buyers had a similar kind of issue with a tripartite agreement, because now it has become a day-to-day activity of the builders, my lords. They take up the project, they have a subvention scheme, they take the RBI guideline, they have misused the RBI guidelines which has been given. They take the entire disbursement amount, and the home buyers are getting penalized, my lords. I have a similar case also which has been filed before the coordinate bench in WP 4195 and 4634. Similar case where the stay has been granted by this Honorable Court, my lords. My submission before this Honorable Court is they have contravened all the RBI guidelines. And it has been made clear from the petitioner insofar as the loan is concerned.
The proceedings initiated by the bank.
I am appearing for the only Union of India. There is nothing
Which is the
as a-
bank?
Bank is HDFC Bank, my lords.
Who appears?
HDFC. I'm not.
Who appears for HDFC Bank?
Francis?
Xavier.
Francis Xavier itself.
Huh?
Francis Xavier.
Oh,
There are about 60 petitions, my lord, similar matters which are pending and tagged and heard together. There is a coordinate bench order also, my lords. It's Francis Xavier who's appearing for all.
let him appear. So and so takes notice on behalf of the respondent bank. Petition shall serve the copy of the same on the council.
The interim prayer stay be granted, my lords. Because the way notice.
Please serve notice on him. Whenever you want, I will grant, but without hearing him, I will not grant any interim.
Much of it. Let the date be given, my lords.
When you can serve the notice on him?
I will, if the, so I-
Basing on that, I'll grant the date.
if the leave of the court, I can serve upon the HDFC.
So and so is directed to take notice, and the petitioner shall serve the copy on the counsel to the respondent. This is
For,
matter.
for HDFC Bank, my lords, because
HDFC Bank.
Ah.
This is matter on 14th of October.
14th I have a matter, my lords, because 14th and 18th I have matters. Any other date, as per your lordship, my lords.
On 17th.
17th, much of it.
Yes, next.
18?
Apologies, my lords. 8 I was.
And,
You don't file
and-
the
and
application.
I-
Sorry, my lords.
I shall be.
Ask for a passover.
I'm sorry,
You won't be present before, and I will not take that. You file it in
I'll
the
file it,
register.
any date may be fixed for that. That's all that I request. I'll file it in the register. I'm very sorry.
And I shall be at liberty to take notice for the other respondents right now.
Yes,
Yes, much.
yes, 19.
8, any date.
18? Girish Raj?
Lordship.
For whom? In 28835, 18. What is it that is questioned?
Lordship, the petitioner, Lordship, challenged the annexure D, Lordship. Annexure D, Lordship, the first petitioner is the borrower of the loan, Lordship, and the second petitioner is the owner of the property, Lordship. By mortgaging the property belongs to the second petitioner, Lordship. The first petitioner obtained 5 lakhs rupees loan, Lordship. And on 18 to 2025, Lordship, the respondent bank issued a demand notice under section 13(2), Lordship. Thereafter, on 12/5/2025, Lordship, they.
Who are you?
Lordship.
You're a guarantor.
Lordship.
You're a guarantor.
Lordship, guarantor as well of the owner, Lordship.
That's what, you have a guarantor and you have mortgaged the property.
Please, my lord. The property granted to the second petitioner under the Australia scheme, Lordship.
Hmm.
It is a small house, Lordship. The petitioners are residing in the same house, Lordship. With the
What is outstanding?
outstanding is now, Lordship, they obtained order from the court, of Principal Senior Civil Judge and JMFC Ramnagar for 6,79,000. We are ready to deposit 2 lakhs, Lordship, in the connected writ petitions also, Lordship, the Government bench of this honorable court, Lordship. By staying the impugned order, Lordship.
I will not stay, I will not grant any of it, any outstanding amount. When are you ready to pay? An undertaking shall be filed before this court. As per the undertaking, I will dispose of. Because there are no merits in this writ petition, you are only on the ground that you are ready to pay.
Lordship, within 8 weeks,
Come
Lordship,
up
I'll-
with an affidavit and give the other numbers also.
Please.
In all other matters also, you please file. What are the numbers?
Another writ petition is 6960 of
Give it to the court officer. In all those writ petitions, you have to come up with an affidavit. When are you going to pay the amount? On
Please.
that, we will dispose of the matter. No stay.
It is a small amount, my lord. We will ready to clear
all the
the
matters.
entire loan amount, my lordship.
Instead of keeping it pending, I'll learn counsel for the petitioner submits that. And the section 14 notice is in challenge before this court. It is submitted to the outstanding as per the same is 6 lakhs and odd, and they are ready to pay the amount. It is submitted that there are other, how many matters?
One matter, my lord.
Only one matter.
One
There is
matter.
another matter where this court has granted stay on the condition, the coordinate bench of this court has granted stay on the condition that the deposit
Deposit of 10% on demand.
or 10% of the demand amount. Then counsel submits the same order may be passed in this case. The petition has questioned the opposition notice issued in section 14 of the Surface Act. The only ground that is stated is that he is ready to pay the entire amount. In those circumstances, the petitioner shall file an affidavit before this court. How much, within what time he is ready to pay the entire outstanding amount. Basing on that, the writ petition will be disposed of. The list a connected matter also along with this. In the connected matter also, the similar affidavit shall be filed. When can you file?
Next Monday, my lord. Till then, kindly be not disturbed.
Don't take any coercive steps until Monday. I'll list this matter on 11th of November. Learned counsel, who is the counsel?
P. Suresh.
Huh?
P. Suresh.
P. Suresh is directed to take notice on behalf of the respondent bank. They shall not take any coercive steps till Monday, till the next date of hearing.
Much less.
19 urgent, 20. Rajesh P.
My lord, for the petitioner, kindly maybe taken day after tomorrow, my lord. Senior is on his legs arguing in the other court. I request you.
This is the matter
20.
on 18th of November.
21. Jagdish.
Yes. No representation for dismissal tomorrow. 22.
22. Abhinav Ramanand.
There's also no representation for dismissal.
23. Vinod Prasad.
Yes.
The petitioner has obtained the loan under Chief Minister's
What
self-employment
is
program.
question? Let us look
He has
at
taken
your,
5 lakhs.
let us look at
Your
your prayer.
page,
Prayer.
Annexure M, my lord, page number 76. My
Page
position-
number?
Page number 76. my lord.
This is a prayer.
Please, my lord, prayer. Annexure M, page number, my lord, 11 is a prayer, my lord. Page number 11, issue writ of mandamus quashing the position notice issued by the respondent bank.
Position notice. What is the outstanding amount?
My lord, it is
well, this is not the, that case is still pending.
10,45,425.
10 lakh.
45,425.
What is the property mortgage?
Now they can't mortgage. Kindly, the
House property.
My lord can find it page number 77.
my lord, annexure F at page 22 for a moment kindly be looked into.
Yes. On what ground you are before this court?
This is from the bank to the petitioner. Last page, annexure of page 27. Security, hypothecation of stock machinery estate. Since this Chief Minister self-employment scheme, and earlier page, my lord, they are getting bank subsidy of 1,75,000.
According to you, you have not mortgaged the property.
I could not repay the loan for the reason that I am a new entrepreneur. That apart, I have no fixed customers. This agarbatti only for 6 to 8 months. Then due to COVID, it's 17. Then only stock in trade.
No. Whatever are the reasons for.
No, I could not pay.
You have not paid.
There are outstanding
What outstanding
amount.
is 10 lakhs. So why are you before this court? What is that you are expecting from this court?
My difficulty is having initiated the civil suit, having said that is Chief Minister's self-employment scheme, they could not mortgage the property. It is Khadi and Village Industry that has sponsored them, and they have granted the loan in pursuant to that. Now they have taken subsidy of the 1.73 lakhs. If they have not taken the subsidy bank, then they should again intimate Khadi and Village Industry Board. And what they should do, they should give advice to them. Because I'm a new entrepreneur. Now having filed bank suit or a regular civil suit, when still it is pending, can they pursue parallel remedy?
Mortgage rate, my lord, page number 23. My lord, senior is making submission before this honorable court. I filed a suit before the court immediate below, that is for recovery of money at page number 78, annexure N.
For the very same amount.
Very same amount. There is no bar for me, my lord. Here, my lord, either I'll go before the DRT, that is more than 20 lakh. In the transfer, my lord, paragraph number 53, it is very clear. There is no bar for me, my lord, to initiate action both, either Surface Act as well as, my lord, the defect or, my lord, recovery of money. Here the case, For recovery of money, I filed a suit before the Milord Mysore, Milord at the civil judge JMFC at Chamarajanagar. In addition to that, I initiated surface action. There is no bar for me. It is clarified in the Honorable Supreme Court in the case of transfer. Therefore, now, Milord, now they assigned the 13-4 Milord before this Honorable Court. Either Milord, they have to go before the DRT under section 70, or Milord, they have to undertake before this Honorable Court. I am going to pay within this much of time. Milord, now Milord, this contention saying that they already filed a suit, Milord, Milord, it will not hold any water. The reason is this issue has been already dealt by the Honorable.
I understand their difficulty, but now question is, when the government says only hypothetical stock in trade and machinery which they have given, when still it's available, how can they mortgage the property?
You have mortgaged it. Now you can't question all this.
Yeah, understood. Because of their pressure, I have mortgaged.
No,
That-
we will not go into all
that's
that.
all-
What is the pressure
that's all
between
my
both of
submission.
you? Now, only thing is, if you want this court to interfere, only you have to, a timeline when you're going to pay. Otherwise, I'm not going to interfere.
Party is in trouble, that much I can say. But
what the
that
court
I
can-
understand.
court can-
But my only question of law is, can they pursue parallel remedy?
Yes.
Having disowned or having,
Give him the
Transport,
judgment.
Milord, I'll pass on judgment, Milord. Transport. It is very clear, Milord, paragraph number 53.
may 2 days time accommodation, I ask the party what he wants to do, day after tomorrow.
Tell him that unless and until he comes out with any payment, I'm going to
I understand.
dismiss the writ petition.
Day after
Yes,
tomorrow.
yeah, tomorrow. Yes, 24.
24, Madhuar.
Not this petition.
My lords, there are 3 loan accounts, my lords.
Passed out matter. No. Is it dealing, not to dealing, 8 and 8.1. This both the matter. 12 till 18.
Handshake.
Yes, which is the one?
13-4, my lords. Page 9, my lords, is the prayer.
13.4 is question.
13-4 is question.
On
my
what
lords.
ground?
My lords, on the ground that after the demand notice, my lords, I've paid the substantial amount, outstanding amount with respect to 2 loan accounts, and the respondent bank has issued the letter stating that the account is closed. All I am asking is that, my lords, the loan amount is 7 crores, my lords. Let them come up with the amount to regularize my account, my lords, loan account. No, my lords, that is what they have suggested, my lords. My instructions is that they are asking some 45 lakhs to regularize the 1 loan account, my lords.
Why they will not tell the borrower unless they come to the court? What is the amount that is
My lords,
required
my
for
apprehension is that, my
regularizing
lords,
the account?
my apprehension is that, my lords, this is the commercial property, my lords. I don't know when they will take, my lords. That is, I'll file the affidavit to that effect.
What is the
Lords, after
outstanding
the-
amount as of now?
Lords, after the demand
15
notice,
crores outstanding amount.
7 crores 32 lakhs is what they are stating, my lords.
Yes.
After the demand notice, my lords, they have issued the possession notice with respect to all the 3 loan accounts. Substantially, I have made the payments also, my lords.
What is substantial? After substantial, what
No,
is
my
the
lords,
outstanding?
after the demand notice, I have made the payments, my lords, where they have issued the letter stating that the 2 loan accounts with respect
After
to
paying the substantial amounts according to you, what is outstanding?
outstanding is, according to me, 7 crores, my lords. In the possession notice, they have included, I mean, that loan accounts also, my lords. That is the reason. My lords, they have suggested 45 lakhs, my lords. I'll file an affidavit to that effect.
45 lakhs is a final settlement.
No,
for
my
7
lords, to
crores.
regularize the loan, my lords, I cannot pay 7 crores straight at one go to regularize, my lords.
Is it so? Who appear for the response? Who is the counsel? Where is he?
I'll receive the notice, ma'am.
Mr. V. Suresh is there to take notice on behalf of the respondent bank.
Kindly direct them to furnish the copy.
The petitioners have served the copy on the counsel for the respondent. This is matter on 6th of November. By the time the learned counsel for the the learned counsel of the petition submits that. If you pay 45 lakhs according as per his instructions, they are ready to regularize the account. There is a counsel for the respondent shall get instructions in this regard. This is matter on 6th.
Lords, until then, let them not take any
They
coercive
will
steps.
not, but what till 6th,
Grateful,
what they will
lords.
take?
That is the
After
only apprehension.
34, there
That is
is
the
no
only
way.
apprehension I am before this.
6th only. We will hear it on that day.
25, Narendra S.
For response.
Order passed by the 42nd ACM, my lord, for taking possession is under challenge, my lord. Outstanding amount,
What is that?
annexure G is under challenge, my lord. Order passed by the land magistrate.
What is outstanding?
Lord, 30 lakhs is the outstanding, my lord. Petitioner is ready to pay.
Huh?
Petitioner is ready to pay the outstanding amount, my lord. He'll file an undertaking affidavit also, my lord. Some breathing time may be given for that, my lord. I may narrate in the affidavit and consultation with the bank also, my lord.
Today outstanding is around 40 lakh.
40 lakhs.
My instruction is 30 lakhs, my lord. As on 31,
Their instruction
Please.
that will prevail.
please. 31/10/2025, 30 lakhs is the due amount. My instruction is the bank manager has WhatsApp the outstanding amount to my client. As per the instruction, I'm submitting before this annual court, my
What
lord.
is the breathing time he wants?
Lord, 6 months is equal installment. He is going to close down the entire loan account, my lord.
After obtaining interim order, 1.5 years they have enjoyed, my lords.
I have
Only
fi-
6 lakh is being paid.
That's what is happening.
I have filed NOC vakalat.
Already, no. It's not about NOC.
I'm
Your
sorry, my
client-
lord.
Your client is there.
Please,
So
please.
from 2024 till now, you already have the enough breathing time. No further time is required. So let your client file an affidavit. We will not grant 6 months. If he's ready with 3 months, that is also on the higher side. But still, if he's ready to pay within 3 months, we'll pass an order. Or else I'll dismiss his request.
Would it be 4 months, my lord? I'm request my honor.
Come up with an affidavit.
I'll file the affidavit,
list matter on 10th November. By the time you should file an affidavit.
Please,
before
please,
this
my lord.
court. Then counsel for the petition submits that within 4 months, the outstanding amount, the entire outstanding amount will be paid, and they will file an undertaking before this court. That with undertaking before this court. According to the petitioner, it is 30 lakhs. According to the respondent, it is 40 lakhs is the outstanding. As per the instructions of the bank, whatever is the outstanding, the petitioner shall file an affidavit. List is affidavit by 7th, by serving the affidavit of the counsel for the respondent. List this matter on November 10th. By that date, if the affidavit is not filed, on that ground, the writ petition will be dismissed and no further time will be granted. Next
May I
one.
seek instruction, my lord? Bank may communicate the outstanding amount so that I can file the affidavit.
Bank shall communicate what is the outstanding
Please, my
amount
lords.
by tomorrow.
Please, my lord. So that I can fill it in the affidavit, my lord. Please, my lord.
26, Varshita, yes. Varshita?
Please, my lords, I am appearing on behalf of the petitioner in the matter. Your Ladyship, on the last date of hearing, there was some confusion between the learned counsel for the bank that no email has been sent. My lords, we have already sent an email. We have received a reply from the respondent bank also. There is some discussion going on related to the final amount of proposal, my lords,
My lord,
for which
No,
we
my
have
lord.
also been given an affidavit format which we need to fill and submit to the bank, my lords.
My lord, in fact, on the previous date of hearing before the coordinate bench, he had specifically made the submission that they have already made proposal. In fact, they made this
Yes, Your Ladyship.
after that date. After that date, to which we have specifically asked them to, we've responded to it and asked them to give a specific amount. My lord, there is no such, my lord, unless they actually produce a letter mentioning a certain amount, because the dues are more than 5
My
crores.
lords, 3.5 lakhs has already been proposed to them in the email. My lords, let my learned friend make correct submissions.
You have to come before the court. They can't, because you are not understanding when she is submitting.
My lords, my apologies. My lords, may give me any date. I belong to Delhi. My lords, may give me any date. My lords, it's a wedding in my family today.
No, I will list this matter next week. By that time, you
My
have.
lords, not next week. My lords, there is a wedding going on in my family. My lords, may list it in the end of the month if your roster allows. My lords, my humble request.
No.
My lords, there is a wedding, my brother's wedding. My lords,
Please appear.
My lords, till
Appear
12th.
online, produce that online, whatever is the proposal, produce before this court.
Leadership, I'm ready to come and depose before your leadership in physical. My lords, only humble request is, my lords, may keep it.
Why you have to come? You can.
My lords,
You are
my lords, may keep it on. My humble request is, your ladyship may put it on 20th of November. I will be there physically before your ladyship.
I'm, Mr. Counsel, please understand. I am asking you, where is the proposal? Why should we wait?
My lords, it's on a mail given to the. We have it on email, your ladyship. It is only unfortunately that I could not be present before your ladyship physically today.
Please send your.
Lord, in fact, my lord, may kindly see, I produced that mail, my lord. I produced the mail. The first page.
I will also assist your ladyship with the dates of the email.
2 and 3, my lord, is the mail, my lord, which they have produced. And this is a very detailed mail rate saying all, quoting RBI guidelines, all that. To which, my lord, we have specifically responded at page 4. We acknowledge the receipt of your communication, my lord, and we advise you to submit a formal letter clearly
This is
stating the
matter.
final settlement.
Request of Learned Counsel for the petitioner on November 20th. By that time, the petitioner shall approach the bank and shall give a,
Very
approach the bank in person and shall give
Very
a,
well.
the proposal to the bank, and
Please.
this proposal should reach the bank by 11th of November. And
If your ladyship may permit me,
by 20th of November, the bank shall come up with what is the amount that is agreeable to the
right.
bank, the settlement.
My lord,
Yes.
specific, my lord,
If your,
specific.
my lord, if your ladyship may permit me, I wanted to put forth one fact before your ladyship.
Offer, my lord, specific offer.
Petitioner shall come up with a specific offer quantifying the amount.
Yes.
But yes, your ladyship, if your ladyship may allow, my lords, I wanted to put forth one point before your ladyship. My lords, why they email dated 28th of the last month, we have already proposed them for an amount of 3.5 CR, my lords, for which we have received an email. Alongside that, we have received a performa to be filled and given to the bank.
You cannot entertain this writ petition, and above all, if you want to, make all these kind of submissions, then the court is left with nothing but to dismiss it.
My
So
apologies.
please,
Because I'll come on 20th and I'll clarify to your ladyship.
yes. Next.
27.
Appealing for the respondent. my
Anantara.
lords. The account has been settled, my lord, so it is infructuous.
It is settled.
Yes, my lords.
Learned Counsel appearing for the respondent bank submits that the dispute is settled between the parties and the account is settled. Hence, considering the submission of the counsel appearing for the respondent finance company, the writ petition is dismissed as infructuous. Yes, 28.
28. Sanjay Prabhu.
28, I appear for the respondent, not on the previous date.
Yes, yes, I remember.
Lord, ready with the undertaking affidavit. Undertaking affidavit to close the loan before that 25th March with the schedule.
Yes, yes, take it. Do you have the copy of?
I was just
I think it can be.
I'll have to seek instructions regarding this. However, since the petition has become infructuous, it may be disposed of, my lords, and any other representation.
No, ultimately bank wants money and they're filing an undertaking. Even one installment is not paid. That is on 28/11/2025. Immediately you can proceed. So what is the instructions you want in that?
Very well, my lords. That may be.
Any of the installments that has been stated in this undertaking affidavit, even one installment they are at default, well, you can proceed. That's what I'll, yes, please come.
In the initial stage of surfacing, initial stage, 32.
The writ petition. No, what will happen is, if you do not comply with any of the undertaking, they will proceed with the.
Please, I am available.
The present writ petition is filed, seeking a writ of mandamus, directing the respondent to consider the reply given by the petitioner on 6/8/2025 for the demand notice. The facts of the case are, the petitioner has obtained a overdraft limit facility for an amount of rupees 15 crores by hypothecating the stock, book debits, and 3 properties. The director of the petitioner's company had closed account maintained by them with ICICI Bank by paying a sum of rupees 30 crores. The petitioner had availed a term loan of rupees 32 crores 80 lakhs by mortgaging some other properties. It is stated that the petitioner is regularly servicing the loan account. And recently, the respondent bank issued a demand notice by wrongly classifying the loan account as a non-performing asset. A demand notice was issued to the petitioner under Section 13(2) of the Surface Act. The petitioners have replied to the demand notice and had requested 90 days time for closure of the loan account by selling the house property and some other property which is not the security given to the bank. The property available as a security for recovery of the dues of rupees 15 crores is only worth rupees 4 crores, and the petitioner has undertaken to close a loan of rupees 15 crores in entirety without asking for any discount. Earlier, writ petition 17196 of 2024 is filed before this court, filed before the coordinate bench of this court. Where is that order?
Election H, not with regard to this loan, the State Bank of India loan.
That is not relevant. You struck it off.
And the next para also, my lord, therefore the loan available at HDFC 86 crores was closed. That is, this is just to, my lord.
It is submitted that in spite of a representation that is given to the bank as a response to the 13(2) notice, they have failed to consider the same. It is submitted that when the petitioner is ready to clear the entire loan amount, the ought to have granted a reasonable time to the petitioner, as he is not seeking any reduction on the amounts. In this matter, on 9/10/2025, order discloses that the land counsel the petitioner seeks for and is granted a week's time to make a submission as to what amount would be paid to the respondent and by what time. And the interim order that is granted earlier was extended, where the court that no notice shall be published under the 13(4) of the Surface Act. When this matter came up before this court on 28/10/2025, this court has recorded that the submission of the counsel for the petitioner that by 3/11/2025, she will come up with an undertaking affidavit within what time she is going to clear the outstanding, the petition is going to clear the outstanding amounts. Today, and the matter is adjourned to today. Today, when the matter came up, the counsel for the petitioner has placed before this court the undertaking affidavit. And as per the undertaking affidavit, she is ready to pay 15 lakhs as per the
15 crores.
as per the schedule mentioned below. This undertaking,
My lord,
there is
if I
a
may.
schedule. Please extract it.
Lords, if I may, the outstanding amount as mentioned in the 13(2) notice is 15 crores 16,82,710. However, the undertaking
With the
affidavit only mentions
last
15 crores.
installment, I will
No,
clear.
what I'll say is, in the last installment, the bank should indicate what are the other outstanding, and in that will be cleared in the last.
Very
Below, it is submitted that in view of the same, the petition may be disposed of. directing the bank not to take any coercive steps. And as the petition is ready to pay the amount by 25/3/2026, Land Council appearing for the respondent bank submits that the outstanding is as per the 13-4 notice, the
13-2.
13 to
two
notice.
notice, 15 crores.
16 lakhs 82,710.74.
You have taken so and so. Land Council for the petitioner submits that in the last installment dated 25/3/2026, as per the bank, whatever is the outstanding, they would be clearing the same. In the light of the undertaking affidavit that is filed before this court, the writ petition is disposed of in the following manner. One, as per the affidavit dated 31/10/2025, as per the schedule mentioned therein, the petitioner shall pay the amounts. Number two, if there is any default of any one installment, the bank is at liberty to take further steps, further steps under the Surface Act. With regard to any outstanding amount, the bank shall inform the petitioner within 10 days from today, and whatever the amount above what is mentioned at for the month of March, that amount shall be added in the said installment, and the petitioner shall clear the same. Accordingly, writ petition is disposed of, directing the respondent not to take any proceed further in the light of this arrangement.
Kindly apologies. The last but one para. Last but one para. Not very properly, it is the bank should give a 10 days notice. Within 10 days, bank has to give us what is the outstanding amount.
Outstanding is at above 15 lakhs.
Above 15 lakhs.
That's
15
what.
crores.
15 crores.
Please.
Yes, next.
29 withdrawn, 30.
Yes.
From the respondent bank in this.
Petitioner, my lord, challenge the sale notice, and there is a substantial amount EMI also they have been paid. Some fund it is we are arranging. We had asked for some time with the bank. Bank has not agreed, and we have come to the court.
Outstanding.
My lord, 66 lakhs 18,970 was outstanding. 970 according to the sale notice which they are given, and they have come out with now 79 lakhs.
78. There are two loan accounts.
Because it won't stop there.
I know, my lord, when they want to charge me legal notice and all the other things, limit is sky, my lord. They are charging such a huge amount, and I'm not able to understand where is the charges it's going on. And I have taken 90 lakhs, and further I have not got a moratorium time, because at the COVID time I did not pay 6 months EMI. They gave me another loan, my lord, with the same property, and they made it out.
Only interference by this court is.
My lordship, I may require some time. Stay may be given, my lord. I will settle the entire amount. I have asked for 4 weeks time, my lordship. And sale is tomorrow. If it is, my lordship, I right now I am not aware of this affidavit, my lord. Otherwise, I would have been filed, my lord. Maybe tomorrow I will file it, my lordship. Stay may be given. Tomorrow is a sale, my lord. If it is not there, my lordship.
Once the sale notice is issued, question of redeeming the mortgage is no more available to you.
My lordship, I have also paid a substantial amount. I keep paying, my lord.
In the light of the Supreme Court judgment.
My lordship, I completely am aware of that, my lord. This honorable court has jurisdiction to give a stay for 4 weeks. My lordship, if it is given, I can save my property. Otherwise, my lord, my children, my wife, and my parents are all investing this in this property. I wanted to save my property based on that. I command. Though they are given a stale notice, I paid the substantial amount, my lord. My intention is to clear the payment, my lord. I am not cheating, and my property is worth of 2.5 crores according to their calculation. My calculation is 3.8 crores. It is of the property cost. And my lord, the time may be given. If it is not there, my lord, my entire generation investment it is in this property. And I have also kept one property for sale. That is and it is because the e-Khata has not been issued for that. Based on that, it has been delayed, my lord. Few weeks a time, my lord, I may be able to save my property, and I am going to pay the entire amount, my lordship. There is a span of time, my lord. If stay is given, I will be saving my property, and that is,
If you're completed, then I will tell you something.
well, lordship, I completely bow head, my lord. If it is,
No, please understand. By granting you time, by paying the entire amount, if this court can pass some order, the court will definitely pass. Now, I will ask you to repay the entire amount. Now, they've issued the auction notice. Now, they will come up with saying that, no, once the auction notice is issued, as per the Supreme Court judgment, as per the amendment, there cannot be any redemption of mortgage. Once there is no redemption of mortgage, if you pay the amount, what is the purpose that's going to be served? We have to pass order as per the settled law, as per the judgment of the apex court. And exercising any jurisdiction or passing any order contrary to the judgment of the Supreme Court, you will be the person at loss. Ultimately, neither you get the property or you have to shell down the amount. Two things will happen.
my lord, this time, if my lordship grants, then I'll be saved, my lord. This is my humble request. And it is, that bank is not agreeing for negotiating. Even yesterday we had gone there, when Saturday.
I have issued a sole sale notice
Right.
already.
My lordship,
These things you have done much before the sale notice.
my lord, this is continuing from long time, my lordship. I wanted to settle the amount. I have paid enough money also. I am keep paying it. I have not stopped paying the money.
I'm telling you, in the light of this law, the hands of the court are tied. Now, what happens even if you pay the money? That is disadvantageous to you. That is disadvantageous to you. Now, neither you have the property nor the money.
My lordship, this one time I may be given, my lord. I will clear it because I will save my property, my lord. That is,
How will you save?
my lord, I kept one property for sale. That is going to happen. Because of that only, this is delayed. If e-Khata is,
May, my lord, the last lordships may kindly see the 13-2 was issued on 13/7/2024, 1 year before. Symbolic possession was taken on 10/7/2024. The outstanding is a 79 lakh. What my learned friend is saying that he has kept the property for sale, he has kept the property for sale, he has produced the sale agreement. Your lordships may come to the sale agreement. What my
No,
learned,
if he pays the amount, will you redeem the
no, in
mortgage?
fact, he is not selling his property.
Asking you, if he pays the money, you will redeem the mortgage.
If he pays the entire amount, I need to take instructions. Only thing, if he pays the amount, bank is not interested in the property, my lord. The bank is interested
No,
in
every
the
day in and
recovery.
out, you people are coming for the court and giving the same, making the submission that no.
With regard to this, my lord, as of now, on the last occasion itself, I pointed out that till the last date of hearing, there was no bid which has been received by the bank. Now also I have confirmed that no bid has been received in respect of the property. The property is put for auction tomorrow. 5 p.m. is the last.
But you have
time.
not received, it has to be before day you receive.
Pardon me, ma'am?
Before the, one day before you
One day
receive.
before. The last time for submission of bid is today at 5 p.m.
You have not
So far,
received
we
till
have
now.
not received. On the same thing was submitted on the last occasion also. Your lordships asked me to get the instructions with regard to the conduct of
No,
the party.
tomorrow.
Conduct of the party, my lord.
I'm not passing any order.
No, my lord.
You
I
don't
would like to bring one.
I am not passing any order, so you don't worry. Your submissions are not required at this stage. Please find out from your bank. Now, whether if the petitioner is granted some time in the sense 3 months, whether the bank will redeem the mortgage.
3 months, my lord. 3 months. If we, my learned friend said 2 weeks. What is say to close the entire loan? What is submission is?
2 weeks. He said.
2 weeks. What is said during the
four weeks for a substantial amount. I'll object, my lord. Only one.
No substantial amount has been paid. If my learned friend keeps on saying that, on the last occasion they have filed a memo.
This matter
Out of
on 11th of November, by the time the petition shall file an affidavit before this court, within what time he is ready to pay the entire amount, and the learned counsel for the respondent
shall
get instructions. Whether the bank is ready to redeem the mortgage after the notice is issued, auction notice is issued, provided the amounts are paid by the petitioner. Yes.
much.
List number 3, serial number 1, Hanumantarayappa. List number 3.
The present RPSC is filed agreed with the orders passed in I number 6 in criminal miscellaneous 434 of 2021. Office has raised the maintainability in view of section 19(4) of the Family Courts Act. Office objections with regard to the maintainability are upheld and the writ petition is dismissed, giving liberty to the petitioner to file an appropriate petition within 15 days from the date of, within 1 week from the date of receipt of the copy of the order. The registry shall return all the papers for the statistical purposes. The writ petition is disposed, the RPFC is disposed of. Yes.
Two urgent. Seal number 3. Umashankar.
Petitioner, your lordship, on this matter. Lordship, till,
Non-filing of acknowledgement having period arrears amount.
lordship, till day, your lordship.
We have
will pay the
cleared,
amount.
Yes, clear.
Yes, ma'am.
Lordship,
Then
kindly-
shall we dispose of?
Yes, ma'am.
kindly-
Argue.
Lordship, kindly pray for week time, your lordship.
Why it is going to be dismissed?
Senior, your lordship, in this.
This is matter on 20th November
Please,
at the request of land counsel the petitioner.
Number 4. Abhinav Ramanand.
Non-filing of acknowledgement.
I'm placing on
you
record.
filed.
I've paid it.
Where is the other side? A memo is filed stating that the, as that he is continuing to pay 7,500 per month. Memo is taken on record. No representation for the respondent. This is matter in the month of December.
Interim order.
From order earlier granted is extended till then. Yes, 5.
Obliged.
5.
Appear for the petition in this case. My lord, trial court, my lord, has ordered rupees 9,000 as maintenance towards the wife, my lord, respondent. My lord, the case of respondent is that the petitioner is the husband, my lord. The case of the petitioner is that marriage has taken place in the month of April 2022. The respondent stayed with him for gap of 2 months, my lord. Thereafter, she deserted and she started residing in a parental house, insisting the husband.
What is your financial capacity?
My lord, financial capacity, my lord, he is a diploma holder in civil engineering. Previously, he was working. He was getting 25,000 rupees as salary, my lord. Now, due to the disability of both the eyes and left leg, he has left the job and he is no more working, my lord.
What
In
is
fact,
the disability
document
to
was,
the eye?
please, my lord,
What is the disability to the eye?
please, my lord, I have, in fact, the document was marked as annexure R1, page number 58, my lord. My lord, the disability is shown as 40% to both the eyes, page number 58 of my petition, and left leg, 30%, my lord. Both are being progressive in nature. Hence, my lord, he left the job during July 2024.
Counsel for the petitioner submits that the family court had granted maintenance of an amount of rupees 9,000 to the wife. It is submitted that petitioner earlier working and now he is not able to work because of the disability he is suffering in both the eyes and the leg. As per the certificate, he has disability of 40% on both the eyes each, and also the disability on in the left leg is 30%. It is submitted that it is difficult for the husband to pay the maintenance. Next para. Considering the fact that the petitioner is disabled, where there is a vision problem and also disability in the leg, there shall be stay of all further proceedings. Notice to the respondent.
Obliged, my lord.
List number 4, serial number 1. Srinivasa DC.
Appellant.
Appearing for the advocate Padmanabha Kedilia.
The application for being spoken to. What happened? Well, after the dismissed the appeal filed by the owner of the vehicle. Only that the acknowledged therefore company has to pay and then recover. But point is left out in the final portion of the order, 16.4.
This is an appeal by the
owner of the vehicle. But also it has held that he has no license, therefore he has to. Company has to pay and then recover.
Let me see. Respect to that. Nobody can say that.
On 48 of 70, appeal 10,609 of 80. Again, what is a being spoken to the
In,
lawyer.
in paragraph number, operative portion, point number 4.
Yes, ma'am.
The matter is listed, the caption for being spoken to. It is submitted that the court has held that the insurance company shall pay the compensation and record the same from the owner of the vehicle. When it comes to the operative portion of the order, the same is missing. As such, they have come up with this petition. At clause number 4 of the
Class 16.
operative portion of the order, end of that order. People are continuously talking in the court, please tell them. The insurance company shall record the same from the owner shall be substituted, and the corrected copy shall be uploaded. Yes, next.
Dismissal, serial number 2, Bhagirathi L.
I received the copies. Weeks time may be granted. I file wakala.
What is this?
The last time I made a submission that the copy was not served. So it was posted
Case of
today for
injury.
dismissal. I have received the
The
copies.
case?
Case of injury, my lord.
It says by wakalat, filing wakalat will grant some time. It can't be argued.
I have no
The-
papers. I have to get the confirmation from the company.
Yes,
It may be
the
taken up by
delete
the-
from dismissal at the request of land counsel appearing with the respondent company. This is matter on
17th or 18th.
on 19th,
Please.
Wednesday. Yes, next.
Number 3,
Same submission.
Syed Abdul.
Same submission.
I am for appellant, my lord.
So you, this also,
This also, I have received the copies.
same, this
File
also
wakalat.
delete from the caption dismissal. Papers are served in both the matters. The appeal memo is served on the counsel for the respondent. Yes, same date.
Obliged.
Order.
Orders, number 4,
My lord, I am for the appellant, my
K.
lord.
Kumar.
My lord, yes, sum of 3,651 is deposited before the tribunal, my lord. I have produced the acknowledgement also, my lord.
It is submitted that stay is already
Not for stay,
granted.
my lord, not for stay. It's an easy matter.
It is submitted that they've, as calculated by the registry, they have deposited the amount of rupees 365, that 3,651. Then, what is
My lord, it is a easy matter, my lord.
hmm?
He is a occupant in a private car. He is not a driver. My lord, there is no relationship, dual relationship of the employer and employee. And my lord,
submits,
income is taken at 15,000 per month instead of
submits that the
8,000.
court had taken the income at 15,000. There is no relationship of employer and employee. And the accident has not taken place during the course of employment. All these aspects were not considered by the court. Considering the submission of the land counsel petition, they shall appellant, they shall be stay of all further proceedings on the condition that they shall deposit 50% of the amount.
Hello, we have already deposited the entire award
They
amount.
have deposit, before this, it is submitted that the entire amount is deposited, considering the so and so, they shall be stay of all further proceedings.
That amount may be kept in any nationalized bank.
The amount shall be kept in a fixed. Anyhow, all these 25 matters will be disposed of.
Please, let it
Fine.
Notice.
Notice to the respondent.
much obliged.
By B. Pradeep.
What is this 12/8/2025 order?
We have filed certified copy in MFA number 3,999 of
They
2025.
submitted that, they have filed the certified copy of the order in MFA
3,999 of 2025.
3,999 of
25.
2025, considering the same. Where is this IA?
Yeah, we filed IA number. IA for
IA
dispensation.
1 of 25 is filed seeking dispensation of notice. Considering the dispensation of the present, the dispensation of filing the certified copy of the judgment, oblique award. Considering the fact that this is already filed in the MFA number so and so, I number 1 of 25 is allowed by dispensing with production of the certified copy of the order. Yes,
Seeking stay, my lord. Insurance company as of date of there is no policy, my lord.
no policy.
No
What is the
policy.
amount granted?
Granted, my lord, amount 7,54,204
It is submitted
rupees.
that, it is submitted with the land counsel of appellants that as in the date of the Why you are saying that no policy?
Policy, my lordship, as per exhibit P2, policy insured valid from 11 to 2022. Timing, my lordship, to 10 to 2023. Invoice dated on 2 to 2022 is 1 day after
That
lapse
as
of.
on the date of the accident, there is no policy and still the liability is fixed on the insurance company. Considering the same, they shall be stay of all further proceedings on condition of deposit 50% of the amount.
Before this court, my lordship, will deposit.
Or wherever you want to deposit 50% of the amount and on a notice to the respondent. Within, in all these claim matters, 4 weeks. Yes, 6.
Jagdish,
Who are the respondent? You are the insurance company.
Yeah, it's KSRTC car.
Mm.
The address is the, whatever the mentioned in the judgment cost statement, as well as the petitioner, JDR Friday execution, the same address. But Shara is comes, no such person.
The petitioner.
I permitted to serve the copy to a trial court advocate.
The appellant shall serve the copy of the appeal memo on the counsel appearing for the respondent in execution proceedings. What is the amount?
Amount to total amount to 9 lakh something.
Case of death or injury?
Injuries.
On what ground you are before this court?
Because at the time of accident, the rider of the motorcycle, the petitioner is a consuming alcoholic. So it is a mentioned judgment as well as the documents also reflected, but the tribunal is not considered.
It is submitted that at the time of accident, the claimant has consumed alcohol and there is a contributory negligence on his part. This aspect was not considered for the court. Considering the same, they should be stay, same 50%, and the respondent is at liberty to withdraw. Notice to the petition shall take good summons on the counsel appearing for the respondent in the execution case.
the 7, and Krishnaswamy.
Referring for the appellant, my lordship. My lordship, there is one office objection, my lordship. In the MACT judgment, United India Insurance Company Limited is not
Non-production of certificate
is already produced, my lordship. In the connected matter is already produced and dispensation IA is already filed, my lordship. There is only one office objection that India is not missing in the trial court judgment.
What is that sound? You can mute that wherever the
sir.
sound is coming. Yes.
In trial court judgment, my lordship, respondent number 2 as well as respondent number 4 is mentioned in United Insurance Company.
What I can see from here is for non-production of corrected copy of the judgment as per the court order dated 13/8/2025. This is what is the objection.
Correct, my lordship. There is only office objection. That is the office objection, my lordship. That United India is missing in the trial court judgment. It may overrule, my lordship.
Mr. Counselor, 13/8/2025, there is an order.
In connected matters, stay already granted, my lordship. My lordship, in connected matter, there is only one office objection, my lordship. That is the.
I am looking at 7. There is no connected matter here. What office objection is non-production of the corrected copy of the judgment as per the court order dated 13/8/2025. This is the order dated 13/8/2025. You have to comply. The petition shall comply with the order dated 13/8/2025 within a week. Yes, next. 8.
Number 8.
2 weeks time is.
Rangya Goda.
We will file necessary application, my lord.
For what?
Regarding, my lord, compensation, my lord, claimed before the tribunal, not 6,50,000. The awarded, my lord, 5,94,000 is awarded.
6 lakh?
6,50,000 is the claimed amount.
75,000 is.
My lord, 5,94,900 is the awarded amount. Difference, my lord, the 55,100 is the different. Below 1 lakh, my lord, climate appeal is not maintainable as per amended.
What you will do now?
We will file a necessary application for amendment of claimed amount, my lord. By oversight, my lord, my trial court advocate is claimed compensation, my lord, 6,50,000. We will file necessary application. My lord, that is applicable, my lord, only for insurance company while challenging the award. We are seeking announcement of compensation, my lord. Appeal subjection may be overruled, my lord.
That is only against insurance company.
Please.
1 lakh, if it is less than a lakh, you can't file an appeal. Agreed?
Agreed by the award, my lord.
Less than 1 lakh, it cannot be challenged.
He is not agreed with our.
It is not a challenge. They are seeking for
It's seeking for announcement of.
I don't think that's an interpretation. No, if it's aggrieved in the sense, whoever is not happy with the award.
They are seeking enhancement
Enhancement
after
is
total
permissible.
amount. Total amount, suppose if they claim 10 lakh, if the criminal award is only 90,000, the balance amount, the amount in dispute is 9 lakh 10,000.
That's not the
They claim
issue.
10 lakh. Malad, in the claim.
No, I can, Mr. Ravi Samprati, I can understand, according to you, aggrieved means it's only insurance company.
Yes, yes. If the amount is less than 1 lakh.
I am agreed that the compensation is granted beyond 1 lakh or whatever it is. So I am agreed. They are seeking.
He is also aggrieved. No, he is also aggrieved.
Enhancement.
Huh?
He is seeking enhancement of the balance amount.
But he is dissatisfied with it. Dissatisfied with not granting.
No, he is not challenged that the 90,000 liability.
He is challenging an award. He is challenging an award which has not been granted as per his claim.
To what extent that amount is not granted is the point. The lordship will grant that. Malad, he claims.
What it says, no appeal shall lie against the award of a claims tribunal if the amount in dispute in the appeal is less than 1 lakh. Here, the amount is not in dispute. See, when an insurance company or KSRTC files an appeal, we will be questioning that 1 lakh, saying that that is what is amount in dispute will be 1 lakh. Here it is not the question of dispute. They are not disputing. They are only seeking enhancement.
No, I think that's not the. No. Amount in dispute is, no, they wanted compensation of 7 lakhs. Court had granted 6 lakhs. That amount of 1 lakh not being granted by the court, they are disputing that award. They are aggrieved by the award passed by the tribunal in not granting the whole amount as claimed.
Value money.
The amount in dispute, what they are seeking is beyond 1 lakh.
No, for example, before the trial court, they sought for 7 lakhs. Court has granted 6 lakhs 15,000.
The balance what they are asking
85.
is beyond 1 lakh. It is not less than 1 lakh. It is beyond 1 lakh.
No, not in this. I'm not saying in his case. I'm not saying in his case. I am saying on the point, this aggrieved amount.
That amount is only 75,000, not 20.
You're always, we are debating on something. Let's just debate on that. When the insurance company itself is saying that it won't apply to the claimant, that I want to understand from what Mr. Samprati is saying.
We are not challenging the liability. We are disputing only the momentum. We dispute the liability, not the whole amount.
Does the section say so? That's what, give the tag. One more book is not there.
Is less than 1 lakh.
No, he must be having another copy.
Searching.
The last slide.
So that's why it would have said, if it is only insurance company, it would have said,
It is not said.
aggrieved any person. Now we say when a claimant comes before this court, we will say that he is aggrieved, but the amount of not granted. Here it doesn't say about liability, compensation, nothing. So whoever comes before this court is aggrieved. That's what we'll see what it is. Lissus matter. After Lissus matter in the month of December. Yes, 9.
Praying for the appellant, my lordship.
Krishna
The accident occurred prior, policy lapse prior to the accident, my lordship.
Hmm.
And premium paid by the check through, premium paid by check, my lordship, 28/3/2018. And check was returned on same day, my lordship. And everything, letter sent to RTO officer as well as the owner of the vehicle.
Let's see the exhibits
Yes, my lordship.
from the insurance company. Authorization letter issued by the company for dishonoring of check amount, cooperative bank check, endorsement, dishonor check statement, authorization letter, copy of the sketch. Where is the acknowledgement? How much is the amount?
Amount is granted in MACT, my lordship. Total is,
Case of death or injury? It's a death case.
It's a death
8
case,
lakh
madam.
12,500.
this is all batch cases, my lordship. Total batch cases. Day before yesterday also same matters. Stay already.
In that case, I've seen.
Yes, ma'am.
I've seen the exhibits. In that you have the acknowledgement also filed before the court. In this case, it is not filed. I have verified. I remember the other day.
So buses involved is same bus, my lordship. So a letter and everything is same only, my lordship. Maybe it's not marked, but involvement of bus as well as the lorry is same, my lordship.
Which is that matter? List along with so and so.
My lordship.
List along with so and so. Give the number to them. To the court
Everything is
officer.
mentioned, my lordship.
To the court officer. List along with that on Thursday. Yes, next.
10-11 also same, my lordship. 10-11.
All the three.
Yes, my lordship.
On the same day. Yes, 12.
Number 12, Janardhan Reddy.
Yes.
Challenge the quantum, my lordship. The injured.
How much is awarded?
The award is 9 lakh something, 9 lakhs 28,000.
What is your admitted amount?
Admitted amount is the 50%, my lordship. Because, no, my lordship, you are sustained only 2 fractures. The tribunal granted pain and suffering 2 lakhs, amenities 1 lakh, food and nourishment 1 lakh.
What is the injury?
My lordship, injury is the fracture of right humerus and L1, L2 vertebra. 35% is a particular limb disability. 20% was taken by the tribunal, my lordship.
Vertebra.
20, the doctor assessed only 35%.
The informs for the appellant insurance company submitted that the court has granted the compensation on the higher side. And for pain and suffering, the court had granted 2 lakhs. Further, at the head of loss of amenities, an amount of rupees 1 lakh is awarded by the tribunal. Food and nourishment also, an amount of rupees 1 lakh is awarded. Considering the same, they shall be stay of all further proceeding. 50% 4 weeks, and their respondents are at liberty to withdraw.
Dispensation for second respondent.
Memo is fetching dispensation or notice to second respondent, notice to the first respondent. Yes, 13.
13, we have challenged the liability, my lordship.
On the ground?
Because the vehicle involved in the accident KA05AB4815. The charge sheet was filed by KA53C0078, my lordship.
What did the court say?
Court, without considering the charge sheet filed against the insured vehicle, on the basis of that only liability was fixed, my lordship.
It is submitted that the insurance companies before this court questioning the liability. The involvement of the vehicle itself is challenged. Considering the same, 50%, no permission to withdraw. 4 weeks. Yes, next. 15.
15, D. Vijay Kumar.
Bill by the insurance company, it's an ex parte judgment, my lord.
Why, Mr. Vijay Kumar?
But particularly MACT Mysore, my lord, we have come across more than 50 cases of that insurance company. I don't know what is happening in almost all the cases, my lord.
Is it a case of death or injury?
My lord, it's a case of death, my lord.
How much is
wife
awarded?
and 4 major children, sir. My lord, 12 lakh and dad is awarded, and he is aged about 65 years. Tribunal has taken only 60 years and adopted, my lord,
What is
applied
admitted amount?
future purpose.
Admitted amount?
My lord, maybe about 5 lakh.
Huh?
5 lakh.
How can it be 5 lakhs?
My lord, it's a proper multiplier is only 5 multiplier.
What
Tribunal
is
has
the court
adopted 9
adopted?
multiplier.
Huh?
60 more than 65 years.
Half of the amount
And my lord,
submitted that
future prospectus
it's
is
an ex
also.
parte order and the court had granted.
And
Multiplied
no
the,
dependency.
applied the
1/4
multiplier
is
of
applied.
15, multiplier of 9, where it is only 5 is the
5.
multiplier to be applied.
10% future prospectus is applied.
And the future prospects were also taken.
And 1/4 is deducted instead of.
Considering the same, they shall be stay half of the amount, 4 weeks
Much of it.
on such, they are entitled to withdraw.
Much.
The 16. I number 1/25 in 13, seeking dispense production certificate of the judgment. If dispense is for the present. Yes, next.
16, my lord, case of death, my lord. Case of death, only income, my lord.
16.
Yes, ma'am.
Who appears?
Appears.
You appear?
Respondent.
Yes. Let's see.
Date of accident 16/1/2018, my lord.
Where is that? Come to the date of accident is
16/1/2018, my lord.
16/1/2018.
My lord. Court has taken
Age.
age 38 years, my lord.
Quoted, what is the income taken?
10,500 is taken, my lord.
10,500.
Yes,
How
ma'am.
much it should be?
12,500, my lord.
What is the multiplier?
Multiplier, my lord, 15, my lord, 38 years, my lord. And
Correctly taken?
rightly taken. Correct.
And future prospects were given or
40% is added, my lord. 40% is added, my lord. And 15 multiplier taken, bachelor, my lord. 50% deducted, my lord. Only income and conversion, conventional rates, my lord. Mother and brother, sisters.
1 minute. $8,750 would be the contribution.
Yes.
Into 12 into 50.
Yes, my lord. 15,75,000.
Into 12.
It comes to 15,75,000.
Yes, ma'am.
44 into 2, 88, 36.
My lord, 44 into 5, my lord. Brothers and sisters are mother and brothers and sisters, my lord. He is a bachelor, my lord.
Yes. 44 into how many?
5, my lord. And the court has already given 120, my lord.
No, that I'm not
Yes,
considering. We are doing it. It will 2,20,000 would be the amount. 36,000, 10,000.
Yes, ma'am.
It comes to 1,18,41,000. Please come. Agreed with award passed in a missing number 212 of 2019 dated 16 June 2022. The claimants are before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at paragraph number 19. Then counsel appearing for the claimant submits that the accident had taken place in the year 2018 and as per the table the court ought to have taken 12,500 or the court had taken 10,500. It is submitted that under the conventional heads the brothers and sisters were not, the court had not granted a reasonable amount under the conventional heads. Hence, amount of compensation needs to be enhanced. Then counsel appearing for the respondent submits that the court has granted a reasonable compensation, no enhancement is called for. Next, having heard so and so. The accident had taken place admittedly in the year 2018 and as per the table, it is 12,500. Future prospects at 40% will come to 5,000, that is 17,500. As he is a bachelor, 50% has to be deducted towards personal expenses. It comes to 8,750 into 12 into 15 is 15,75,000. As there are the siblings and the mother, 44 into 5, 2,20,000, 36,000 towards general expenses. Then in the light of the law laid down in make law so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 18,41,000. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 14,73,000 to 18,41,000. Enhanced amount shall carry 6% interest. Next.
17, Krishnaswamy.
Appeals for the appellant, my lordship.
Yes.
My lordship is the insurance company appeal. We are challenging liability, my lordship. MACT awarded the pain recovery order, my lordship. The rider of the motorcycle didn't have the driving license, my lordship, and learner's license also expired. So we challenging the pain recovery order, my lordship. As per the new act, pain recovery is impermissible, my lordship.
When was the accident?
7/9 to 2023.
When was the amendment?
1/4/2022.
It is submitted that the court, though having considered that there is no driving license, still has ordered the pay and recover and insurance company before this court. In this same 50%, 4 weeks, no permission to withdraw. Yes, next, 18.
Much obliged, my lordship.
18, Janardhan Reddy.
Liability connected case already 13 serial number, sir. Interim stay was granted, same.
Same 13 order in this also. 19, notice to the respondent. In this, no dispensation.
No, liability challenge.
19, but in that you ask for this.
No, that is, that 12 I have dispensation.
Yes, yes. 19.
19,
My lord, challenging the
Shabendra.
liability, my lord. I have deposited the entire award amount in the ECA matter, my lord, Employees Commission Act. And I have deposited. There is no driving license. They have not produced the driving license in this case, my lord. IO has been examined. There is no employer and employer relationship.
They submitted that the entire amount is deposited. There is no driving license. And these aspects are not considered by the court, hence there shall be stay of all further proceedings. Notice to the respondents. Next 20.
Stay may be granted, my lord.
Yes, 20.
Much obliged. 20.
I have 1/25 for continuation of delay is not pressed by the council, is not pressed as the appeal is in time. Accordingly, I have 1/20/25 is dismissed as not pressed. Next 20.
20,
20 appeal for the appellant.
Case of
injury, my lord.
Kindly have it on next week, my lord. Lingaraj's case.
Why he is not coming nowadays?
No, from last 3 or 4 occasions, no, she is not.
He is not appearing.
I will
My
argue the
case
matter. I will argue the matter.
Yes.
Case for enhancement not seeking. Case of injury.
No, what is the next list? These are all order matters. What we do is, we'll take up these order matters and complete this final hearing list. So, next, let's list, list number 5.
My lord, serial number 21 in the same list. My lord, act liability policy, your lordship called for report.
Come
Please
back to
wait,
that.
sir.
Oh, yes.
After list number 5, we will call.
Yes, memo is fine. First matter.
List number 5, serial number 1.
Memo is filed seeking dispensation of
Shantraj
notice to
Kaur.
R1 dispensed with. I have 1/25 to condone the delay of 2 days condoned. I number 1/24 is dismissed as not pressed. Admit post for final hearing, call for the DCR.
My lord, I am for the respondent, my lord.
Who appear appellant in this case, my lord?
I number 1/24, 116 days delay, condoned on condition, admit final hearing DCR. Next
Much
three.
obliged, my lord.
3, Rajshekar S.
For appellants, my lords. We have paid the process fee
It is
and we have
submitted
asked for the stay in MVC 589, my lords.
24, you are happy, please be happy with that, not now. I number MF, it is submitted, the needful is done, list after service of notice. 4, memo is filed. The acceptance of PF furnished after lapse of time. Yes, is ordered. 4, memo for dispensation of notice to R1, dispense with at the risk of appellant, admit final hearing.
Number 5.
Office objection shall be complied within a week.
Please, ma'am.
Yes, 6, list after service of notice to respondent.
BMTC, my lord.
BMTC. Mr. Dabali appears? Vijay Kumar appears. Mr. D. Vijay Kumar is director to take notice
Please.
on behalf of the respondents. So service is completed.
Service is complete.
Admit final hearing, TCR, serve the papers on the council. 1, how many? 2 days, IA number so 2 days delay condone. Yes, 7.
Let's
The
appear for the
7,
appellant in
Jagdish
this case, madam.
Shetty.
I sought the copy also, my lord, Arnish
On
Swaminathan.
Mr. Harni's, on, yes, IA number, where is she? I number
Harini
1,
Shivanand.
I number 1/25 to condone the delay of 511 days condoned on condition, admit final hearing TCR.
Please.
Yes,
Number
next.
8,
First respondent, my lord.
Alli
Copy is
Shantappa.
not served in this. Copy is not served in this case.
No representation, list this matter for dismissal on Thursday. 9,
Appeal for the appellant in this case, my lord. Respondent number 3 is the United India Issues Company,
United.
India.
Geeta Raj is directed to take notice on behalf of the insurance company. I number 1025, 330 days condoned on condition. Next 10.
10, Maheshwarappa.
I appear for appellant.
What is this amended copy?
The claim, the 21 lakhs, 25,000. In the order judgment, only 17,025. I have produced the claim petition, 21 lakhs, 25,000. That is the raised objection.
So then office of it is submitted that the petition has already filed a certified copy of the amended impugned order. Yes, next. Who appears
And
for
your
respondent?
lordship, the issue notice, that is admission for.
Notice to the respondents. Yes. New India. Mr. Ashok and Patil is directed to take notice on behalf of the insurance company. Next 11. Will accounts for the appellant shall serve the copy on the council. Yes, 11.
Number 11, V. Pradeep.
There's 3 days time, my lord, to take steps.
3 days time to comply with the office objections.
Please, my lord.
Yes. 12.
Syed Abdul Sabur.
Abhi, it's
I've
time.
already submitted before registry memo for dispensation. Fine. To R1.
Why you can't appear in person for even this was no colleague here, no file. Every time matters are getting adjourned like this. It
No,
is
my lord,
submitted
I've
that
already.
the memo is filed seeking dispensation, which is not available. Petitioner shall file the appropriate memo. List next week, 13.
13 minutes
13.
awaiting service of notice.
List after service of notice. Next memo is filed for dispensation of R1, dispensed with I1, 5 days, condoned, admit final hearing, TCR. Next 15.
15.
Waiting notice to
List after
Tata
service of-
AIG, my lord.
Huh?
Tata AIG.
Memo is filed seeking dispensation of notice to R1, dispensed with Tata.
AIG.
Ms. Janardhan Reddy is directed to take notice on behalf of the insurance company.
And
Admit final hearing TCR.
delay.
Yes.
Delay.
Delay.
How much?
1,113 days, my lord.
115.
1,113.
Huh?
1,113 days, my lord.
1,130. You want to file objection? Anyhow, ultimately that is with
I have to see copies.
1,113 days on condition. Give the papers to him right away.
Yes, ma'am.
Yes. 16.
16,
Appearing for appellant, my lord.
Pramod,
United India, my lord.
United.
India, my lord.
Mr. N. Krishnaswamy is directed to take notice.
Yes, ma'am. Delay of 690.
I number 1025, 617 days condo. No, this is how much delay?
617 days.
617 days condone. Admit final hearing TCR. 17.
My lords, appearing for the appellant.
I am for the, not received the copy of the bill.
Serve him a
Serve
copy.
him. My lords, here after the award of the tribunal, the legs have been amputated of the appellant. So I'm praying the court for give the, I will submit the additional documents, my lords.
That you do it. I number 1025 is filed to condone the delay of 211 days. Condone. Admit final hearing TCR. Next 18.
18,
After service of notice to R1. Next.
Serial number 18, my lord.
Memo is filed seeking this.
Serial number 18. Kindly delete name HS Lingaraj. B Pradeep has been filed wakalat.
Delete the name of in 18, delete name of Mr. H.S. Lingaraj. 19 memo is filed for dispensation notice to R2 dispense with admit final hearing. List after service of notice 20. 21 also list after service of notice. 22 also list after service of notice. Next 23.
23, Suresh K.
I
appear.
Condone the delay of 32 days condone admit final hearing this year. 24.
24 filed memo for R1.
A memo is filed seeking dispensation. Already it's filed.
Oh.
It is already dispensed with. I number 1 of 24 to condone the delay or 422 days. Condoned on condition. Admit final hearing TCR.
25, Rupesha.
File seeking dispensation
For
of
R2
notice to R1 and R3 dispense with at the risk of appellant. Oriental Insurance Company.
Oriental Insurance.
Mr. Shankar Reddy is directed to take notice on behalf of the insurance company. I number 1 of 25 is filed to condone the delay of 147 days in filing condoned. Admit final hearing TCR. Yes, 24 admit,
25, 26,
26 admit, 27, 28,
28,
29.
I am for the appellate.
27, my lord. I have filed here for return, release of amount, my lord. Case
What
of
is the
death.
case?
Pardon me.
What
Case of
is the
death,
case
my-
about?
Case of death, my lord.
Case of death.
Please,
This 27 list on Thursday.
please,
On 4, yes, it is coming on 4th, death matters.
please.
So tomorrow, list is matter 27 tomorrow. Next 28 admit, 29 admit. Admit finally, that's what, once it is admitted, PCR. 30,
30,
Copies out. Copies out.
it is submitted that the copies are served on the respondent. The matter may be referred to the Lok Adalat, yes. 31,
31,
I appear for the appellant, my lord. I am ready, my lord. Matter could be disposed of. May I take?
yes. This matter on next week. Yes, call the final hearing matters. In list number 4.
list number 4, final hearing matters. Serial number 20,
Lord's case of
Nagaraj
injury.
Reddy.
Yes.
Date of accident, Lord, is 9/12/2020. Lord, sir, the injury is not, sir, major injury is not, sir.
How much is awarded?
Lord, it is 11,63,772. Lord, out of which, Lord, 30% contributory negligence has been.
Let's go to the table.
Please. Lord, ink page 23.
You are on what
paragraph number
grounds?
20.
You are on what ground?
Lord, for enhancement as well as, Lord, sir, for the
Contributory negligence. So on enhancement, you are on what point?
Lord, Dome Lords was admitted for 16 days. Lord, for pain and suffering 15,000, conveyance 15,000, medical loss of amenities 15,000.
No. Let's. How many are the fractures?
2 fractures.
2 fractures, 50,000.
Pain and suffering was only 50,000. 15,000 is awarded.
I'm saying 50,000.
Yes, Lord.
Next, medical expenses.
Medical expenses as it is, Lord, 9,04,930.
1 minute. 9,04,931. How many days he was in hospital?
16 days. Lord.
So then we will grant 16,000. Incidental expenses.
Loss of amenities, Lord, only 15.
1 minute. Loss of income during laid up period.
Only 12,882.
Which year is the accident?
2020. For only 1 month it is been given.
1 minute. 14,500. 14,500 into 3. It comes to 43,500. Then, now, what is the
Loss
disability?
of amenities, Lord, only 15.
No, we will first of all disability, then we'll go to that.
Yes. Lord.
A loss of future earning.
10% has been stated by the doctor, Lord, which has been taken by the tribunal.
So then, as it is.
But the income has been taken 12,882.
It should have been?
14,500.
So 14,500 into 12. What is the multiplier?
13 Lords. 47 years.
13 into 10 by 100. It comes to 2,26,200. So loss of amenities. What do you say? Court has granted 15,000.
Amenities, my lord.
Another 15,000. That's it.
So for contributed negligence, my lord.
No, 1 minute, I'll just calculate this. It comes to 12,80,631. Now please come to the contributory negligence
My
part.
lord, there are 11, my lord. The tribunal is rightly held.
Let's
For the contributory negligence.
let's see.
There are 11 of the judgment.
Please read.
Page 9, my lord.
17.
Page 9.
Page 17 and paragraph number 11. So this page 9 only. Lords, in the
My lord, on going, I will read, my lord. On going through the pleadings and evidence of the petition are available on record, it goes to show that the oral and documentary evidence is against the pleadings, against his pleadings. As per the case, he took the right turn, hence this accident is caused. But as per the evidence, he took the left turn, hence there is this accident is caused. Furthermore, damages caused to both the vehicles speaks that car was in high speed rather than lorry. Further pleadings of the petition is that lorry was going in front of him, he was following the lorry. Further, as per the case, he was slow and lorry was inside in high speed. Under such circumstances, it is not possible to cause an accident if a lorry was very slow and lorry was in high speed.
Oh, you were behind the lorry.
Yes, my lord, he was behind the lorry.
Without showing any signal,
Rule 23
lords,
of
the
the
lorry took right turn.
Huh?
Without showing lords any signal.
But that's what the court says. But as per his evidence, he
Yes,
took
my lord.
left turn.
The cross examination, not in the evidence.
Yes.
Cross examination was by mistaken fact, lords. Yes,
That is,
instead of
you have-
right turn,
you said
just
so.
stated left turn.
You said so.
Only
Can't
because
take
of
it
that
that by
stray
mistake you
admission,
said
lords.
it.
No.
Even that, lords, the driver, lords, has pleaded guilty before the criminal
Hello,
court
rule-
and paid fine.
No, that is,
Mere
pleading
plead
guilty is
guilty.
not a reason.
Yes.
And you tell the court, I can understand if the lorry has come and hit the car.
Yes.
I mean, the car went and hit the lorry.
Yes, ma'am.
According to you, there is negligence on the part of the driver. How did you establish?
Lords, without showing any signal, lords, he has
How?
taken-
That is your
How?
assertion. What is the material on record?
Lord, charge sheet has been filed against the driver of the lorry only. He has pleaded guilty before the court, criminal court, and paid fine.
Mere pleading guilty of an offence,
Without show-
as per the decision of this
Because
court.
he has taken right, lords, I couldn't control my car and hit the vehicle.
We'll make it
My lord,
20.
rule 23 of the regulation, rule 23 is
No,
very,
we'll make it 20%.
my lord, he himself has dashed against my vehicle and in Nishan Singh, as Supreme Court, what says, 50% negligence on the part of the driver of the car.
So.
First point, my lord. Secondly,
4,000
rule 23 of the regulation of the Motor Vehicle Act is very clear.
minus
They should keep a sufficient distance.
1,80,631. So insurance company is liable to pay
25%, my lord, fixed 25%, madam, because he himself has dashed against my
I have
vehicle.
kept it, Mr. Zingareddy. It's only 30% I have taken it
Yes,
as
madam.
it is. Yes.
Lord, instead of 30, lords,
50. Actually, in Nishan Singh is very clear, my lord.
only because of stray admissions, lords.
Not stray
It
admission.
is not admission.
Yes, lords, in the-
Apart from that, what is the evidence? No other evidence.
No other except the evidence which has been extracted in
So-
the judgment, lord.
And also, in this case, my lord, unfortunately, he is a businessman. As per the decision of the Supreme Court, he has continued, there is no loss at all. And this court has granted, the tribunal has granted, because in Mamata's case of the Supreme Court judgment says that this court has got
Agreed
vast
by the
powers
award passed in
to
WC
reappreciate
number
the evidence.
850 of 2021, dated 4th October 2023. The 23, the claimant is before this court seeking enhancement of the compensation. The compensation is awarded as per the table given below at page 21. Then counsel appearing for the claimant submits that the court had taken the income at
12,000.
500.
882.
Huh?
12,882.
12,882,
Yes,
and
ma'am.
as the accident had happened in the year 2020, it would have been taken at 4,500. It is submitted that the contributory negligence is fixed at 30% on the claimant without any basis. It is submitted that the charge sheet is filed against driver of the lorry. yeah, hence there cannot be any contributory negligence on the part of the claimant. It is submitted that on all the heads, the compensation that is awarded by the tribunal is not just and reasonable. Next line, counsel appearing for the respondent company submits that the lorry, the car is behind the lorry. The evidence, as per the court has observed that in the evidence, he has stated that when the lorry is taking a left turn, this accident has happened. And in the evidence, he has stated that he was taking a right turn. These are the contradictory statements, and the court had rightly fixed the liability, contributory negligence at 30%, and there are no grounds to interfere. Next para, having heard the counsels on either side, for a material on record. First, coming to the compensation, considering the two injuries that are sustained, this court is granting 50,000. Under the head of medical expenses, no enhancement is called for. Incidental expenses, this court is granting 16,000. Coming to the loss of income in the later period, 14,000 into 3, 43,500. Loss of future earning, 14,500 into 12 into 13 into 10 by 100 is 2,26,200. Loss of amenities, considering 10% disability, this code is granting 30,000. In the light of the law laid down in Mekala versus so-and-so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 12,80,000. The compensation comes to 12,80,631. It is the case of the claimant. It is a case of the tribunal had fixed the contributory negligence at 30% on the claimant. This court has perused the order passed by the tribunal and also the submission of the claimant that as he has pleaded guilty before the criminal court and the charge sheet is filed against him, there is no contributory negligence. Basing on the evidence on record, the tribunal had rightly fixed, and this court finds no reason to interfere. Accordingly, the appeal of as far as the contributory negligence is concerned, the same is affirmed. This court has granted 12,80,631. The 30% would come to 3,84,189, and hence insurance company is liable to pay 8,96,441. The legal expenses you wrote in the make a loss. So the insurance company is liable to pay 8,96,441. The enhanced amount shall carry 6% interest. Next.
21.
At least to 20%.
Prasanna, we are
The contributory negligence have been reduced.
In this
30%.
It was there in lots in the trial.
That's why, because there is nothing to lessen it. Yes, 21.
Injured claimant is the appellant, my lords.
My lord, I appear for the respondent, my lord, this policy issued was an act liability policy. So there is no liability against the insurance company. Your lordship called for the records.
The said issue is under consideration before the full bench of the Honorable Supreme Court. The matter is
We'll hear it some other day.
Please.
List this matter after TCR is received. 22.
Please.
Yes, from
22. B. Pramod.
Appearing for appellant.
Respondent.
You appear for?
Appellant.
Yes.
Claim petition was dismissed.
On the ground?
It was not maintainable.
Mm.
Case of death of three buffaloes on the highway. Ambulance has caused the accident, saying that it is not maintainable.
Any point?
Charge sheet is filed against the driver of the ambulance.
On what ground? We'll see some other day this matter. Yes, this matter after the TCR is received. Yes, next.
23. 23.
I appear for respondent number 2.
Satish Shetty.
Where is he? Case of death or injury?
Amputation case.
Amputation. No representation. List this matter on November 20th. Yes.
24. FS double.
Appellant murder.
Yes.
Of injury appealed by the corporation
On the ground?
on the ground of involvement murder, but involvement of the vehicle and also negligence on the part of the claimant.
I'm for respondent, my lord.
Because there is delay of not 6 days in lodging the complaint. As per our case, not the bus was moving not on the highway, Bangalore to Mysore.
MLC is produced.
Yes, ma'am.
MLC is produced.
Discharge summary has been produced, medical wood
Because
certificate.
that the accident has taken place on that
Yes,
day.
that is
So
true.
delay is gone. Next,
Because manner of accident is not, the bus was moving out from Mysore towards Bangalore. At Channapatnam, my lord, the auto was coming behind the bus. And the scooter, my lord, the motorcycle ridden by the claimant, my lord, who was coming behind this auto rickshaw, he dashed to the auto rickshaw, my lord, which was following the bus. Because even as per the IME report, my lord, there is no, the case of the claimant is not the bus dashed to the rear side of the motorcycle ridden by the claimant.
we'll hear with some,
Negligence still,
This matter TCR is
matter,
required,
huh?
my lord. This matter TCR is required.
required.
Parts are required.
teacher बोलते हैं.
List this matter after the TCR is received. 25,
25, Rupesha B.
Waiting for respondent corporation.
no representation for the petition, no, don't write no representation. List this matter on 26.
Sorry,
My lord, appear for appellant, my lord.
for 26, sorry, Lordship. I am for serial number 26.
25 on 26. What
Appear
about
for
26?
appellant, my lord. My lord, a date may be fixed, my lord.
26.
26/11.
This is matter on
Objection.
27 of November. Yes,
Await trial court records.
yes.
Lord.
28.
26, 27.
United
27
India
adjourned.
Insurance Company, who appears?
28, Vijay Kumar T. 28, Vijay Kumar.
Mr. Ravish Beni is directed to take notice on behalf of the insurance company. List this matter after the TCR is received and counts for the appellant shall serve the copy of the appeal memo on the counsel. 29.
29, Srinivasaya.
For appellate, my lord. Claimant appeal, my lord. Case of death, my lord, minor, by my lord, aged about 6 years, my lord.
Which law to be applied?
2025, my lord.
25 law I will not apply. If that is what you want, I'll adjourn the matter. List this matter in the month of January. 30.
30, Sripad V. Shastri.
Yes, Mr. Shastri. List this matter after TCR is received. Yes, 31.
31, Raghuvar.
Where is Mr. Jagdish? Yes.
My lord, only ground, my lord, medical bills is not awarded, my lord. Medical bills is amount, my lord, 3,78,180.
Why it was not awarded?
Not noticed, my lord. MSCT is not noticed.
We'll call for the TCR.
TCR is there, my lord.
TCR is there, my lord. What happened, my lord, in evidence also, they have nowhere stated that there is amount of so much of medical bills amounting so much, that's all. Only as exhibits they are marked as P42, P12
Or we
to
have to
P14.
remand it then.
We are marked, my lord. It is
They are
marked.
You have to adduce evidence in that regard.
They are not adduced, that is what.
They are adduced
entire
evidence, but
there
not
is no-
stated in the evidence, my lord. Only.
Whom you have,
I am the petitioner.
whom you have examined.
Petitioner, wife of the
Wife of
deceased.
the deceased.
That is not, when you're speaking about the bills, somebody in the hospital you have to
Yeah,
examine.
we are, hospital is not necessary, my lord. We have produced the original medical bills, my lord, in this case. But court has not noticed it. It's only taken on record, it is taken on record.
Evidence, there is nowhere whispering regarding the medical bills. That's why there is no, even we have not suggested any questions in the cross examine also. That's why court has not considered or not gone through the medical
What
bills.
of, proving these medical bills, Mr. Samprati? Medical bills. Are you not supposed to examine anybody from the hospital with regard to that?
If the bills are not disputed, if the bills are disputed and if there is any sponsorer for the bills, then it is required to be examined.
Subject to cross examination.
Look at the TCR, what has happened? List this matter. TCR is there. And look at it. List the matter on 20th of November. Yes, 32.
My lord, 32, my lord, I appear for the appellant, my lord. Your lordship may kindly see, my lord.
Huh?
Your lordship may kindly see, my lord, para number 11 of the judgment.
Respondent has to be here. Respondent is
With
not
regard
here.
to the
Is this matter? 20th.
33.
tomorrow, adapt, my lord. Sorry.
20th.
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 Please, please.
33.
This
Gurudev
also on
Proceed.
20th.
I am for the respondent, 33, case
This also
30.
20th. MFA, why is this part third, Mr.
34.
Naik? 33 ಏನಾಯ್ತು? Tomorrow if MFA matters are coming, I think in the first list, this in the top of the list, part and matter. Tomorrow on the top. No, MFA on 4th. I said they should come on the first list.
Last hearing, my lord, actually calculated the amount, my lord. The response council objected, my lord. 10% disability is taken, my lord, injury. My lord, total awarded.
See tomorrow on the top of the list. First list it will come.
My lord, in so far as this 173 filing of 1 lakh, your lordship is right. No, that is what I've just downloaded one of the observation made by the High Court. I'll just read out, my lord. Therefore, if the claimant is awarded an amount less than 1 lakh and the claim petition is filed after the amendment came into force, they generally cannot file an appeal in the High Court for enhancement under section 173, as the appeal would not be maintainable. They would have to explore the other limited legal avenues. I'm sorry.
No.
Confusion.
It's already, I posted it some other day.
I'm grateful. I'm very sorry. Everything reads at the same time.
No, the problem is,
I understand.
no, advocates are not understanding. Morning Passover, I can understand. Again, if you ask for afternoon Passover and you see how many lists I have, and so many people are waiting from the morning.
I appreciate that, my lord. Unfortunately, it is the same.
And ask the court officer have given a date.
I'm grateful.
ಸರ್ ಅದು 31 ಒಂದು LCR ಇದ್ರೆ ಈಗ ಸಾಹೇಬ್ರ
31 LCR ಇವಾಗಲೇ ನೋಡ್ಬಿಡ್ತೀರಾ?
ಅಲ್ಲ ನೋಡ್ಬಿಟ್ರೆ ಇನ್ನು ಅವತ್ತಿಗಾಗುತ್ತಲ್ವಾ?
ನಾವು
ಕಂಪ್ನಿ ಮಾತಾಡ್ಬಿಡ್ತೀವಿ ಅಷ್ಟೇ.
ಆ ಬಿಜಿ ಒಳಗೆ ಇಸ್ಕೊಂಡು ತಪ್ಪು ನಿಮ್ಮ ಹತ್ರ ಅಂತ ಇವತ್ತೇ ಖಾಲಿ ಇದ್ದಾಗ ಇಸ್ಕೊಂಡ್ರೆ ನೋಡೋದು ಅಲ್ಲಿ ನೋಡ್ತೀಯ ಎಲ್ಲ
ಸರ್ 70-80 ಪೇ ಮಾಡಿರೋದು ಇಷ್ಟೇ ಇದೆ.
ಇಲ್ಲ ಟೋಟಲ್ ಎಲ್ಲ ಇದೆ ನೋಡಿದ ಬಿಲ್ ಹಾಕ್ಬಿಟ್ಟಾರೆ ನೋಡಿ, ಇಲ್ಲಿ ನಂಬರ್ ವೈಸ್ ಹಾಕ್ಬಿಟ್ಟಾರಲ್ಲ.
ಅಡ್ವಾನ್ಸ್ ಬಿಲ್ ಇದೆ ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ ಅಡ್ವಾನ್ಸ್ ಬಿಲ್ ಏನು ಗೊತ್ತಾ, ಇವ್ರು ಕೊಟ್ಟಿರೋಂಥದ ಅವನಂಗೆ ಬರ್ದೆ ಜಡ್ಜು ಅಡ್ವಾನ್ಸ್ ಬಿಲ್ ಅಂತ
ಇದೆ ಪೇಡ್ ಇದೆ.
ಇಲ್ಲಿದೆ
ಸಿಂಪಲ್
P14 ನೋಡು, P14 ನೋಡಿ ಇಲ್ಲಿ P14 ಇದೇ ಅಡ್ವಾನ್ಸ್ ಬಿಲ್ ಅಂತ ಹಾಕಿರೋನು. ಯಾವ್ಯಾವ ಕೊಟ್ಟಿವಿ ನೋಡಿ 20
ನೋಡಿದ್ರೆ ಡೇಟ್ ಆಫ್ ಅಡ್ಮಿಷನ್
ಹೌದು
ಆಯ್ತಾ, ಅಡ್ಮಿಷನ್ ಇದೆ, ಡೇಟ್ ಆಫ್ ಡಿಸ್ಚಾರ್ಜ್, ಟೋಟಲ್ ಅಮೌಂಟ್ ಕಟ್ಟಿರೋದು, ಟೋಟಲ್ ಅಮೌಂಟ್ ಬಿಲ್ ಅಮೌಂಟ್ ಅಡ್ವಾನ್ಸ್ 3,16,000 ನೆಟ್ ಅಮೌಂಟ್ ಇದು ಲೆಸ್ ಡೆಪಾಸಿಟ್ ನೀವು ಕಟ್ಟಿರೋದು ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ ಲಾಸ್ಟ್ ಬಿಲ್
ಇದಾಯ್ತು. ಇಲ್ಲಿ ನೋಡಿ 35 ಮುಂದಕ್ಕೆ ಬಾ, ಮುಂದಕ್ಕಿದೆ ಇಲ್ಲಿ ಇಲ್ಲಿ ಮುಂದಕ್ಕೆ ಇಲ್ಲಿ ಬರ್ತೀಯ ನೋಡಿ, ಮುಂದಕ್ಕೆ ಬಾ
ನೋಡಿ ಇದ್ರ ಡೇಟ್ ನೋಡಿ ಸರ್ ಸಾಕು, ನೀವು ಬೇರೆ ಏನ್ ಬೇಡ.
ಕೊಟ್ಬಿಡ್ತೀರಾ ಡಿಸ್ಮಿಸಲ್ ಗಿದೆ ಇವ್ರೆ?
ಒಂದು ನಿಮಿಷ 29, 35 ಅಂತ ನೋಡಿ.
35 ಏನು ಅನ್ನೋದು ನೋಡ್ಬೇಕು.
ಇಲ್ಲ ತಡಿ ಇಲ್ಲ ಅವ್ರೇನೋ ಮಾಡ್ತಾರೆ ತೋರಿಸ್ತಾರೆ. ಇದು ಅಷ್ಟು ಒಂದೇ ಬಿಲ್ ಇದು ಇದೆಲ್ಲ ಇದ್ರದ್ದು.
ಹೌದು.
ಯಾವ ಡೇಟ್ ನೋಡಿದ್ದು? 27. ಒಂದು ನಿಮಿಷ ನೋಡಿ, ಇದು ನೋಡಿ ಇಲ್ಲಿ ನೋಡಿ 1,100. ಇದು ಬೇರೆ ಕದ ಇದಲ್ಲ, ಇದು ಇಲ್ಲಿ ನೋಡಿ 1,116. ಇದು ಬೇರೆ ಇದು ಬೇರೆ ಬಿಲ್ ಫಾರ್ಮಸಿ ಬಿಲ್ಗಳು ಇಲ್ಲ ನೋಡಿ, ಏನೇನು ತಗೊಂಡಿರ್ತಾರೆ ನೋಡಿ ಇಲ್ಲಿ ಇವೆಲ್ಲ ಅಷ್ಟೇನೆ. ಇವು ಬೇರೆ ಏನಾದ್ರು ಮಾಡಿರ್ತಾರೆ ಫಾರ್ಮಸಿ ನೋಡಿ, ಫಾರ್ಮಸಿ ಕ್ಯಾಶ್ ಬಿಲ್ ಇದು ಇದು ಹಾಸ್ಪಿಟಲ್ ಬಿಲ್, ಇದು ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಇದೆಲ್ಲ ಅದ್ರದ್ದು ನೋಡಿ, ಇವೆಲ್ಲ ಬೇರೆ ಬಿಲ್ ಅಷ್ಟೇನೆ ನೋಡಿ. 4,760 ನೋಡಿ, 4,700 ಬೇರೆ ಬಿಲ್. ಹಂಗೆಲ್ಲ ಡಾಕ್ಟರ್ ಇದು ಮಾಡಲ್ಲ, ಅದನ್ನ ಮಾಡಲ್ಲ ಅಷ್ಟೇ.
ಸ್ಯಾಲರಿ ಎಷ್ಟಿರುತ್ತೆ